Much awaited CA Interlaw exemption oriented mega marathon is here. Just wait a minute. Having resources alone doesn't give you marks. You have to utilize them properly. And in this introduction to marathon, I'm giving you instructions which you have to follow them. Then only you can score maximum marks. You can even score exemption. Trust me. First of all, this marathon is applicable to May 26, September 26, Jan 27 examinations. The total duration of this marathon is 26 hours. If you see my earlier marathons, my main focus is covering all the concepts. But in this marathon, I covered all the concepts. Before each and every chapter, I gave sections chart and I narrated a story to remember these sections also. And also, very recent examinations, very recent past 3 to 4 examinations, how ICA twisted the concepts. Yes, I decoded all the things. And I also gave some tips, how ICA is going to ask questions. See, most of the examinees fail because of surprise element in the examination hall exam paper. So that surprise you are going to bypass after listening to this marathon. Trust me. This marathon of 26 hours is divided into 3 parts. Part 1, Part 2, Companies Act. Part 1, 10.5 hours, weightage 35 marks. Part 2, 6.5 hours, weightage 35 marks. And Part 3, Other Laws and LLP, 5.5 hours, weightage is 48 marks. You can see here Part 1, Prospectus, Incorporation, Deposits, Charges, MGT, Dividends. Part 2, Share Capital, Accounts of Company, Audit and Auditors, Foreign Company, Preliminary. And Part 3, LLP, FEMA, General Clauses Act, Interpretation of Statutes. My suggestion, watch LLP and Foreign Company after completion of all other topics of Companies Act. Because you'll find the majority of the provisions that are there in other chapters of Companies Act. Similar provisions you will find. These two are not a new concepts, they are just byproduct of all other chapters of Companies Act. So watch these two chapters after completion of all other chapters in Companies Act. Clear? And throughout this marathon, I used my master notes. You can download it in Shrestha website, Shrestha for CA and CMA. Just go through the free resources tab. Here, CA Inter, P2, Corporate and Other Laws, DV Subramaniam sir. Just click on it. You'll find my master notes, you'll find my question bank, and you'll find my running notes. Master notes. So this is of just 220 pages. All the important words were highlighted, technical words were highlighted, and after completion of each and every lecture, after completion of each and every chapter, go through my question bank. This question bank is compilation of all MTPs, past 6 attempts MTPs, RTPs, and previous examination papers. So once you finish watching the chapter lectures, if you go through the question bank, you will assess yourself to what extent, you will gain confidence. Automatically you will gain confidence. If you are able to solve many questions, almost all the questions, your confidence levels almost will be good. And for moderate topics, I used my handwritten notes. This is my handwritten notes. You can download this from the same website. Clear? So master notes, question bank, and running notes. And sir, suggested speed for watching these lectures. My suggestion, standard speed is enough. 1 is enough. But if you are someone who are able to grasp concepts very quickly, you can watch them at 1.25 speed. But don't go beyond that. Why? Because at 1.5 or at 2, you will hear, but you can't retain the concepts for long duration. You may listen, but you can't retain them. And one more point, sir, directly I'll jump into one section, sir. I'll skip one section, I'll jump into another section. No, every concept is interlinked. Why? Because you see case scenario, multiple choice questions. So some mixture of 2-3 chapters they are asking, mixing some 2-3 chapters they are asking 3-4 MCQs. And most importantly, LLP FEMA General Clauses Act. LLP FEMA General Clauses Act. Compulsory case scenario questions are coming from this chapter. So don't take risk. Don't take this chapter's choice. Is it clear? So I wish you very, very all the best. Continue watching this marathon. Take care. Let's continue our marathon with the next topic, Limited Liability Partnership Act 2008. From examination point of view, you can expect minimum 12, maximum 16 marks from this chapter. In the recent Jan examination, 2 MCQs came 4 marks and 2 descriptive questions came 10 marks. So 14 marks came from this chapter. So from a chapter, if case scenario questions are coming, then you should not take that chapter choice. Clear? FEMA, LLP, compulsory you will get case scenario questions. And Companies Act, it's up to the question paper setter, because you'll get a combination of chapters. Like he will test prospectus and allotment of securities, share capital and debentures, combinedly one case scenario he will draft, and he will ask some 2 to 3 questions. But FEMA, LLP, individually you will get case scenario questions. Fine. So in this chapter, if you ask me the important topics, filings with ROC, incorporation of LLP, small LLP, next one, compromise arrangements, and one more important topic is that is compounding of offenses. Compounding of offenses. So let's see each and every concept. Limited Liability Partnership Act 2008. This is not at all a new topic. In this topic, you will learn advantages of company and advantages of partnership firm. Just 2 minutes, I'll give a brief introduction about limited liability partnership. See, if you take partnership type of organization, partnership, registration mandatory or optional? Optional. That means compliance burden heavier, zero? Zero. Just partnership deed is enough. And if you see management, who are the owners of the partnership firm? Partners. Who will make day-to-day decisions? Partners. High flexibility in the management. Suppose if you take company type of organization, they want to amend object clause of MOA. For that, directors, can they pass resolution and amend MOA object clause? No. They need to give notice calling for meeting. Immediately, can they conduct meeting? No. They need to wait for 21 days. And after special resolution, can they change objects and can they start new objects? No. File all the documents with ROC. Until you get confirmation from ROC, you can't start new business. So that flexibility is missing in company. And in company, you are having a disadvantage of heavy compliance burden. Any activity happening in company, first communicate with ROC. Heavy, that means high compliance burden. That means partnership is having advantages. And the same advantages are disadvantages to the company. At the same time, partnership also had disadvantages. What are the disadvantages? Unlimited liability. Not only unlimited liability, joint and several liability, because in partnership we had a concept of mutual agency. Every partner is an agent to all other partners. What our contract of agency is telling? Act of an agent, principal is liable. Now act of one partner, all other partners are liable without any limit on liability. So unlimited liability means what? Unlimited liability means in case of continued losses, if business assets are not sufficient to meet business liabilities, then personal assets will be at risk. You need to bring cash from personal assets and you need to settle them. Joint and several liability means I am liable not only for my share of debts, I am also liable for other partners' share of debts if they are not contributing. Getting my point? So these are the biggest disadvantages in partnership. But if you see, same are advantages in company. In company, what is the nature of liability? Generally limited. Is there any joint and several liability? No. I am liable only to the extent of unpaid value multiplied by shares held by me. I'm not responsible for other member shares. Getting my point? So partnership is having its own advantages and disadvantages. Company is also having its own advantages and disadvantages. So lawmaker decided, a person who needs flexibility of the management like partnership firm, and also who wants the limited liability like company type of organization, and who wants less compliance. It's not zero compliance cost, less compliance, compared to company. Compared with companies, less compliance or very, very less compliance. So for those group of associations, lawmaker brought a new concept, that is Limited Liability Partnership Act 2008. Getting my point? The new concept is LLP and it was regulated by LLP Act 2008. Clear? So LLP Act 2008, Ministry of Law and Justice notified the LLP Act on 9th January 2009. Parliament approved it on 12th December and President gave consent on 7th January. 2 days later, it came into force. First, 12th December 2008, it was approved by both the houses of the Parliament. President gave approval on 7th January. 2 days later, it came into force. So if you understand the background of LLP, that means it's a combination of partnership firm and company advantages. Then this concept is over. This act provides for formation and regulation of LLPs along with the related matters. In LLP Act, total we are having 80 sections. Actually 81, but 81 was omitted. So net we are having 80 sections and we are having 4 schedules. In this schedule 1 decides the rights and duties of the partners and LLP. First of all, your LLP deed is applicable for deciding the rights and duties of the partners and LLP. But if your deed is silent, if partnership deed is silent, then first schedule is applicable. Getting my point? Simple example. What is the profit sharing ratio of the partners? Generally, you need to see deed. In deed, profit sharing ratio, it is blank or it was not mentioned. Then as per first schedule, profit sharing ratio will be equal. So matters that are not present or matters that were absent in LLP deed shall be referred to first schedule. Getting my point? It's like first schedule of the Companies Act, where you will see MOA and AOA. 10 tables are there, 5 tables, 5 different companies MOA, and next 5 tables AOA of 5 different companies. Similar point. Next, second schedule, third schedule, fourth schedule. It is all about conversions. If you want to convert partnership firm into LLP, follow second schedule. Private company into LLP, follow third schedule. Unlisted public company into LLP, follow fourth schedule. Okay, that means for all LLPs, which schedule is applicable? Only first schedule. Only for conversion of existing business entity into LLP, you need to follow 2, 3, 4. Sir, what about listed companies? Sir, unlisted company is there. Listed company, first it should be delisted. Then we call it as unlisted public company. Following fourth schedule, it can be converted into LLP. MC and ROC oversee the administration of LLP Act 2008. That means executive department is ROC only. Executive is ROC. See, in interpretation of statutes, I will tell this point, but for the time being, we are having 3 bodies. Legislative body, executive body, judicial body. Legislative body is responsible for framing the laws, amending the laws. Simply Parliament. Executive body is responsible for implementing the laws. Example, MCA, Minister of Corporate Affairs, next ROC. And judiciary, the duty of judiciary is to interpret the law, interpretation of statutes. Interpretation of statutes is done by judiciary. So coming to LLP Act 2008, the executive body is MCA and ROC, executive body. CG has power to frame and amend LLP rules through notifications in the official gazette. Yes, the Indian Partnership Act 1932 does not apply to LLP. So this point is also important only. Suppose if LLP Act is not dealing with a particular matter, any particular matter was not dealt by LLP Act 2008, and Partnership Act is providing solution to that matter, can I apply Partnership Act to that matter, sir? No. No. Indian Partnership Act expressly not applicable to LLPs. Next one, concept of LLP. LLP is a legal business entity with limited liability offering an alternative corporate structure with low compliance cost. Simply advantages of company plus advantages of partnership. Nothing but flexibility of management and low compliance cost. Sir, compliance cost, for example, sir, if you take company, audit mandatory, ROC filings mandatory, audit is of course we need to pay remuneration to the auditor. Filing with ROC definitely need charges, because if you see annual returns, it should be signed by CS of the company. If company is not having CS, practicing CS, again costly matter only. And if you don't file these forms with ROC, heavy penalties. So that's what compliance cost refers to. It allows partners to structure their internal operations like a traditional partnership. It is a separate legal entity. LLP itself is liable for its debts to the full extent of its assets, while partners' liability is limited to their capital contribution. If you see, same point in the company. Company is liable to the full extent of its assets. Members' liability is limited to the extent of unpaid value. Here, contribution amounts. Particularly if you analyze this point, LLP partners nature of liability is similar to members nature of liability in company limited by guarantee. Company limited by guarantee without share capital, if you take, each and every member at the time of incorporation will agree to contribute some amounts at the time of winding up of the company if assets are not sufficient to discharge liabilities. Similar concept. LLP combines features of both company and partnership, making it alternative corporate business form. Since LLP includes elements of both corporate structure and partnership structure, it is known as hybrid between a company and partnership. In examination, I think in foundation examination, I have seen a question like this. LLP is a hybrid between a company and a partnership. Comment. Like that, if they ask, you have to write these 4 points. Getting my point? LLP is a hybrid of company and partnership comment, then you have to write all these 4 points. Next one, definitions. So in the entire LLP Act, if you see address in connection with individual, that means his residential address. For example, service of notices, service of notices. LLP should give notices to the partner's address. Address means which address? Residential address. If address is in connection with body corporate, then registered office address. Two things only. With respect to individual, residential address. With respect to body corporate, registered office. Tell me, who can be the partners of LLP? Who can be the partners of LLP? Individual, also body corporate. Now LLP want to serve notices to these people. So notice to the individual partner, to which address? Individual residential address. Notice to the body corporate partner, to which address? Residential address. That's it. Body corporate. Body corporate definition under LLP Act, under Companies Act is different, different. Under Companies Act, if you see, body corporate includes company incorporated outside India, excludes cooperative society and any other entity notified by the CG. Only simple 3 points, includes, excludes and prescribed entities. But here if you see, body corporate means company. It is inclusive definition, but here it is means and includes. So first of all, body corporate is equal to company as per section 2 clause 20 of Companies Act 2013. That means all Indian companies. Also includes LLP registered in India, LLP incorporated outside India, company incorporated outside India. Yesterday I told you clearly, company incorporated outside India, every company incorporated outside India is not a foreign company. If it is having place of business in India, doing some business activity in India, then it is a foreign company. Clearly here also, LLP incorporated outside India and company incorporated outside India, they will also comes under body corporate definition. Of course, these three as per body corporate under Companies Act also same only. Next, body corporate excludes only cooperative society we have seen in Companies Act. But here one extra point is there, that is corporation sole. Sir, what is a corporation sole? It is a legal entity by a single member or appointed, legal entity having one single member. Example, President of India, Governor of the state. These people will change, presidents will change, but the position never change. Position never changes. Getting my point? If you take government company, if it is a central government owned company, who will hold the shares? President of India. If it is a state government owned company, who will hold the shares? Governor of the state. These people may change, but the position is permanent. Such kind of things we call them as corporation sole. Next one, any other body corporate excluded by central government notification. So here you have to remember, body corporate excludes corporation sole, body corporate excludes cooperative society. Very important. The reason is, who can be the partners of LLP? The answers are individual and body corporate. When body corporate excludes cooperative society and when body corporate excludes corporation sole, these two entities are ineligible to become partners of LLP. Getting my point? Ineligible or disqualified. Remember 3 points, remember three persons: HUF, corporation sole, cooperative society. These three can never become partners of LLP. Karta can become partner of LLP, but HUF cannot become because it is not a person, because it is not a separate person. Next one, simple definition: business. It includes both trade, it includes all trade, profession, service, occupation, but excludes activities specified by the central government. Okay. Chartered accountant means chartered accountant holding certificate of practice. After qualification, you will have 3 opportunities, you will have 3 options. One is industry, that means employment. Other one is profession, and the last one is business. Business, best example, if you see Kumar Aditya Mangalam Birla sir, Rakesh Junjunwala sir. So these people are chartered accountants but having business units. One is chairman of Birla Group of Industries. Profession means holding COP. Going to industry means full-time employee. Now out of these 3, who will be known as chartered accountant under Companies Act as well as LLP Act? Only a person holding COP. That means second category person. A person holding COP will be treated as CA under LLP Act as well as Companies Act. Designated partner, in detail we will discuss in the next topics. Entity generally refers to body corporate, but for these sections 18, 46 to 50, 52, 53, for these sections even a partnership firm under Partnership Act will also be treated as entity. Generally entity means a business body. Generally entity means business body, but when I say it is a body corporate, that means incorporated association will be the entity. But for these sections only, even partnership firm will also be treated as entity. So when you see word entity in these sections, entity is equal to body corporate as well as partnership firm. Financial year, important, very very important. Financial year. Now what we learned in Companies Act regarding financial year is, if company's date of incorporation is on or after 1st January, suppose 1st January 2026, then financial year closure date will be 31st March of 27, I told, right? So the what is the cutoff date? 1st January. On 1st January or after 1st January, financial year closure date will be 31st March of next year. This is only for first financial year. For remaining years, April to March, April to March, April to March. But coming to LLP, cutoff date is 30th September. And it is not on or after, it is after. After. That means from Companies Act point of view, it is on or after 1st October. But we should not change legal terminology. So you have to remember, if LLP's incorporation is after 30th September, suppose 30th September 26, after 30th September 26, then first financial year closure date will be 31st March of 28. 31st March of 28. So simply LLP, just date of incorporation, 1st May 26 Then what is the first financial year closure date? What is the first financial year closure date? 31st March 27. Sir, incorporation date 1st September 26. Then 31st March 2027. General only, general. Next one, if incorporation date is 30th September 26, then also 31st March 27 only. But if incorporation date is 1st October 26, then financial year closure date will be 31st March 2028. So maximum duration of first financial year is 18 months and minimum duration of first financial year is 6 months 1 day. Getting my point? 6 months 1 day is the minimum duration of first financial year, whereas 18 months is the maximum duration of first financial year. Remember, what is the cutoff date in company? 1st January. On or after 1st January. LLP Act 30th September. On or after? After 30th September. Not tested in LLP. I think this point is not tested. So chances are there for may attempt. Foreign LLP. LLP incorporated outside India and having business in India. LLP means partnership formed and registered under LLP Act. That means you tell me unregistered firms can be called as LLPs. No, only registered firms. That too registration should happen under LLP Act. Next one, LLP agreement. This is nothing but deed which decides the rights and duties of the partners and LLP. If you ask me, this is similar to MOA, AOA. This is similar to MOA, AOA. If deed is silent on any matter, then which schedule will apply? First schedule. Name, with relation to individual, in relation to individual, full name. That means middle name, first name, last name, everything, full name. In relation to body corporate, registered name. Small LLP, another important point. Tell me, what is the small company limits for May 26 attempt? May 26 attempt, 4 to 40. September 26 attempt, 10-100. Important, you have to remember, small company is a company other than public company. Clear? Coming to LLP, 2 conditions. Actually, third one is there, but third one is like, other prescribed conditions which will be prescribed in future, okay? Which government is having power, it will prescribe some LLPs, okay, as small LLPs. But right now, 2 limits you have to remember, 25 lakhs to 40 lakhs. 25 lakhs to 40 lakhs. What is 25 lakhs? Contribution. Companies Act terminology, capital, simply. Okay, now contribution 25 lakhs, less than or equal to 25 lakhs. Whereas turnover, less than or equal to 40 lakhs. Sir, then what about these limits, sir? 5 crores to 50 crores. Tomorrow, if government wants to increase these limits, they can increase up to 5. They can increase up to 50 without parliament permission. Without parliament permission. If these amounts want to be amended, parliament permission is required. Okay, na? So government should remember 5 or 50, but we should remember 25 lakhs and 40 lakhs. So we need to check them in which, with respect to which financial year parameters, preceding financial year. Preceding financial year, we need to check these parameters. Can I proceed? Next one, characteristics. Just write characteristics of a body corporate. LLP is a body corporate. That means it's a separate legal entity having perpetual succession, continued existence. Partners may come, partners may go, but partnership, but LLP remains same. That means death of the partners will not decide the fate of the LLP. Perpetual succession, continued existence, separate legal entity. That means LLP can own properties, LLP can incur liabilities in its own name. Act of LLP, LLP is liable, not partners. That means very simple. Separate legal entity importance. Can be sued ma. That means tomorrow if LLP is not paying amount to creditors, creditors can sue partners or LLP LLP. If debtor is not paying amount, who can file case on debtor? Partners or LLP LLP. Mutual agency. In partnership firm, mutual agency is between and among the partners. Among the partners, each and every partner is an agent to all other partners. But here, mutual agency is between partners and LLP. Act of partner, who is liable? LLP is liable, not other partners, not at all other partners. Next one, LLP agreement. So the mutual rights and duties of the partners are governed by LLP agreement. If no agreement exists, Schedule 1 is applicable. Artificial legal person. Yes, separate legal entity, artificial person, same points ma. It is invisible, intangible, immortal, but this is not a fictitious person. This is not a fictitious person. Its existence is decided by a certificate issued by the authority, that is ROC. Common seal, not mandatory. If there, it must be in the custody of LLP officials, affixed in the presence of at least two designated partners. What is the nature of partners liability? Limited. Management of business. Yes, business is managed by designated partners. And number of partners, minimum how many ma? 2. And minimum 2 designated partners should be there. That means sir, 2 plus 2 equal to 4. No, 2 plus 2 equal to 2 only. Every LLP should have minimum 2 partners, and those 2 partners will be designated partners. No sir, I will fix 2 designated partners and 2 other partners sir. Yes, you can have it. In that case 4 partners. In that case 4 partners, it's up to you. And maximum there is no limit ma. Maximum there is no limit. Business for profit only. Important character ma. Important, very very important character. We had section 8 company concept, right? But we had no section 8 LLP concept. We had no section 8 LLP concept. If you remember partnership definition, partnership is an association that carries business with an objective of sharing profits among the partners. Profits, if we are listening the word profits and business means, will it include charity? No. So sometime, one time like this, a question may come. For example, a group of individuals, some 7 individuals approached you to incorporate LLP for carrying charitable activities, and they are not sure about the procedure for incorporation of the company. So you need to advise them. So tell me, possible or not possible? Impossible. LLP can never be a charitable LLP. LLP, the main objective should be business and profit motive only. CG is having power to investigate LLP affairs by appointing a competent authority. Mergers, amalgamation, compromise as usual. Firms, private companies, unlisted public companies can be converted into LLP. So for firms, Schedule 2. Private companies, Schedule 3. Unlisted public company, Schedule 4. And e-filing of documents ma. All the forms which LLP is filing with ROC, they must be filed electronically and signed by designated partner. Digitally signed by designated partners. Foreign LLPs, yes, they were incorporated outside India but having business operations in India. Clear, everyone? See, one important point. For understanding point of view. Partnership firm. Next one, company, LLP. Who will take care of management of each and every entity? Who will take care of management of every entity? If you take company, tell me, management is taken care by board of directors, correct? And owners, if you see members. If you see partnership firm, who are the owners ma? All the partners. In LLP also, who are the owners ma? All the partners. Getting my point? Then sir, partnership firm LLP is taken, management of these 2 entities are taken care by who sir? Active partners. Here we call them as designated partner. See ma, people are same ma, but naming is different. If you ask me here, owners, silent partners. No, it's not silent partners, it's sleeping partners. Try to understand the roles. If you take company, members are nothing but like sleeping partners of partnership firm. They can't participate in day-to-day affairs. Getting my point? Directors are none other than active partners in case of partnership firm. And the active partners of partnership firm are none other than designated partners in case of LLP. Getting my point? People are same only, but names are different. So active partner under LLP is nothing but designated partner. Sleeping partner is none other than member in case of a company. That's it. So in the LLP Act, designated partner means active partner. Normal partner means sleeping partner. What is the difference between active partner and sleeping partner? Active partner participate in day-to-day affairs. So sleeping partner will not participate in day-to-day affairs. That's it, ma. Advantages of LLP. Yes, it will be operated by agreement. Management is highly flexible, easy to form, easy to dissolve. All partners enjoy limited liability. This can be asked for 4 marks. Advantages of LLP can be asked for 4 marks. Easy to form, easy to dissolve. Next one, flexibility in the management, operated by agreement. And all the partners will enjoy limited liability. Partners of LLP, partner of LLP. 2 times this concept was tested. One is directly, who are eligible to become partners of LLP one time. And another time the question was asked like this, narrated a story. And in that story, the crux is LLP wants to appoint HUF as a partner in LLP. Sorry, LLP wants to admit one HUF as partner into the LLP. Possible or not possible? Not possible. Let's see. Here, partner is of 2 categories, individual, artificial person. In artificial person, only 3 people are excluded: cooperative society, corporation, sole, HUF. Coming to the individual, minor can never become a partner of LLP. In partnership, there is a proviso, that means there is an exception. Minor can be admitted for the benefits of partnership, but here minor cannot be admitted. Here minor is disqualified. Next one, unsound mind is also disqualified, unsound mind is also disqualified. Next one, insolvent. 2 types of insolvent, 2 types of insolvent. Already his assets are less than liabilities and he filed an application with the court. That application is yet to be approved. We call him as adjudicated insolvent. Sir, application approved. Official assignee took his assets and selling. Official assignee is selling his assets and settling all the liabilities. Settlement of all liabilities is going on. During that stage, we call him as undischarged insolvent. Insolvent 2 types: adjudicated, undischarged. Both are disqualified. So tell me, natural persons who are disqualified to become a partner of LLP: minor, unsound mind, undischarged insolvent, adjudicated insolvent. Next one, other than individuals, HUF disqualified, corporation, sole disqualified, cooperative society disqualified. So any individual body corporate can become partner in an LLP. Disqualification: unsound mind, undischarged insolvent, adjudicated as an insolvent, and his application is still pending. So directly they won't ask like disqualifications of partner, right? 4 marks. He won't ask. He will narrate a beautiful story. Next one, eligible entities as partners: individuals, residents, NRI, overseas citizens of India and foreign nationals. Yes, everyone is eligible. Limited liability partnership firms. Yes, companies including foreign companies, foreign LLPs, LLP incorporated outside India, foreign companies. So every body corporate is eligible, but cooperative society and corporation sole cannot become a partner. If an LLP receives capital from foreign investors, it must comply with FDI regulations. Clear? HUF, cooperative society, corporation sole. Corporation sole disqualified. Next, minimum number of partners. Minimum number of partners. Tell me, in LLP, minimum how many partners should be there? 2. Suppose post incorporation, after incorporation, if number of partners fall into below 2, that means only 1, then what is the consequence? Just remember section 3A of Companies Act. What section 3 of Companies Act is telling? Lawmaker will give you 6 months time to increase the number. If you don't increase the number within 6 months of reduction of partners, reduction of members, then after 6 months, debts entered into, contracts entered into, debts contracted by the company liable, known members are liable. Same concept here also. If an LLP continues business for more than 6 months, 6 months from which day? 6 months, 6 months from which event? 6 months from date of reduction. 6 months from date of reduction. With only one partner, that sole partner will be personally liable for all obligations incurred by LLP after 6 months. That means up to 6 months, contracts, debts, LLP is responsible. No personal liability. After 6 months, new debts, new contracts, who is liable? LLP? No, already corporate will lift it. Then who is liable? Sole partner is liable. Can I proceed? Designated partner. Tell me, who is designated partner under company? Director. Under partnership firm, who is the designated partner? Active partner. According to LLP Act 2008, all the filing responsibilities of LLP lies with designated partner. Getting my point? See in company sector, annual return, financial statements we have seen. If company fails to file these documents with ROC, officer in default will get punishment. Director in default will get punishment. Here straight away who gets punishment? Designated partner. Whether he is negligent or in default, I don't know. It is his responsibility to comply with the provisions of LLP Act 2008. So any non-compliance of LLP Act, designated partner will straight away gets punishment. That one point remember. And how many designated partners should be there? 2. Remember, designated partner should be always an individual. Designated partner should always be an individual. Suppose, sir, in my LLP, all the partners are body corporates only, sir. All the partners are body corporates. Then who can be appointed or who can be named as designated partners, sir? Very simple. 2 body corporates. At least 2 designated partners, at least 2 body corporates should nominate their nominees. And those nominees take the position of designated partners. Getting my point? See, director, who can be director? Only individual, only individual. No other negotiation. And coming to designated partner also, individual only. Suppose if it is a LLP with all body corporates as partners, then 2 body corporates should appoint nominees. Those nominees will take the position of a designated partner. So every LLP must have at least 2 designated partners who must be individuals with at least 1 resident in India. So 2 designated partners, out of 2, 1 should be resident in India. Here resident in India means period of stay in the current financial year should be at least 120 days. Here it is there, at least 120 days during the financial year. During the financial year. Getting my point? How many designated partners should be there? 2. Out of 2, how many resident partners should be there? 1. Resident means how to determine residential status? Period of stay. How many days? 120. In which year? During the financial year. At least 2 individuals, either partners or nominees of the body corporate, must act as designated partners in case of contravention. In case of contravention. Contravention means what? LLP without 2 designated partners, or LLP without 1 resident designated partner. Getting my point? LLP without designated partners or LLP without 1 resident designated partner, this punishment is applicable. What is the punishment, 10,000 plus 100 per day up to 1 lakh rupees for LLP, and every partner gets punishment 10,000 plus 100 per day up to 50,000. Listen carefully. There is ABC LLP, there is ABC LLP. In ABC LLP, Mr. A, Mr. B are designated partners. Both are designated partners. Suddenly A died. Now how many partners are there? Out of 3, if 1 partner died, 2 partners are there, right? So there is no problem with this section. Minimum number of partners, there is no problem. But if you observe carefully, every LLP must have at least 2 designated partners, but this LLP is having only 1 designated partner. Now both B and C, every partner, not only designated but also other partners, gets punishment. What is the punishment? 10,000 plus 100 per day up to 50,000. Can I proceed? Next one. Maximum in LLP, designated partners only will get punishment. But if there is any problem with appointment of designated partner, or if no appointment is done, then all the partners will get punishment. Tell me, non-compliance of LLP Act, who gets punishment? Designated partner. But if there is no designated partner, then all partners will get punishment. Very rarely you will find this word, every partner, very rarely you will find. Next one, identification of designated partners. Sir, how to identify them? Go through incorporation document. At the time of incorporation of LLP, you have to specify who are the designated partners after incorporation. Those people automatically becomes designated partner. Or state that each of the partner from time to time of LLP be designated partner. Then every partner will become designated partner. Instead of naming designated partners, if you tell all the partners of LLP are designated partners, then automatically the people will become designated partners. A partner may become or cease to be a designated partner as per LLP agreement. So LLP agreement will decide who can become designated partner. Sir, suppose if LLP agreement is silent on this matter, then what to do? Go to schedule 1. Go to first schedule. Next one, filing with ROC. Before naming someone as nominee, before appointing the first directors of the company, before appointing first auditor of the company, what is the requirement? We need to obtain written consent. Yes or no? We need to obtain written consent before naming someone as nominee, debenture trustee. Next one, auditor, director. Same point. Individual must give prior consent before being appointed as designated partner. And LLP shall file particulars of designated partner with ROC within how many days of appointment? 30 days of appointment. A designated partner must meet prescribed conditions to be eligible. And every designated partner must obtain DPIN from the central government. See, prescribed condition is telling, right? The one such prescribed condition is DPIN. What is DPIN? Designated partner identification number. Is it a new number, sir? No, ma. For company, we call it as DIN, Director Identification Number. Under LLP Act, we call it as Designated Partner Identification Number. Same number, no different numbers. If you have DIN, the same number will be used as DPIN for LLPs. Okay, na? So tell me, within how many days of appointment of designated partner, LLP should communicate with ROC? 30 days. First time limit we are getting. So far, we got only statutory limits, 25 lakhs contribution, 40 lakhs turnover. Okay, na? Next, this is the first limit, time limit. Within how many days we have to communicate with ROC regarding appointment of designated partner? 30 days. Non-compliance, LLP 5,000 per day. Sorry, 5,000 standard punishment plus 100 per day up to 50,000. And you tell me here who is getting punishment, Here who is getting punishment? All partners are only DP? Only DP gets punishment, because compliance of LLP Act is the responsibility of designated partners. So if you are not filing with ROC, whose mistake it is? Designated partner's mistake. So only designated partners gets punishment. So designated partner punishment 5,000 plus 100 per day up to 25,000 rupees. Everyone, can I proceed? Next, liability of designated partner. Just now I told you they are responsible for LLP compliance, including filing documents, returns, statements and reports. Simply financial statements, annual returns. In the LLP, you will find 3 types of filings. Event based filings. Let me write here. Event based filings. Event filings. Sir, event filings means, for example, appointment of designated partner. Next one, resignation by the partners. If this event happens, then only you need to file. And 2 other filings are financial statements and annual returns. Financial statements applicable form is form 8, annual returns applicable form is form 11. Only 3 filings. How many filings? 3 filings. One is event based filings, like appointments, resignations, and second one is form 8, that is financial statements, form 11, annual returns. Sir, what about charges, sir? Charges will also be filed in same form 8. Registration of charges will also be done through form 8. Can I proceed? So if they are not taking this responsibility, then they will be liable for penalties imposed on the LLP for non-compliance with the provisions. See, interpretation is different, what is the role of designated partner in LLP? He is responsible for all the acts of LLP, business operations of LLP. Who will be taking care? Designated partner. But as per statute, the role of designated partner is he is responsible to fulfill the rules and regulations of LLP Act 2008. He is responsible for LLP compliance. If not, he will be liable for the penalties. Next one, changes in the designated partner. Just now I told you, above point, if you see, B point, you see, B point. So every appointment of designated partner shall be communicated with ROC within how many days, 30 days. But this is different, this is different. How this is different? Vacancy. Do you remember vacancy of auditor? vacancy of auditor. Within how many days that auditor should be, auditor should be appointed to fill up the casual vacancy? 30 days. 30 days. Even it is a government company by C&AG, 30 days. So even it is a non-government company also, 30 days by board of directors. Same here also. Same here also. Suppose our designated partner retired, resigned, died, disqualified. Now we call it as vacancy. We call it as vacancy. So within how many days of vacancy we should fill up that position? 30 days. Within 30 days of vacancy, fill up the position. And once you appoint him, next 30 days, file with ROC. Listen carefully. This is vacancy date ma. D0, casual vacancy. Casual vacancy. Now appointment should be done by D30. This is about appointment. Appointment of designated partner. That procedure you have to see LLP deed ma. If LLP deed is silent, then first schedule. Then first schedule. So here what should be happen? Appointment should be happen. Appointment alone is sufficient, sir. No. The same shall be communicated with ROC. So this is 30 and this is 30. That means by day 60. By day 60. For understanding, I am telling you. Suppose if appointment happened on 10th day itself, then communication with ROC should be done by day 40. Day 40. So day 60, communication with ROC. Communication with ROC. Can I proceed? See, here you will find word registrar. Registrar, ROC, same person only. If no DP is appointed or only one DP present, then every partner will be deemed to be designated partner. Accordingly, if you see here, every partner gets punishment. If you go above, if you go to the previous page, every partner will get the punishment. If there is no DP or only one DP, then every other partner will be deemed to be designated partner. Same punishment. If you see, this is like, if you read study material, you will find a punishment clause like this. You will find punishment clause like this. But summarized form of punishment you can see in previous page. You can see in previous page. So here itself, if you want, you can write it ma. Here itself, if you want, you can write it. 10K plus 100 per day up to 1 lakh. This punishment is for LLP. And every partner, not only designated partner, every partner, the punishment is same punishment, but maximum punishment is different. 10K plus 100 per day up to 50,000. Same punishment. And if you read a study material, a punishment clause, they will tell if non-compliance of clause C, one punishment. Non-compliance of clause D, one punishment. No clear indication. Now you need to go through those clauses. But here, individually, we have given the punishment clauses. Next, procedure for incorporation of LLP. Procedure for incorporation of LLP. If you remember, yes. If you remember companies incorporation, MOA, AOA. Next, compliance by declaration of compliance by the professional and first director. Next one, declaration by the subscribers and directors, address for temporary correspondence, details of the directors, details of the subscribers, written consent of the directors, interest of the directors in other body corporates. You'll find some 8 documents. Here you'll find only one document, that is incorporation document. Attachments very simple ma. Attachments you will see here only. I'll repeat. I'll discuss with you. At least 2 persons must subscribe to the incorporation document for a lawful business with profit motive. Once again, I am telling you, there is no concept of Section 8 company in LLP. There is no concept of Section 8 company in LLP. Next, the document must be filed electronically with the registrar of the state where LLP register office will be located. Chennai means ROC Chennai. Coimbatore means ROC Coimbatore. Filing requires a statement in prescribed form made by advocate CS, CA, CMA involved in forming the LLP. That means this is a declaration of compliance, DOC. Declaration of compliance should be signed by one practicing professional and one subscriber, nothing but one partner to the incorporation document confirming compliance with LLP requirements. Complying with LLP requirements means we are 2 in number and we are eligible to incorporate LLP. We are majors, not unsound, not insolvent. Getting my point? Next, contents of the incorporation document must include format is actually Philip form for incorporating limited liability partnership. The full form is Form for Incorporating Limited Liability Partnership. LLP name. Again, name of LLP should also be unique. That means it should not be identical or similar to the name of existing body corporate. It should not be undesirable in the opinion of central government. That care you need to exercise. Proposed business, nothing but object clause. You will find MOA only here also. This is name clause, object clause, registered office address, for the time being situation clause. Situation clause. There is a difference. Situation clause will contain name of the state, but here you will find a complete address. Initial partners, nothing but subscription clause or association clause. Details of the designated partners, nothing but who the directors of the company and any other prescribed information. Capital clause is not there because here they will fix the contribution amounts. Getting my point? Name is there, object is there. Liability, always limited. Name itself is selling limited liability partnership. But companies, there are types, limited by guarantee, limited by shares, unlimited. That's why liability clause is there. Next one, penalty for false declaration. Penalty for false declaration. Again, Companies Act. Try to recollect Companies Act. If you furnish false information at the time of incorporation of company, what is the punishment? 447. But here different punishment. What is the different punishment? Imprisonment up to 2 years and fine between 10,000 and 5 lakhs. See, if there is no armis, it indicates end. Both imprisonment and fine. Imprisonment up to how many years? 2 years. Fine, minimum 50,000, minimum 10,000, maximum 5 lakhs. Who will get this punishment? A person knowingly makes a false statement. Can I proceed? Incorporation by registration. Once all requirements are met, registrar will register the incorporation document and issue a certificate within how many days of filing the application? 14 days. See, this 14 days is a duty on the LLP or ROC? ROC. Once ROC receives the information, he will issue certificate of incorporation of LLP. Within how many days? 14 days of filing this application with ROC. 14 days. Second time limit, remember. First time limit is 30 days of appointment of designated partner, communicate with ROC. Another time limit, in the case of designated partner vacancy, within 30 days appoint a new designated partner. And third limit, within 14 days of filing application with ROC, ROC should give certificate of incorporation. Over. Next. And of course, this certificate is signed by ROC, authenticated with an official stamp. And this will be the sufficient evidence of compliance. Certificate is conclusive proof of LLP incorporation. Registered office of LLP and changes. This is similar to section 12 of Companies Act. Section 12 of Companies Act. Again. See, LLP means, I told you, this is just a byproduct of company and partnership. Company and partnership. So if you are able to recollect those points, you can easily remember these points. Registered office changes, if you remember, within the same city. Change in city, no change in ROC. Change in ROC, no change in state. Change in state. But here, that much lengthy procedure is not there. Here, simple word prescribed is there. If you observe carefully, the word prescribed will be there. Yeah, the word prescribed will be there. Every LLP shall have a registered office for receiving the communication and notifications. First day of the marathon session, I told you, CIJ. Importance of registered office is communication, investigation, jurisdiction. All the official letters are addressed to, all the notices of LLP are addressed to LLP registered office. All investigations are subject to LLP registered office only. Jurisdiction, LLP registered office. A document may be served via post under a certificate of posting, registered post, or any other prescribed method. Okay, this prescribed is different, leave it off. Any other prescribed method at registered office or an alternative declared address. This one, LLP can change its registered office by filing a notice with ROC as per prescribed rules. But in Companies Act, that prescribed matter also we read. Filing with RD. RD will give confirmation within 30 days. Same shall be communicated with ROC within 60 days. ROC will give certificate within 30 days and you have to file INC 22 with new ROC in 30 days. Like that, detailed procedure we had. But here, prescribed rules. If LLP fails to comply, it faces 500 per day penalty, maximum 50,000 penalty for LLP and its partners. Next one, effect of registration. Simply remember characteristics of company, effect of incorporation of company. Same point, can file lawful suits, that means can sue, can be sued. can acquire properties in its own name, can incur liabilities in its own name, may have common seal, can perform all lawful acts. This is similar to section 9 in case of company. Next, selection of name of LLP. Same to same. For company, what measures we took, for LLP also same measures. Simply, the name should be unique. That means what? Name should not be identical. Name should not be similar to another LLP, company or registered trademark. In the place of these two, I can call it as body corporate. Name shall not be identical or similar to the existing body corporate, also registered trademark, and it should not be undesirable in the opinion of central government. Reservation of name. Reservation of name. For company, we had two forms. For company, we had two forms. Ma, is it okay, or are you getting confused? You know, sometimes I'm telling company and sometimes I'm telling LLP. Okay, na? It's just recollecting of Companies Act provisions. One more revision, that's it. In case of company, if you remember, for proposed company incorporation, we file form in a SPICE. We file form, that is SPICE, simplified procedure for incorporating company electronically. Whereas for existing company to change the name, we use form RUN, reserve unique name. And here a person may apply to register in a prescribed form with a fee to reserve a name for a new LLP or name change of an existing LLP. Interestingly, here also we use run mechanism only. Reserve unique name only. If the registrar is satisfied that name does not violate section 15, sir, does not violate section 15 means what? Neither similar nor identical. And next one, not undesirable. Not undesirable. If these conditions are satisfied, then that name will be reserved for how many months, ma? 3 months from the date of intimation. And interestingly, if you remember company, it is 20 days, 60 days. For proposed companies incorporation, name will be reserved for 20. Existing company planning to change its name will be reserved for 60. But name of LLP will be reserved for 3 months. That is both for proposed LLPs as well as existing LLP which is planning to change its name. Okay, na? 3 months. Reservation of name, 3 months. So far the limits we have seen 30, 30, next one 14, and next one 3 months. 14 is for ROC. 14 is for ROC, issuing certificate of incorporation. 3 months is for reservation of the company, reservation of LLP name. Reservation of LLP name. Next, rectification of name. Similar to section 16. Similar to section 16. So here what happened, you know, existing LLP or company or owner of registered trademark. Owner of registered trademark. For owner of registered trademark, you know, the time period is 3 years. If your name is if you have used the name which is identical to or similar to the name of existing LLP or existing registered trademark, then the owner of registered trademark will file an application with central government within how many years? Within 3 years. Central government will react only when application is filed within 3 years. Suppose if this fellow is filing application with central government after 5 years, do you think central government is having obligation to react? No. Then central government will order LLP to change its name, and this order period is 3 months. That means within 3 months of central government order, LLP should change its name. Sir, if LLP is silent, then central government will give new name. Sir, LLP is not liking that name, sir. LLP, you change the name according to the provisions of LLP Act. Getting my point? That means same to same section 16, ma. So if LLP is inadvertently registered with a name which is identical to or similar to the another LLP or company or too similar to the registered trademark, then on application from the affected LLP, company, trademark owner, the CG may direct LLP to change its name within 3 months. So here, you know, CG will react only when there is an application by the existing body corporate or the owner of registered trademark. But for the owner of registered trademark, there is a time limit. What is the time limit? 3 years is the time limit. 3 years from when? 3 years from the incorporation of LLP or 3 years from the date of change of name of LLP. Once LLP changes its name, it shall notify the registrar within 15 days. Registrar updates the incorporation certificate. LLP shall update LLP agreement within 30 days. This is nothing but alteration of MOA for company. Alteration of MOA for company. Okay, na? If the LLP does not comply with CG, then CG will assign a new name and registrar will issue fresh certificate of incorporation. However, LLP can change the name voluntarily later despite a government mandated change. So now in the rectification of name, total how many time limits are there? Here itself you can write in this box, you can write First, 3 years time limit. This is a duty of RTO. RTO means registered trademark owner. Registered trademark owner, 3 years. Next one, 3 months. 3 months. This is the timeline that LLP is having to comply with the CG order. Next, 15 days. This is the timeline for filing with ROC. Whenever you change the name, file it with ROC within 15 days. And next one, 30 days. Fourth time limit is 30 days. Sir, what is this 30 days, sir? Change of LLP deed. Change of LLP deed. LLP deed shall also be amended within how many days? 30 days. 30 days of receiving fresh certificate of incorporation. Okay, na? How many limits? 4. 3 years, 3 months, 15 days, 30 days. 3 years is the duty of owner of registered trademark. 3 months is the duty of LLP to make changes. 15 days is the duty of LLP to file with ROC regarding changes of the name. And 30 days is the duty of the LLP to change its LLP agreement. Can I proceed? Next one, relationship of partners with LLP. Nothing but agency. Partner is an agent to LLP. Remember one point. Remember only one point. Every partner is an agent to LLP only. Partner is not an agent to other partners. That means act of one partner, other partners liable or not liable? Not liable. Who is liable? LLP. LLP only liable. But that fellow should act as per the deed only. As per the deed. Suppose ultra virus acts, you remember? Ultra virus, beyond the powers of MOA. In case of ultra virus, is company liable to outsiders? Directors default. Directors in default liable to the outsiders? Directors in default. Here also, partner acting within the capacity, partner acting within the authority, LLP is liable. If partner acts beyond the authority, who is liable to the outsiders? Partner alone is liable. LLP is not liable. That point you have to remember. At the time of incorporation, persons who subscribe to the incorporation document becomes partners. Any other person may become a partner as per the LLP agreement. If LLP agreement is silent, generally, with the consent of all partners, admission will take place. Relationship of the partners. Mutual rights and duties of the partners are governed by deed. If deed is silent, then first schedule. The LLP agreement and any modification shall be filed with ROC in the prescribed form, manner and phase. A written agreement made before incorporation between subscribers can impose obligations on the LLP provided it is ratified by all the partners after incorporation. If you remember, MOA is also prepared before. MOA is also prepared before incorporation. But MOA gets significance post incorporation. Here also, agreement, if ratified by the partners after incorporation, then that agreement gets validity. Accordingly, partners are liable to LLP, LLP is liable to partners. This is like section 10 binding effects of MOA OA. Company is liable to the members. Members are liable to the company. Here also, partners are liable to the LLP. LLP is responsible to the partners. In the absence of agreement as to any other matter, the mutual rights and duties of the partners and mutual rights and duties of the LLP and the partners shall be determined by the first schedule. Beginning only I told, rights and duties, mutual rights and duties are decided by LLP agreement. If LLP agreement is silent, first schedule. Next, changes. Here, changes as to the partners. Changes of partners. Second one is partner details. Partner details. Partner details means name change, for example, address change of the partner. Name change of the partner, address change of the partner. For example, K Pooja, my friend name is K Pooja. After marriage, her surname will change definitely. Nothing but change of partner details. Suppose my friend is a partner in LLP. He became a partner when her surname is K. Now surname changed. Is it a change or not a change? Change. After marriage, she went to father-in-law house, mother-in-law house. Address change, no change, address change. Now that partner should communicate with LLP about the changes within 15 days. Within 15 days. And LLP should communicate the same with ROC within 30 days. Within 30 days. Getting my point? Changes in partner details. 50 days or 30 days. Changes in partners means generally change in partners arises only by way of retirement, resignation. death, insolvent, disqualified. These three are decided by law, operation of law, no problem at all. But resignation case, there are some duties on the former partner. See, outgoing partner, we call him as former partner. We are hearing, right? Former captain of India, Rohit Sharma, Virat Kohli sir, Rohit Sharma sir, Virat Kohli sir, MS Dhoni sir. Former, that means present, are they captains, or earlier they are captains, earlier. So this outgoing partner is known as former partner. Former partner. Farmer partner has to communicate his intention of resigning from the LLP with other partners. First he should make communication 30 days before resignation. 30 days before resignation, he has to communicate his intention of resignation. And immediately, LLP should file the form with a ROC. Within 30 days of resignation, LLP should file a form with a ROC. Getting my point? Sir, or else what happened, former partner is, for namesake, former partner. But in the eyes of law, from public point of view, he is not a former partner. He is a present partner. That means, is he liable for firm debts? Yes. Sir, you told limited liability. No, sir. Yes, limited liability only. But to the extent of contribution, he agreed. Getting my point? Suppose, today I decided to resign from the LLP. If I give resignation notice and if the same has been filed with ROC, debts incurred by the LLP till today, I am responsible. Subsequent to today, I am not responsible. Suppose I communicated my intention, but no one has filed with ROC. Then whether my resignation is valid, legal or illegal, valid or invalid. That means in the eyes of law, from public point of view, I'll be still treated as continuing partner. I'm even liable for not only past debts but also present debts. Getting my point? This is not a new point, you all know. In partnership firm also, active partner at the time of resignation, he must give public notice, right? Active partner should give public notice. Here also public notice only. But we are not giving notice to the public. Notice given to ROC is deemed to be notice given to the public. Same point I discussed with you in charges chapter. Doctrine of constructive notice. Any piece of paper you are filing with ROC, it becomes public notice only. So active partner will give public notice in case of partnership firm, and partner of LLP should give notice to the LLP. LLP should give notice to the ROC. Then only his liability comes to an end. These situations will not come in case of death of the partner, insolvent of the partner, because operation of law already terminated their liability from the date of death and date of insolvency. Let's see, a partner can leave the LLP either as per the LLP agreement or by giving written notice at least 30 days to other partners. Sir, at least 30 days means what? 30 days before. 30 days before the day of resignation. Suppose if you decided to resign with effect from 31st March 2026, 30 days before only you give communication. Why? LLP has to make arrangements, right? The moment if you are leaving the LLP, your share of contribution, your share of profits in the LLP must be paid. Getting my point? So that those arrangements should be taken care. So the time period 30 days is as per LLP Act. Suppose in LLP agreement, if you want to change the time period, you can change it. That's why they are telling he may leave as per LLP agreement, or by giving a written notice at least 30 days to the other partners as per LLP Act. First we are giving priority to the agreement. Agreement is silent, act. A partner automatically ceases on death to LLP dissolution, being declared as unsound mind, applied, or being declared as insolvent. So in these cases, notice required, not required, because one case party is not there, another case party is there but insolvent, not capable to the contract. Continuing liability, important. Former partner means whom? Outgoing partner. Former partner is still regarded as a partner in dealings with the third parties unless exception is there. Unless exception. What is that exception? The person, the person. Here the person means third party. Third party has noticed that former partner has ceased to be a partner of the LLP. Sir, how third party gets notice? If you file a notice with ROC, it becomes public notice. or notice that former partner has ceased to be a partner of LLP has been delivered to the ROC. Because of B, A will happen. Sometimes, if you are telling to all the known creditors, see, sir, I am resigning from this firm, sir. So tomorrow onwards, if you want to give credit, but don't look at me, because today itself I am resigning. Tomorrow onwards, if you want to give credit to the LLP, you give it. It's up to you. It's your risk. Now the person dealing with LLP is having a knowledge that this fellow is not a partner. Now can he make this fellow liable? No. Getting my point? 2 points. Either communication should be done to ROC or communication should be done to the public, or else former partner will be assumed as active partner only. Active partner means continuing partner. He will get liability. Obligations after exit. Cessation does not discharge the partner from any previous obligation into the LLP. Other partners are third parties. Very simple, ma. Suppose this is Y0, year of incorporation of LLP. A, B, C brought 10 lakhs capital. Each brought 10 lakhs. And cash and bank balance also 10 lakhs. This is year 0 balance sheet. Year 3, A decided to come out of the firm. That time, A 10 lakhs, B 10 lakhs, C 10 lakhs. Cash and bank balance, for example, 21 lakhs. Profit and loss debit balance 9 lakhs. 30. So when A decided to come out of the firm, what is his share in the LLP? Is it only 10 lakhs, or he is also required to bear the losses, carry forward losses? He should also bear carry forward losses. He assumed all the partners are all the partners are equal partners. Now 9 lakhs divided by 3, each partner is liable for 3 lakhs. So A will get how much share? 10 minus 3, 7. Now you tell me, till the date of resignation, whatever losses are there, former partner should bear it or not? Yes. That is the point here only. You can see. Does not discharge previous obligations. Exactly. A former partner is entitled to refund of capital contribution made to the LLP, share of accumulated profits after deducting losses up to the exit date, and no management rights. A former partner has no right to interfere in the LLP's management. So remember, former partner, he is having 2 rights and 2 disabilities. It's like 2 disabilities. 2 benefits, 2 disabilities. 2 benefits, not liable for future acts. And he's entitled to get his share of contribution along with accumulated profits or accumulated losses. He will bear it. These are the benefits. And disabilities, he can't participate in management activities. That's it. So advantages, no further liability. Correct only, no further liability. And he's entitled to the share of capital and share of accumulated profits. But the only disability is he cannot participate in management after resignation. Registration of changes in the partners. A partner shall inform LLP any change in name or address of the partner within 15 days. Now you tell me, here name is which name? Individual full name, body corporate registered name. Address means which address? Individual partner residential address. Body corporate address means registered office. The definition we have covered first point. The LLP shall file a notice with registrar within 30 days if partner joins or exists or change in name or address of the partner. And the notice shall be in prescribed form with required fees, be signed by a designated partner, authenticated as per the rules. For new partners, include a signed consent statement. This is common point, before naming someone as a partner. Written consent, prior written consent is mandatory. And next one, penalty for non-compliance. LLP and designated partner 10,000 penalty for failure to file notice. See, these are 2 punishments. Here 2 punishments are there. One punishment for 2 defaults. What are the 2 defaults? Retirement to admission not communicated with ROC. Retirements, appointments, admissions. Admission or retirements not communicated. Other one is changes in partner details. Okay, na? And if you see here, individual partner 10,000 penalty for failure. Sir, this individual penalty for which partner, sir? First point if you see. Change in address, change in name shall be communicated with LLP within how many days? 15 days. Try to remember this chart. Try to remember this chart. Within 15 days, partner should communicate with LLP. LLP should communicate with ROC. If partner is making mistake, that individual partner gets 10,000 penalty. If LLP is making mistake, then LLP and designated partner gets punishment of 10,000 rupees. Getting my point, everyone? If partner believes that LLP will not file the exit notice, then that former partner, here they means former partner, may file it themselves. Then the registrar will seek confirmation from the LLP. If no response within 15 days, registrar shall register the notice. So what is the meaning of this point? Former partner gave notice to the partners, I'm going to quit from the LLP. Other partner said okay, but LLP not yet communicated with ROC. Former partner got a doubt and he filed a form with ROC. Sir, from so and so date I already resigned, sir. They didn't file, I am filing the form. Now immediately ROC will not register the form. ROC will give one opportunity of being heard to the LLP. Is it true? Is it true? And ROC will wait for 15 days. How many days? 15 days. If there is no permission, if there is no objection, then ROC registers resignation of the partner. Getting my point? So in this concept, total time limits, if you remember, 30, 15, 15. Only 4 limits. 30, 30, 15, 15. See, this 15 partner to LLP. This 30 former partner to partners with respect to resignation. This 30 LLP to ROC. Sir, what is the last 15, sir? When former partner is approaching ROC, ROC will give a letter to LLP and ROC wait for 15 days. If there is no objection within 15 days, ROC register the document. Sir, why former partner will go to ROC? Array, if the document is not filed with ROC, if public is not aware about his resignation, then that fellow will be liable for future acts. To protect his interest, he will go. Can I proceed? Extent and limitation of liability of the partners in LLP. Always limited liability. But there is an exception. Sir, what is that exception? If partner is responsible for fraud, if partner is negligent, then he will get unlimited liability. Getting my point? Yesterday, audit and auditors, body corporate is disqualified. Why? All the members have limited liability. There is no exception. Of course, corporate will lifting one point is there, but that is not one day activity. It takes a lot of time. Coming to LLP Act, straight away point is there. Straight away a provision. What it tells, partner responsible for fraud gets unlimited liability. For that, lifting of corporate will is not at all required. So that precaution was taken in LLP. That's why LLP is not disqualified and all other body corporates are disqualified to act as auditors of the company. Clear? Okay. So every partner is an agent of LLP for LLP business activities, but not an agent of other partners. We all know. If a partner acts without authority, that means with power or without power? Without power. Then LLP is not bound if partner has no authority to act for the LLP and third party knew that partner had no authority and was unaware or was unaware they were a partner. But remember carefully. We are having one partner, Satish. He is not cashier. He is not cashier. He is just a sleeping partner. For example, not designated partner, not cashier, normal partner. If that fellow is going to the debtor and collecting the amount, is it within the authority or without authority? Without authority. Without authority. Now is LLP liable or not liable? Not liable because he is not having authority. And the other case, if you see, third party knew that partner had no authority. The debtor paying amount, he knows that Satish is not having authority, but still he is paying amount to Satish. Satish misappropriated the amount. LLP is not liable. Satish is personally liable to debtor. Or third party was unaware that they were a partner. If third party doesn't know Satish is a partner of LLP, then concept of mutual agency will come. Act of Satish LLP is liable. That concept will come. What third party will think? individual partner is personally liable. If individual partner is personally having, if individual partner is having personal liability, then LLP will not have any liability. Speed okay na? Okay, fine. LLP is liable if a partner's wrongful act or omission occurs during business operations or within LLP authority. Oh my god. See, this B point is like an exception to A point. What A point is telling? Partner acting outside authority. Partner is personally liable, LLP is protected. And what B point is telling? Partner act, LLP is liable when if partner is acting within the authority. For example, Mr. Arun is our cashier. He is a partner come cashier. Arun is having a bad habit of betting. IPL season started. Arun went to debtor, collected some 3 lakhs amount. Meanwhile, he kept that money in one betting. He lost that money. That is also wrongful act only. Wrongful act only. Betting is wrongful act. But collection of amount, is it within authority or not within authority? It is within the authority. Now, is LLP liable or not liable? Responsible. LLP is responsible to the debtor. That means second time debtor is not debtor is not liable for the second time. Debtor paying amount to Arun, who is having authority to collect amount. Debtor is discharged. LLP is responsible. That is B point. Partner's wrongful act or omission occurs during business operations, whereas Satish activity is outside authority. So A point is Satish, B point is Arun. LLP obligations are solely the responsibility of LLP. Liabilities of LLP shall be met out of property of LLP. Separate legal entity concept is that only. Next one, extent of liability of the partner. A partner is not personally liable for LLP obligations just because he is a partner. He is personally liable for the own wrongful act but not for the acts of other partner. Sir, he is liable for own wrongful act means what? Ma 3 persons ma. LLP, debtor, Arun. Who is Arun? Cashier. Who is Arun? Cashier. Debtor paid amount to Arun. That means debtor discharged or not discharged? Discharged. Now, whose responsibility to transfer that money to LLP account? Arun's responsibility. Arun lost that money in betting agreement. Now, who should compensate LLP? Arun. So, Arun is personally liable for own wrongful acts but not for the acts of other partners. Getting my point? Suppose Satish did mistake. Who is responsible to LLP? Satish only, but not Arun. Act of one partner, LLP is responsible. That too, if it is within the authority only. Sir, debtor knew that Satish is not having authority, but still debtor paid amount to Satish. Is LLP responsible to debtor? No. Everyone? Next one, ma. Holding out. Partner by estoppel, partner by holding out. Do you remember? That means, is he an actual partner? Is he an actual partner? Or namesake, lending his name to the third party, lending. That means, in the presence of, partners, this outsider will represent himself as partner of LLP. False representation, ma. This is not true representation, false representation. And the representation is either spoken, written, or by conduct. And the third party believed and gave credit to LLP. In that case, if LLP receives credit due to false representation, LLP is liable for the amount received. Separate legal entity concept, right? But if LLP don't pay that amount, partner by holding out will pay that amount. If an LLP continues using a deceased partner's name, their legal representative is not liable for LLP acts after the death. Very simple, ma. ABC LLP is there. C died, but they didn't change it the name. They continuing the name of LLP as ABC LLP only. Now, whether C's legal estate or C's legal representative responsible for the acts of partner A and partner B? No. There is no personal liability. There is no joint and several liability. So, even if firm uses deceased partner's name, estate of the deceased partner, representatives of deceased partner are not liable. In case of resignation, notice should be filed with ROC or else liability will continue. Unlimited liability in case of fraud. Already I told you. Partner responsible for the fraud. If a partner acts to defraud creditors or for fraudulent purposes, liability becomes unlimited. LLP is liable for a fraudulent act of a partner unless it proves the act was without LLP's knowledge or authority. Same point getting repeated, ma. This point is talking about whose activity? Satish. Who is Satish? Partner without authority. No authority. Partner without authority, LLP is not liable. LLP is liable only for the acts of the partner who is having authority. In that case, if there is any loss to the LLP, who should compensate LLP? All the partners are partner who is negligent, partner who is fraudulent, partner who is negligent or fraudulent, not all partners. If an LLP knowingly carries out fraudulent business, those involved face imprisonment up to 5 years and fine 50,000 to 5 lakhs. LLP partners, designated partner, employees involved in the fraud must compensate for the losses suffered by affected person. However, LLP is not liable if the fraud was without its knowledge. No time limits, ma. No time limits in this concept. Here you have to know this one page content. They won't ask you write extent and limitation of liability of partners in LLP. They will narrate a story. In this one page content, you have to understand only 2 points. The 2 points are partner acting fraudulently within his authority. LLP is liable to the outsiders and this partner is liable to the LLP. Partner doing fraudulent activities outside the authority. LLP is not liable to the outsiders. That individual partner is liable to the outsiders. Suppose if outsiders don't have knowledge about his partner status, and if outsider deals with that individual partner without knowing partner status, then individual partner is personally liable to outsider but not LLP. That 3 points, if you remember, that's it. And 4th point, partner carrying fraudulent activities, normal point. That partner's liability becomes unlimited. All other partners' liability is limited. Next one, whistleblowing. Whistleblowing. What is meant by whistleblowing? Whistleblowing means it's like alarm. It's like alarm. In case of wrongful things. In case of for example, in factory, when we ring the alarm, suppose if there is any fire accident in the factory, we create some fire alarm. Now coming to the companies and coming to the LLPs, top level management or any manager is getting involved into some fraudulent activities or activities opposite to public policy or activities against to the company. Now you being an assistant manager or inferior, you are inferior to the boss, you are subordinate, and your boss is involved in some fraudulent activities. Now you had a benefit of this concept, whistleblowing. So you should create one alarm sensation. In this whistleblowing, important point is second one, ma. Important point, second one. Already one time the second point was tested. Okay, na? September attempt. Okay. See, court or tribunal may reduce, waive any penalty for the partner or employee of an LLP if they have provided useful information during an investigation of the LLP. Suppose ma, A, B, C LLP, C is involved in the fraud, ma, and B is having knowledge of the fraud. B is not a party to the fraud, but B is having knowledge. What C did, B know. Both B and C are designated partners. They should get punishment. They should get punishment. But if B becomes approver, in many cinema, in many movies, you will see the point. A big gangster surrender to the police, same like that only. Sir, I'll become an approver like that. I will provide you the useful information for investigation. In return, what benefit I'll get? Less punishment you will get. You'll get less punishment. And next one, protection. No partner or employee of LLP shall face discharge, demotion, suspension, threats, harassment, any other form of discrimination in their employment terms for providing or facilitating this information. Like when B is responding to when B is cooperative with the investigation authority, C should not send harassment messages like, if you give information to investigation authority, I'll kill you, I'll terminate the partnership, whatever amounts LLP is liable to you, I will not pay you single rupee also. Like that, mental harassment, simply coercion, nothing but coercion. If there is any kind of coercion, that fellow, the person who is cooperative with the investigation authority will be protected from that coercion related activities. That is the only point. Examination, I think suspension or demotion, one point was on that point, story was narrated. Can I proceed? Partners contribution, simple one entry, simple one entry. ABC 3 partners, ABC 3 partners, they started business ABC LLP. A agreed to contribute 20 lakh rupees as a capital, A agreed to contribute 20 lakhs rupees capital. B agreed to contribute 20 lakhs worth to plant and machinery. 20 lakhs worth to plant and machinery. And C is a MBA graduate, for example. you know how to manage business operations. If C go and join a company, any industry, his salary package would be 20 lakhs. His salary package would be 20 lakhs. Now C agreed to work at free of cost and asking AB, whatever service I'm rendering, treat it as my capital contribution. Getting my point? See, if I join if I join in any company in the industry, I'll get how much? 20 lakhs. Now here I will not invest a single rupee. Whatever I can do for LLP, I'll do it and treat that it as a capital contribution, and it becomes capital. That means what? Capital means it need not be in cash only. It can be either in cash or in kind. Need not be in tangible property only. Can be tangible, can be intangible. So simply the entry would be like this, ma. The entry would be cash account debit, plant and machinery account debit, and after 1 year, salary and wages account debit 20 20 20. So to partner A, to partner B, to partner C, 20 20 20. That means what will come under the contribution is the monetary value of something brought by the partners. We call it as capital contribution. Getting my point? Monetary value. That's what, whatever services C is rendering to LLP, if you convert them into monetary form, we call it as contribution only. Sir, monetary valuation not possible, sir. Then it is not a contribution. Why? Because in books of accounts we need figures. Getting my point? See, in schedule 3 you will show the turnover of the company and assets of the company, but you won't show human resources. Biggest asset of the company is human resources, ma. You tell me Infosys is with some 20,000 employees, for example. If these 20,000 employees are absent on one day, can company continue its operations? That means the biggest asset of the Infosys is buildings, human resources, but this will not be disclosed in the balance sheet. That is a limitation factor of the balance sheet of the company. Limitation factor. We can't show all our assets, that is non-financial assets, we can't show in a balance sheet. So same here also, the same point. Monetary value of each partner's contribution shall be accounted for and disclosed in the LLP accounts as per the prescribed rules. And if you see the contribution include tangible, movable, immovable, intangible property or any other benefit to the LLP. This includes money, promissory notes, agreements to contribute cash or property, and contracts for the services. Contract for the services. That's what A's contribution. C's contribution. MBA graduate who can earn 20 lakhs salary outside. Obligation to contribute. A partner's obligation to contribute money, property or benefits to perform services for LLP shall be as per LLP agreement. Creditor of LLP may enforce original obligation against the partner if he extends credit or relies on partner's obligation in the LLP agreement. Another tricky point, ma, can be tested. So just read that highlighted point. Just look at the highlighted point. Creditor of LLP may enforce the original obligation against the partner if extends credit or relies in a partner's obligation in the LLP agreement. So the meaning of this point is, in LLP agreement, suppose in deed, in LLP deed, partners agreed like this: A, B, C. A will contribute 20 lakhs, B will contribute 20 lakhs, C will contribute 20 lakhs. So far A contributed 16 lakhs, B also 16 lakhs only, C also 16 lakhs only. So balance, how much they are liable to contribute? Each 4 4 4 4. That means total how much? 12 lakhs. Looking at this deed, one creditor gave a loan of 10 lakhs to LLP. How much loan he gave? 10 lakhs. After receiving this loan, if you look at LLP balance sheet, capital so far, you know how much they contributed? 16, 48 lakhs. Loan, only this one loan, imagine only this one loan, 10 lakhs. Assets 0, everything lost. Total profit and loss debit balance only, how much it is? 58 lakhs. This is the situation, ma. This is the situation. Now do you think this creditor is at risk? No, he is not at risk. Why? Sir, assets 0, no sir. From where he get funds? No problem, your partner is still liable to contribute amount, right? How much each partner is liable to contribute extra? 4 lakhs. Correct? So 3 partners bringing 4 lakhs means 12 lakhs. What is his debt? 10 lakhs only. So safe or risk? Safe. So like that creditor thought. After receiving this loan, what ABC did, you know, They amended the deed in such a way that their liability is zero. Their liability is zero. Now you tell me, outsider, at risk or safe? Risk. Now, will this amendment affects liability or not is the point, and that is the solution. Will this amendment affects liability? No. Creditor enforce original obligations. Sir, before amendment, what is your original liability? 4 lakhs each. I'm asking, bring that 4 lakhs only. I won't take 12, I'll take 10 only. Against the partner, if he extends credit, I'm giving loan, believing on partner's obligation in LLP agreement. Getting my point? So, tricky point can be tested. Can I proceed? Next, maintenance of books and audit of books of accounts. Company books of accounts, you tell me, should be on which should be on which basis? Cash or accrual? Accrual. Which is system of accounting? Double entry of system of accounting. Here also double entry, but we had one privilege, either cash or accrual. Either cash or accrual. Accrual is best one, ma. Auditor point of view, accrual is best. Why? Because if I follow cash basis, receivables equal to 0, payables equal to 0. Is that balance sheet correct? No. Is that balance sheet correct or no? Suppose I am following accrual, my debtor is following cash. My debtor is following cash basis. Auditor of my company want to know debtor balance. So auditor wrote a letter to the debtor. What is the balance of my company in your books of accounts? What he will tell? 0. We are following accrual, that's why we shown debtor. The debtor is following cash basis, that's why he didn't show our name under creditor. Now auditor will get better evidence, no evidence, no evidence. That's why universal principle, all companies should follow accrual basis of accrual system, double entry system. Okay, for LLP privilege, either cash or accrual. Next one, at its registered office, maintenance of books of accounts at registered office for the prescribed period. Generally period means 8 years only. Statement of account and solvency, another important point. Tell me, what is the time period that company should file AOC for with ROC? AOC for OPC ma 180 days of closure of financial year ma. OPC 180 days. Other companies within 30 days of AGM. Within 30 days of AGM. If it is a foreign company, yesterday I told you 6 months from the closure of financial year. If extension is needed, ROC may grant extension up to 3 months. 6 months or 3 months. But here the time limit, AGM is not mandatory, right? That's why the time limit is 6 months. 6 months of closure of financial year. If you remember like that, it is also wrong only. It is also wrong. Here 6 months time period is given for preparation. Financial statement should be kept ready within how many months of closure of financial year? 6 months. Filing should be done within the next 30 days. There is a confusion among the students. Students think that within 6 months filing should be done. No. Filing should be done within 30 days after completion of 6 months. So simply ma, this is the financial year 25-26. Financial year 25-26. Financial year 25-26. What is the closure date? What is the closure date of financial year 25-26? 31st March 26. So we are giving you time up to 30th September 26 to make statement of accounts and solvency. Statement of statement of accounts and solvency. SOAS or SAS ma. That would be better. SAS, statement of account and solvency, nothing but financial statements. So financial statement should be kept ready within 6 months. And the same shall be filed within next 30 days. Next 30 days. That means by 30th October 26, file Form 8 with ROC. Which form? Form 8. Form 8 is for what? Statement of accounts and solvency. Can I proceed? Can't remember this. Just remember due date of AGM. 6 months from the closure of financial year. 30 days from the AGM date, I need to file AOC with ROC. Same here also. 6 months is for preparation. 30 days is for filing. Applicable form is Form 8. Can I proceed? Next one. Every LLP shall file statement of accounts and solvency with the registrar in the prescribed form. Form is Form 8, manner and with required fees. Audit of accounts. The accounts of LLP shall be audited as per prescribed rules. However, CG may exempt certain LLPs from audit requirement. Penalty for non-compliance of filing. See, this penalty is for filing. If you want, you can mark like this. If you want, you can mark like this. This fifth one is for third point. Fifth one is for third point. And the sixth one is for 1, 2, 4. Sixth one is for 1, 2, 4. What is 1? Non-maintenance of books of accounts. What is 2? Non-preparation of statement of account and solvency. What is 4? Non-audit. Non-audit. Punishment for non-maintenance of books of accounts, non-preparation of financial statements, non-audit. The punishment will be 25,000 to 5 lakhs. LLP, every designated partner 10,000 to 1 lakh. Only ROC filing, separate punishment. ROC filing. How to remember? Very simple ma. ROC filing, each day delay, separate penalty will be there. 100 per day, 100 per day. Whereas books statement to audit, each day delay will not be there. There, standard punishment 25,000 to 5 lakhs, 10,000 to 1 lakh. Can I proceed? Accounts and auditing standards as applicable, follow them. As applicable, follow them. This is like section 133 in case of Companies Act. Next, annual return. Annual return time limit is similar to foreign company time limit. Normal company should file annual return in which form? MGT 7, MGT 7A within how many days? 60 days of AGM. Foreign company 60 days of closure of financial year. Same concept, 60 days of closure of financial year. And applicable form is form number 11. Every LLP shall file annual return with the registrar within 60 days of financial year. So the due date will be 30th May. 60 days means April 30 days, so May 30 days you have to take. So May 30. Non-filing penalty, same like above ma. Same like above. This penalty, common penalty for both financial statements filing and for both and annual returns filing, common punishment. LLP, every designated partner, 100 per day up to 1 lakhs, 100 per day up to 50,000. You'll find only DP only, because DP is responsible for compliance of LLP Act. So DP gets punishment if LLP is not complying LLP Act. Next one, inspection. Inspection of minutes, you remember. Inspection of register of members. Inspection of books of accounts. Same. Incorporation document, partner details and changes, statement of account and solvency, annual return. Simply all these are filings with ROC ma. Whatever documents you filed with ROC, they are available for inspection. They are available for inspection by any person on payment of prescribed fees. When I file these documents with ROC, they become public documents available for inspection to any person. If you want to download that information from MCA website, 100 rupees is the standard fees. Over. Penalty for false statement. Sir, same point we have seen earlier, no sir. That is false statement in incorporation. False statement in incorporation, imprisonment 2 years, that point we have seen. This is false statement in the above filings. False statement in the above filings, that is, annual returns, statements, nothing but financial statements. Then the punishment, imprisonment up to 2 years and fine 1 lakh to 5 lakhs. Yes ma, imprisonment up to 2 years and fine between 1 lakh to 5 lakhs. Next, power of registrar to obtain information. LLP filed annual return with ROC. Unfortunately, ROC verified this annual return. Generally, all these forms are STP. STP means once you file it, that's it. No need of further confirmation. Filing alone is sufficient. But randomly, ROC verified few annual returns, and our LLP annual return was picked up. And ROC believed that some information is missing. Or maybe ROC believed that some financial affairs of the company were mismanaged. Now ROC is having power to carry investigation. It's like inspection only. See, ROC may require any person, maybe present partner or past employee, maybe present partner, maybe past partner, to answer questions, make declarations, or to provide information in writing within a reasonable period. Getting my point? That's random inspection. When they are going through the documents, they found that there is some mistake. So immediately they will ask, who filed the form? Come on, provide some information. If they respond okay, if that person fails to provide required information within the given time, registrar or information has been served, but ROC is not satisfied with the reply. No reply or no satisfaction in reply. Then registrar may summon them to appear before him, an inspector or any public officer designated by the registrar. First we will ask information. We do no need to come to office, no need to come to court, or no need to come to our premises. First we will ask for information. You provide that information over mail or through other filings. If you are not providing information, we will issue summons. Summons means you need to attend the hearing. Anyone who fails to comply with registrar summons without a lawful excuse shall face a fine of 2,000 to 25,000 rupees. See, this is the second offense. First offense, what is the first offense? You didn't file reply, or your reply is not satisfactory. That's why he is giving summons. If you don't comply with summons without any permissions, then punishment 2,000 to 25,000. Okay, na? Now comes compounding of offenses. Compounding of offenses, altogether a different topic. Compounding of offenses. Sir, what is this concept? You committed one mistake, you did one mistake. Immediately you won't get any punishment. Suppose tax evasion is there, for example, tax evasion is there. Do you think immediately you will be found out and you will be punished? No. Some investigation proceedings will commence. For notice 1, notice 2, hearing. Your side lawyer and government side one lawyer will come. Both the parties will have some arguments based on the evidences you produce, based on the evidences government is having. Finally judge will give judgment. Is it one day activity or time taking activity? Time taking activity. Getting my point? Now you thought that, oh my god, instead of going through this lengthy proceedings, I'll accept my mistake. You punish me straight away. Why unnecessarily? For example, if 1 year is taking, 1 year happens, suppose to complete all these procedures, 1 year time is required. 1 year paying to lawyer fees, 1 year attending to the hearings. Why this all nonsense? For me, time is important. So judge, I'm ready to accept my mistakes. Please compound my offenses. That means what? Immediately you give me that punishment, I'll pay the amount. Okay, na? So you can avoid lengthy legal proceedings. But this benefit is available only to one type of offense. Sir, which type of offense, sir? Offenses where fine is the solution. Offenses where punishment is only fine. Punishment is only fine. Suppose if you see this one, 2,000 to 25,000. This is only fine. But if you go with the 21st point, here only fine and imprisonment. Fine and imprisonment. If fine and imprisonment is the case, compounding of offense is not given. Compounding of offense is not given for fine and imprisonment, fine or imprisonment. Compounding of offense is given only for the offenses where fine is the only punishment. And sir, what is the punishment here? Punishment will be not less than minimum fine, not more than maximum fine. That means same fine. Sir, who is having authority to give this benefit, sir? RD. Who is RD? Regional Director. But you can't file application directly to RD. You have to file application with ROC. ROC will forward that application to RD. And remember, once compounding is done, you can't claim same benefit for same offense for the next 3 years. I'm using the word same offense for the next 3 years. That means, sir, for different offense, can I take compounding benefit? Yes. For different offense, yes. Suppose books of accounts is there, non-maintenance of books of accounts. There is a just punishment. Punishment is fine only. That is one offense. This is another offense. I committed 2 offenses, sir. One is in January, other one is in September. Can I take compounding of these 2 offenses? Yes. No, sir. January I committed mistake with respect to books of accounts. Again in December, same offense I committed, sir. Now for the second offense which I committed in the same year, December, can I take compounding benefit? No. Compounding benefit is allowed only once in 3 years. Once you take that benefit, next 3 years you can't take that benefit for same offense. So remember these points. What is the time limit? 3 years. Once you took the benefit, next 3 years for same offense, no compounding benefit. Who is having authority to give compounding benefit? RD. And next, to whom we need to file application? ROC. Which offenses can be compounded? Only the offenses where punishment is the fine. Enough ma. Beyond this there is no point. RD may compound your offenses. What is the punishment? Not less than minimum, not more than maximum. Sir, then what benefit I am getting, sir? You no need to go through the lengthy legal proceedings. Everyone? Limitations on compounding. Once one offense is compounded, next 3 years, the second offense should occur after 3 years. That means within the next 3 years, the same offense will never be compounded. Application for compounding must be made to the ROC, who will forward them to the RD or unauthorized officer. If an offense is compounded, ROC must be informed within 7 days. Second time limit. Second time limit 7 days. Communication with ROC within 7 days of RD's order. If an offense is compounded before prosecution, that means court taking up the case, no prosecution shall be initiated. If an offense is compounded after prosecution, ROC must inform the court in writing that the offender should be discharged. RD may order LLP partner, designated partner, employee to file or register returns, accounts, documents within a specified time. So here RD will give some extra time. You fail to comply, right? Now I am giving you time. You just comply with the things. Suppose, sir, RD order also you didn't comply. Then maximum punishment would be twice the punishment prescribed in the section. Suppose 1 lakh is the maximum fine. RD told 1 lakh rupee you pay fine and you do the things. Suppose if you are not following RD order, then the punishment will be twice of the maximum punishment, twice of the 2 times of the 1 lakh, 2 lakhs. Getting my point? See, to understand court proceedings, best example, JB movie, Surya sir's JB movie is there. So Sinatali, Rajanna, I think victim, these people. So that police who tortured and killed Rajanna is having 2 options: either go with lengthy proceedings or immediately surrender and accept the mistake. What is the benefit in second case? You will get less punishment and lengthy court proceedings can be avoided. It's a benefit to the court only. Administrative burden over court can be reduced. That is a point. That is the background of this concept. Okay, na? But you have to be you have to be very sure with respect to the offenses. Not all offenses can be compounded, only fine related offenses. Once compounded, same offense cannot be compounded for the next 3 years. Different offense can be compounded, yes. Next, assignment and transfer of partnership rights. Simple concept, simple point. One time this point was tested for 4 marks. Remember? Sorry, listen carefully. Because of partner in LLP, what benefits partner will have? A is a partner of ABC LLP. ABC LLP, A is a partner. Now what rights he will have? First, share in profits, right? Share in profits. Next, share in contribution. Whatever amount he contributed, if he want to come out, he can take back his contribution. And third one is management rights. Management rights means voting rights, simply voting rights. Whenever you want to change the deed, you need to consult me. Whether I'm a designated partner or normal partner, my consent is compulsory, yes or no? So being a partner, I'm allowed, I'm entitled to enjoy these rights. I'm entitled to enjoy these rights. Now, sir, can these rights be transferred? Can these rights be transferred is the question. That is what our next topic, assignment or transfer of partnership interest. And the answer is only first 2 can be transferred. First 2 can be assigned. The third one cannot be transferred, cannot be assigned. Because partnership is a relationship. It's a trust. It's a trust. Suppose A is having a share of 20 lakhs capital and a share of 10 lakhs profit. Total how much is there? 30 lakhs. Some one day A is facing some severe financial crunch. Now can he pledge this property with banker? Yes. Now who is the banker? Transferee. Can he sell this asset? Yes. Now the buyer of the share of A is just a transferee. He is just a transferee. being a transferee, you are entitled to share in the profits of LLP. You are entitled to the share in the contribution if LLP is wound up. But you cannot participate in day-to-day affairs of the LLP. Management rights can't be transferred. That point, if you understand, this concept is over. Partners' right to share in the profits and losses, receive distributions as per LLP agreement is transferable either fully or partially. Transfer of rights does not by itself disassociation of the partner, dissolution, because we had a concept of perpetual succession. A transferee or assignee of the partner's rights cannot participate in the management or conduct of LLP activities, cannot access LLP transaction information by virtue of transfer alone. So simply, what can be transferred? Monetary rights can be transferred. Can management rights be transferred? No. Sir, for transferring management rights, what is the solution, sir? Very simple. Go through LLP agreement. With the consent of all partners, you can admit the transferee as partner. If transferee is becoming partner, he will get not only monetary rights but also management rights. Getting my point? So transferee gets only which rights? Monetary rights. Can he get management rights? No. Foundation, yes, January 26, Jan 26, no, September 26. Foundation student, foundation paper, this question is there. September 25, yeah, September 25 attempt, 2 marks, actually question is for 6 marks or 7 marks. One among those 3 questions is this one. Transferee want to access books of accounts, allowed or not allowed? Not allowed. Clear? Next, simple point, effect of conversion of firms into LLP. Very simple. In this, firm need to follow schedule 2, private company need to follow schedule 3, unlisted public company need to follow schedule 4. That's it. Procedure, what? First you file an application with registrar. Which registrar? Where your proposed register office is going to be situated, with that registrar. Once you get certificate of incorporation, file it with your previous registrar. Previous registrar means one who gave certificate under Indian Partnership Act if registered firm, or one who gave certificate of incorporation if you are a private company or a public company. Why? So the previous registrar will close your details and the new registrar will maintain your details. Only through application, ROC, upon confirming that firm, private company, unlisted public company has complied with all requirements, register the submitted documents, issue certificate of registration. One time limit. Within 15 days of registration, LLP must inform previous registrar. Registrar of firms means this is for partnership firm. This is for partnership firm in case if it is a registered firm. ROC is for private company, public company, unlisted public company, private company. About the conversion and provide LLP details in the prescribed manner. After conversion, partners, shareholders, LLP must comply with the respective schedule applicable to them. From the date of registration certificate, conversion is said to be effective. And the tax benefits, tax exemptions, you all know in PGBP. Conversion, transfer of LLP, all the members should become partners. Then only capital gain exemption will be there. There will be no capital gain tax. And this is one more new point, not new point, same point I explain you in case of change of name. Just a sample example, suppose myself private company borrowed 20 crores from SBI. After borrowing 20 crores, I changed my constitution. How? Private to LLP. What is the outstanding loan in private company? 20 crores. Now post conversion into LLP, whether LLP is liable for this 20 crores debt or not is a question. Are you getting my point? Post conversion, whether LLP is liable for the debts entered by the private company? Answer is yes. Getting my point? See, all movable, immovable, intangible property along with all assets, rights, liabilities, obligations of the firm or company will automatically transfer to LLP. No additional assurance deed is required. Firm or company shall be deemed dissolved and removed from the records of the registrar of the firms or ROC. Suppose if you see property documents, if you go through your parents' property documents, names will be given, names will be mentioned, who the buyer, who the seller. Suppose private limited is the owner of some 10 buildings. On all those documents, who is the owner? Some ABC private limited. Now ABC private limited got converted into LLP, ABC LLP. Whether fresh registrations required or not required, all the assets of private limited company becomes assets of LLP. All the liabilities of private limited company becomes liabilities of LLP. That is the point. Not new, but remember this point also. Compromise arrangement of LLP. Internal reconstruction, right? Almost over, almost done. 60. After that, liquidation. Sorry. Closure of winding up of LLP. Business transactions is almost done. Differences, small concepts only. This is the last but one concept. Before winding up, last but one concept. So what is this concept? Compromise or arrangement of LLP. Internal reconstruction. If you know internal reconstruction in advanced accounting, this is over. Example, ABC LLP took loan of 30 crores from Axis, SBI, PNB, next one HDFC. Each 7.5 crores each 7.5 crores. Each bank gave loan of 7.5. For easy calculation purpose, I'll make it as 100 crores. Yeah, 100 crores. Each bank how much? 25 crores. At the time of borrowing, LLP's financial position is stable, no problem. But 2 years after borrowing that amount, COVID pandemic came. Business of ABC LLP badly affected. Now ABC LLP is not in a position to repay these complete amounts. But by the time outstanding loan 100 crores plus interest, some 40 crores, total 140 crores is the outstanding liability. So now there is a problem, there is a dispute, or there is a conflict between ABC LLP and these banks. Banks are forcing, come on, pay the amounts. ABC LLP is telling that we are not having liquid money to pay that amounts. So in case of conflict, the solution to resolve that conflict is compromise or arrangements. So either LLP can go to tribunal, remember, authority is tribunal. Either LLP can go to tribunal, or partners can go to tribunal. Oh my god, this much pressure with banks. No. Partner can go to tribunal, or these banks can go to tribunal. Creditors, nothing but creditors. So who can file an application with tribunal? Either partners or LLP or creditors. For what purpose? Compromise. So tribunal will call for a creditors meeting, and in that creditors meeting, on behalf of ABC LLP, either a designated partner or resolution professional, IRP, RP, in charges chapter I told you, these people will introduce a proposal. The proposal is, sir, please waive off this interest. Balance, only principal amount we will pay. And in that principal also, we paid installments 2 years, sir. After taking loan 2 years, we paid installments. Say for example, 30 crores we paid installments. Not installments, interest amounts. Interest we paid some 2 to 3 years. So you please consider that amount also. And give some waiver in principal also. Some 25 crores or some 20 crores only you give waiver. Each 5 crores you give waiver. Balance 80. Balance 80 crores we will pay you, sir. Every month we will pay, say for example, 2 crores. In 40 months we will clear your liabilities. What banks will think? Okay, instead of becoming NPA, instead of getting 0 in return, every month if they are paying 2 crores to us, okay, right? So banks will agree. If banks approve this compromise arrangement, immediately NCLT will give confirmation. Getting my point? This is nothing but revival. This entire procedure we call it as revival. Okay, na? Concept over, just procedure we will see. Whenever there is a dispute between LLP and creditors, LLP and partners, an application can be filed with a tribunal. Who can file application? LLP, creditor, partner, liquidator. Suppose revival is not possible, compulsory liquidation, then who will come forward? Liquidator. None other than RP only, resolution professional. His name may be liquidator or his name may be resolution professional, depending on the situation. Order a meeting of the creditors or partners to be called, held and conducted as per prescribed rules or tribunal directions. Next point, binding effects of the compromise. For this compromise, we need approval of 3/4 in value of the creditors. See, 4 creditors are there: SBI, HDFC, PNB, and Axis. Each how much? 25 crores. So now 3/4 in value means total debt outstanding is, for example, outstanding debt 140 crores, right? Including interest 140. So 3/4 into 140 crores, around 45 crores. Sorry, 45, 105 crores. 105 only, yeah. 3/4. 4 3 3 35 35 3 105, correct. So if I get consent from 105 crores rupees creditors, it's not 3/4 of the creditors, it's 3/4 of value, 3/4 in value of the creditors. Here in my example, all 4 banks give equal loans, right? Equal loans. That means out of 4, 3 banks give approval. Since equal amounts, if different amounts, I need to get consent from 3/4 in value. Simply to avoid confusion, again I'm telling you what is the outstanding debt, disputed debt, into 3/4. That value creditors. That value may be 1 creditor or 2 creditors or 3 creditors. That many creditors should give approval. Then tribunal will give final approval. Whatever compromise arrangement, whatever compromise agreement approved by the tribunal, it will be binding on all creditors. Why all creditors? For example, suppose in my example, Axis gave approval, PNB gave approval, HDFC also gave approval, SBI didn't give any approval. Since 3/4 in value condition satisfied and tribunal also approved it, now SBI has no other alternative. SBI is bound by it. That means SBI should also waive off some interest. SBI should also waive off some principal. LLP, and if the LLP is being bound up, liquidator and contributories. Understood a point? Next, the tribunal will not approve the compromise unless LLP or applicant disclose all the material facts, including latest balance sheet of the LLP, any ongoing investigation proceedings. So the conditions to get compromise is: first one, 3/4 in value of the creditors. Second one, LLP should disclose all the material facts, including latest financial position of the LLP. If these two conditions are satisfied, then tribunal will give approval. Which two conditions, ma? First, creditors approval. Second, disclose all material facts, including two things. One is latest financial position. Second one, ongoing proceedings, ongoing investigation proceedings. LLP must file tribunal order with ROC within 30 days. Whenever tribunal passes an order, within 30 days you file it with ROC. Penalty for non-compliance, LLP every DP. Common punishment, ma. Since beginning of the chapter, we are reading the same punishment. Non-compliance with ROC filings, 10,000 plus 100 per day up to 1 lakh LLP. Designated partner, 10,000 plus 100 per day up to 50,000. Next, stay on proceedings. The tribunal may stay any suit or proceeding against LLP until compromise application is resolved as per its discretion. That's okay. Next point, section 61. What section 61 is telling you, just now I told compromise in my example, compromise period is 40 months. Every month we will pay 2 crores, right? So once tribunal approves this compromise, don't think that tribunal will leave that situation. Tribunal will keep on monitoring the situation. What are all the better things required? Tribunal from time to time will pass an order to implement those better things. That is section 61. See, tribunal is having power to supervise how the compromise or arrangement is going on. If at all needed, some incidental or ancillary directions, some modifications may be prescribed by the tribunal. If tribunal believes that compromise is not a solution, suppose what LLP promised, every month we will pay 2 crores. 3 months over, LLP paid nothing to the bankers, and tribunal observed the same thing. Okay, compromise cannot be worked out satisfactorily. Then what tribunal will do? Tribunal will order for winding up of the LLP. The sanctioned order, if it is not getting worked, if it is not implemented satisfactorily, then tribunal, either on its own motion or on an application by the creditor, for example any person interested in the affairs of the LLP, for example creditor, tribunal will pass an order of winding up of the LLP. And next, 62 is about amalgamation of LLP. That means 60-61 talks about internal reconstruction, 62 talks about external reconstruction. External reconstruction means amalgamation merger. Getting my point? So far, the example which I told you, listen to that example only. Total 100 crores it borrowed, interest 40, total 140. LLP made a proposal, sir, we are ready to pay 80 crores, each month 2 crores. Tribunal said okay, but tribunal believed that it is not possible. Immediately tribunal will order for winding up of the LLP. That's okay. Suppose internal revival is not possible. If internal revival is not possible, and looking at the manpower in that LLP, some 10,000 people are employed in that LLP. If LLP was wound up, 10,000 people becomes employed, people will become unemployed, jobless. 10,000 families will be affected. So internal revival is also not possible. Then conduct external reconstruction. External reconstruction means one solvent company, financially sound company will come and acquire this entity. One LLP acquiring this LLP. Amalgamation is nothing but external reconstruction. So here, application is made under section 60 for a compromise or arrangement, and it is shown that proposal is for reconstruction of LLP or amalgamation of 2 or more LLPs. The undertaking, property, liabilities of transferor LLP will be transferred to transferee LLP. Tribunal may provide for transfer all or part of the undertaking, property, liabilities of the transferor to transferee, continuation of pending legal proceedings by or against the transfer LLP, dissolution of transfer LLP without wind up. Without wind up. Winding up is different, liquidation is different. Dissolution, sorry, winding up is different, dissolution is different. Winding up means sale of all assets. Liquidation, dissolution. Liquidation means all the assets will be sold and all the liabilities will be settled. Dissolution means cancellation of the certificate. That means there is no association at all. Even without dissolution, even without winding up, dissolution may be ordered for. Even without winding up, dissolution will be ordered. Why, sir? The reason, it is not selling the assets. It is transferring all the assets and liabilities to the another LLP. Now no need to sell assets, no need to settle the liabilities. So straight away dissolve. Provision for dissenting persons based on the tribunal directions. Such incidental, consequential, supplemental matters as may be necessary. So these are the tribunal powers. Tribunal may provide for transfer of all assets and liabilities to the transferee LLP. Transfer of all pending proceedings. Suppose on transfer LLP, some 20 civil cases are there, 20 civil disputes are there. Example, income tax litigation, GST litigation. Now, who will take care of all these litigations? Transferee LLP. Why? Because it is acquiring transfer LLP business. Very simple, very simple. Vodafone is doing business, Idea is doing business. When Idea acquired Vodafone, on Vodafone, all the pending proceedings will be transferred to Vodafone Idea. That's it. Conditions for amalgamation. The tribunal will not sanction amalgamation of LLP under winding up unless ROC submits a report confirming that LLP affairs are not prejudicial. LLP affairs were not conducted prejudicially against partners' interest or public interest. For example, my LLP is in full of profits. I need to pay 26%. I need to pay 31.2% tax. There is another LLP which is with huge losses. If I acquire that LLP, my profits, those losses will be set off. There will be zero tax. Genuine or not genuine? Genuine or not genuine? Suppose if the losses are genuine, no problem. Sir, they intentionally created this LLP and they created some fake losses. Now if amalgamation happens, this will avoid taxes. Now this is not genuine case. So whether it is genuine or not genuine, who will give report? Registrar will give report. LLP affairs were not conducted prejudicially. There is no matter opposite to public policy. You can proceed with the amalgamation like that. Official liquidator examines the LLP records and reports that affairs were not prejudicial to the partners as well as public interest. Then only tribunal will sanction the amalgamation. If an order directs the transfer of property or liabilities, then properties in the name of transferee LLP, liabilities will become those of transferee LLP. See, property in the name of transfer LLP will be transferred to transferee LLP, and the property will be free of any charges if the order specifies that charge is ceased to have effect. Suppose any charges were created on the property, if tribunal orders for no charges, then the property will be charge free property. Tribunal is having that power also. Within 30 days of tribunal order, LLP must file a certified copy of tribunal order with ROC for registration. This is common point. CG order, tribunal order should be filed with ROC. This is a common point only. If LLP fails to file the order within 30 days, same punishment which we read before, 10,000 plus 100 per day up to 1 lakh for LLP. Every designated partner, 10,000 plus 100 per day up to 50,000 rupees. Property means not only intangible assets but also rights, powers, assets. Suppose ma transfer LLP is having right over this property. Right means not ownership. 20 years lease agreement. Owner of this building gave 20 years lease agreement to the transfer or LLP on this property. Lease agreement has been created. Now once amalgamation happens, balance lease period, who can enjoy? Transferee LLP. So properties include all the rights, powers and assets. Liabilities include all obligations and duties, and LLP cannot be amalgamated with a company. Okay na? LLP shall be amalgamated with another LLP. Is it clear, everyone? So simply, one is about internal reconstruction, other one is external reconstruction. For internal reconstruction, two conditions to be satisfied. One is 3/4 in value of the creditor should give approval, and LLP should disclose all the material facts including latest financial position and ongoing pending proceedings. Okay na? That is internal reconstruction. Whatever order passed by tribunal, file a copy with ROC. Coming to external reconstruction, only condition to be satisfied is the registrar, the liquidator, has to give a report stating that affairs of the transfer LLP is not prejudicial to the public, not prejudicial to the partners. Whatever order passed by the NCLT, file a copy with ROC within 30 days. That's it, over. Next one, circumstances in which LLP may be wind up by the tribunal. See, winding up is of two ways ma. Voluntary, mandatory. Voluntary, compulsory. Voluntary means as decided by the partners. If partners decide, they can voluntarily wind up. Mandatory means tribunal passing an order. There is no option at all. Let's see. Winding up of LLP can be voluntary or by the tribunal. Once LLP is wound up, it may be dissolved. Winding up, dissolution. Already told. Once again I am telling. Winding up means process of, in case of winding up, selling all the assets, settlement of all the liabilities. That phase we call it as liquidation. Once assets become zero, liabilities become zero, what is the necessity of having that association? So we will tell them, go back to your homes. There is no more an association. That we call it as dissolution. Dissolution. So dissolution is nothing but death of entity. Tribunal may order winding up of LLP in the following 5 cases. 2 times I think this was tested. 2 times so far. First, LLP itself decided to wound up by the tribunal. Sir, you told this is voluntary. No, sir. Voluntarily they can wind up. At the same time, they can file an application with tribunal. Why? Tribunal is an independent person. If independent person comes and conducts, if independent person monitors the winding up proceedings, it will happen fairly. It happens fairly. So LLP may take help of tribunal, or if the number of partners fall below 2 for more than 6 months, minimum number of partners falling below the statutory limit. LLP has acted against the sovereignty and integrity of India, security of the state, public order. Suppose recently Russian President Mr. Putin sir visited our country India. That time you started a slogan, go back Russia, go back Russia. Now tell me, because of that slogan, the relationship between India and Russia will be affected or will not be affected? Definitely. So if you incorporate LLP for such kind of things, LLP will be wound up. LLP fails to file the statement of accounts and solvency or annual return with ROC for 5 consecutive financial years. 5 consecutive financial years. Remember the time limit, ma. Very important. Continuously 5 years, if you are not filing financial statements, not filing annual returns, what ROC will think? LLP is no more. NCLT will also pass an order. LLP is no more. Tribunal deems it just and equitable to wind up LLP. Ma, suppose ma, in our LLP there are 4 partners, ma. For every decision, majority permission is required. Majority approval is required. 2 partners are in favor, 2 partners are against. That means, is there any relationship between them? Suppose any proposal, 2 are in favor. Oh, you are favor, I am against. Suppose this fellow against. Oh, you are against, I am in favor. Now tell me, is there any sense continuing that LLP? No. So, just and equitable grounds, reasonable grounds, tribunal may pass an order to wind up the LLP. Are rules for winding up dissolution. CG is having authority to make the rules. Business transactions of partner with LLP. In partnership, If a partner do any business with firm, he can't maintain secret profits. He should account the profits to the partnership firm. Getting my point? Partner should not maintain any secret profits. If partner is using firm property, earning some money, that money should be given to the firm. But coming to LLP, it's a body corporate. It's a separate body. Partners are separate. So can a partner do business with LLP? Yes. Can a partner do business transaction with LLP? Yes. A partner may lend money, transact business with LLP, and will have the same rights and obligations as a non-partner regarding the loan or transaction. Next one, application of the provisions of Companies Act. This point, just for knowledge sake, you read it. First, we can't apply directly Companies Act provisions to the LLP. For applying Companies Act provisions to the LLP, first you need to publish a draft notification. First, you need to introduce a motion. That is nothing but you need to keep a proposal in both the houses of the parliament for 30 days. Within 30 days, if we get approval from the parliament, you can apply Companies Act provisions to LLPA. Or else, if both the houses disapprove or modify the notification, then it cannot be issued originally, or it can be issued in the modified form as agreed by both the houses. Getting my point? See, LLPs are governed by LLP Act, but if you want to apply Companies Act provisions, introduce a proposal in both the houses of parliament for 30 days. That means within 30 days get approval. If you are getting approval, then you can publish that notification. Accordingly, you can apply Companies Act provisions to LLP, or else no. Payment of additional fees, first time delay, normal fees. First time offense, normal fees. Subsequent offense, same offense. For same offense also same fees means how it would be. Suppose helmetless drive, first time 500 rupees, second time 1000 rupees. Like this, additional fees can be filed after due date by paying additional fees as prescribed. This does not affect any other liability or penalty under the Act. Different fees, additional fees may be prescribed for different classes of LLP. Different class of LLP means generally, small LLPs are penalty for small LLP is less than penalty for normal LLPs. Benefit of small LLP, penalties are very lower amounts. That point. Enhanced punishment. If an LLP partner DP commits a second or subsequent offense, imprisonment will be same, but fine will be twice of the original amount. So yes, there is a difference, The difference, additional fees is for delay. Additional fees is for delay. Enhanced punishment is for second or subsequent offenses. And what is the enhanced punishment? Same imprisonment. There is no change. Imprisonment 5 years means subsequent offense also imprisonment 5 years only. But fine will be twice of the normal fine. Can I proceed? Last points. I still remember May 25 attempt, I think. May 25 attempt. One question came on these two differences. LLP versus limited liability company, I think 5 marks came. So it's advisable to read 10 points because maximum question comes for 5 marks. So 2 points, 1 mark. Okay, na? So one is LLP Act, other one is Partnership Act. One is a body corporate, other one is not a body corporate. Legal entity separate from members, not a legal entity. Registration mandatory, registration is voluntary, agreement is enough. Perpetual succession, name, suffix is LLP, but there is no guidelines for partnership. Liability of partners is limited to the extent of contribution amount, whereas partners unlimited liability. Mutual agency is between partner and LLP, but here mutual agency is between one partner and all other partners. Designated partner concept is there in LLP. At least how many designated partners? 2 individuals. One should be resident, whereas here there is no such provision. Common seal here optional, here not applicable. Legal compliance, responsibility, designated partner. Here all partners. Annual filings, only 2 filings. Mandatory 2 filings. Event based filings you need to do whenever an event happens. So financial statements, annual returns. Here it is not required. Zero compliance cost actually. Foreign partnership not allowed in case of Indian partnership firms. Foreign nationals cannot become partner in partnership firms, whereas foreign nationals can become partner in LLP. Minor as a partner, minor cannot be admitted to the benefits of LLP, whereas minor can be admitted. Next, company LLP, one is act. Next one, how many members, how many partners, that point you can write. Here owners are partners, here owners are members. Internal governance structure taken care by agreement, whereas here statute. Name LLP Limited, Private Limited. Number of members partners 2 to unlimited. Here 2 to 200 for private company, 7 to unlimited in case of public company. Liability of the members, both cases limited only. But here agreed contribution, here unpaid amount. Next management taken care by designated partners. Here taken care by board of directors. Minimum 2 designated partners. Private company directors minimum 2, maximum 3. Let's continue marathon with the next concept, Foreign Exchange Management Act 1999. From this chapter, you can expect 14 marks in examination. Even if you see recent examination, January 26 attempt, 3 MCQs came, 6 marks, and 2 descriptive questions came, 8 marks. So from this chapter, if you go through previous 4 to 5 attempt question papers, compulsory case scenario question is coming. Case scenario multiple choice questions are coming. So don't take this chapter choice. Small chapter, simple chapter. And coming to the important concepts, we had only some 6 to 8 concepts in this chapter. Out of that, important concepts are residential status, person resident in India. Next, prohibited current account transactions, prohibited capital account transactions. Before I start this chapter, let me give you a brief introduction. So today, for any transaction you take, the consideration will be discharged in money. Earlier we had barter system concept. Barter system, exchange of goods and services, but we had a concept of money. So when a transaction happens between two people, and if these two people belong to same country, consideration will be settled in rupees, which is our legal tender money. But don't think that our country is rich in all resources. We are rich in spices, agriculture goods, but we are not having crude oil reserves. See, all these agriculture goods we produce in villages, but population, you will find majority population in urban areas. Now to bring these goods from village areas to the urban areas, we need transportation system, and the transportation system is based on crude oil. So now we need to import crude oil from other country. That means the transaction is happening between two people, but these two people are from different countries. One is from India and the other one is from outside India, nothing but foreign. Now how to settle this transaction? Is money, rupees, sufficient to settle this transaction, sir? No. Why? Rupee is legal tender money in India only. So when a transaction happen between two countries, we call it as cross-border transaction. So that means transaction is of two types, domestic transaction, cross-border transaction. For domestic transaction, rupees is enough. Whereas for cross-border transaction, we need foreign currency. We need foreign currency. Based on our history, US is the largest and strongest economy so far. That's why all these cross-border transactions, the settlement used to happen in US dollars. Getting my point? So dollars. So wherever I tell foreign exchange or foreign currency, I'll denote it in dollars. So our country need dollars to import the goods. And whenever we export something to other country, they will pay us dollars only. Now it is important to maintain reserves, foreign exchange reserves. Why? Because we are not rich in all the resources, right? So some medicines, some pharma medicines or some crude oil and defense items also, you see, majority of our defense items we import from Russia. So to have this kind of goods, we need to have foreign exchange reserves. Are you all getting my point? Now we need to manage these reserves. Why? Because if there is no regulation or if there is no management, at one point of time they will become zero. They will become zero. In that case, we can't manage our imports. We can't finance our imports. Now our transportation system, our defense will be at risk. So initially, in Defense of India Rules 1939, British brought rules regarding usage of foreign exchange reserves. Later when Nehruji, when India got independence in the year 1947, Nehruji brought Foreign Exchange Regulation Act 1947. And when Indira Gandhi madam became Prime Minister, she also brought one more act, FERA 1973, Foreign Exchange Regulation Act. But you all know what happened in 1991. In 1991, Indian economy opened its doors for global trade. LPG schemes became popular. Liberalization, privatization, globalization. So before that, we had, foreign exchange reserves very, very little. We can't even finance, not even, 1 year imports also. Very little, maybe some 6 weeks, I think, 6 weeks. It's not about, it's not important. Time period is not important. But these LPG schemes, it opened Indian economy to the global. Now what happened is, Foreign Exchange Regulation Act 1947, Foreign Exchange Regulation Act 1973 are the main objective of these two acts is conserve foreign exchange. Conserve, that means protect our reserves, protect our reserves. Sir, one of our citizen want to go to abroad for studies, sir, for studies. Both acts said no, we don't allow you to withdraw foreign exchange reserves to manage your studies abroad. Sir, then critical conditions or emergency, some medical treatment is required. 1947 said no. Whereas 1973, some relaxation is there, some relaxation is there. See, according to Foreign Exchange Regulation Acts, 1947 or 1973, all the foreign exchange transactions are prohibited unless permitted. Prohibited unless permitted. See, because of this, what happened, if I don't purchase goods from your country, why I'm not buying? If I buy goods from your country, I need to settle this transaction in what? Dollars. If I pay dollars, what happened? My reserves will come down. If I don't buy goods from you, will you buy goods from me? No. As a result, what happened? There is no movement in foreign exchange reserves. Slowly coming down, coming down. Foreign exchange point of view, our country is at insolvency phase, bankruptcy phase. Suddenly in 1991, you all know what happened. LPG schemes were announced, and that time, expert committee thought that, this 1973 Foreign Exchange Regulation Act was completely outdated one. We should bring a new one. And that new act was enacted in the year 1999. And that new act is nothing but Foreign Exchange Management Act. This is not a regulation act. This is a management act. One difference I can tell you, the difference between FERA and FEMA. Under FERA, all the foreign exchange transactions are prohibited unless permitted. Negative. Prohibited unless permitted. Whereas under FEMA, freely permitted unless prohibited. Getting my point? See, look at the act name. What is the name of the act? Foreign Exchange Management Act. This is a statute that manage foreign exchange reserves of our country. A statute that can manage foreign exchange reserves of our country. And it was, even though enacted in 1999, it came into force in the year 2000. 2000, it came into the force. Salient features, you give one time reading, ma. This point important, RBI oversees foreign exchange transactions. Enforcement is handled by Directorate of Enforcement. As you all know, legislative body, executive body, judicial body, three bodies are there. Here executive body is RBI. RBI oversees foreign exchange transactions, and one more body, that is Directorate of Enforcement. They are responsible for this statute, FEMA 1999. Preamble. Just now I told you how many previous laws we are having regarding foreign exchange. 3. Defense of India rules. Next one, FERA 1947, FERA 1973. So the main objective and the preamble of this FEMA is to consolidate and amend laws related to foreign exchange with two key objectives. One is facilitating external trade and payments. External trade means nothing but imports and exports. Transaction between two countries. Cross-border transactions. Facilitate external trade and payments, promoting an orderly development and maintenance of foreign exchange market in India. Very important. You have to remember these two objectives. You have to reproduce as it is. What are the two key objectives of FEMA? One is facilitate external trade and payments. Second one is development of orderly development and maintenance of foreign exchange market in India. Like stock markets or for share, company securities. Here also development and maintenance of foreign exchange market. Getting my point? That means no unauthorized or no illegal foreign currency transfers you will notice here. There is a system which will monitor foreign exchange transactions. Development and maintenance of foreign exchange market in India. So tell me, what are the two important objectives of FEMA? Facilitate external trade and payments. External. If it is a domestic transaction, rupees is enough. FEMA is not applicable. Next one, development and maintenance of foreign exchange markets in India. Extend and application. It is applicable to whole of India. It is also applicable to BOA. Remember BOA. Generally BOA means books of accounts, right? But under FEMA, BOA means branches, offices, agencies. Located outside India but owned or controlled by person resident in India. Masima, between two persons, if transaction happens in foreign currency in India, FEMA is applicable. FEMA is applicable for all the foreign currency transactions that happen in India. It is also applicable to the persons located outside India but owned or controlled by Indian person. Infosys, Indian company, having branch office in USA. Now, USA branch, is it under FEMA Act 1999? Yes. It also applies to branches, offices, agencies located outside India if they are owned or controlled by Indian residents. Suppose if they are not controlled by Indian residents, then FEMA is not applicable to them. Okay, na? Next one, covers contraventions and contraventions committed outside India by anyone to whom the act applies. So if you don't comply this FEMA Act in India, it will come under A point. FEMA will levy punishment on Directorate of Enforcement will levy punishment on you. Suppose if the same thing you are doing outside India, you are already covered under FEMA, then your offenses outside India are also covered. Your offenses outside India are also covered. Commencement, important, remember, FEMA 1999 came into force on 1st June 2000. Even though it was enacted in the year 1999, it came into the force with effect from 1st June 2000. Can I proceed? LLP Act 9th January 2009. 9 January only, 7 January President consent. 9 January it came into the force. Next one, definitions. Sir, definitions important, 100% important. Previous attempt, I think September attempt, I think 2 definitions were asked for 4 marks. Each 2 marks. They will ask foreign exchange, define foreign security. Getting my point? So definitions important. Authorized person is equal to authorized dealers, money changers, offshore banking units, any other person authorized under section 10 subsection 1 to deal in foreign exchange or foreign securities. Suppose you are going to Dubai, or you are going to, say for example, Malaysia for a trip. Now our local currency, our money, is it enforceable outside India? No. So at airports you will see these money changers. You can deposit Indian currency, you will get dollars. Authorized people are, sir, authorized people. See, these people are like dealers, These people are like dealers who helps you to convert rupees into dollars, dollars into rupees. If you ask me from company point of view, securities point of view, for us depositories means NSDL, CDSL, right? NSDL, CDSL. Foreign exchange point of view, if you want to transfer foreign exchange, foreign money, you can't do it directly. You can do it only through authorized person. Who comes under authorized person? Dealers, money changers, offshore banking units, person authorized under section 10 subsection 1. Okay, na? Next one. Now you tell me, in Shivaji movie, Rajni sir Shivaji movie, Shivaji sir deposited some crores of rupees to the local person, and this fellow gave message to his friend in USA. Now rupees got converted into dollars. Will that fellow come under authorized person? No, that is illegal transaction. Getting my point? Every foreign transaction should happen only through authorized persons. Because of this, transparency will be there, everything will be reported, and how much foreign exchange reserves we are having, every second we can count it. That's it. Capital account transaction means a transaction that alters assets or liabilities outside India of a resident in India, assets or liabilities in India of a person resident outside India. Remember, capital account transaction. Sorry, listen carefully. Capital account transaction. CAT. CUT. CAT means capital account transaction. CUT means current account transaction. So what is a CAT? A transaction which is affecting net worth of resident outside India, or net worth of non-resident in India. Observe carefully. Residents' net worth outside India, non-residents' net worth in India. Any transaction affecting the net worth, we call it as capital account transaction. But net worth means generally net worth means what comes in net worth, You tell me. Generally net worth means assets minus liabilities, correct? But coming to the resident, assets minus liabilities minus contingent liabilities. Asset minus liabilities minus contingent liabilities. For non-resident only, asset minus liabilities. Asset minus liability. Any transaction affecting residents' net worth outside India or any transaction affecting non-residents' net worth in India, we call it as capital account transaction. Now listen to me. Suppose I'm a resident. I bought one villa in Chennai. Is this a capital account transaction under FEMA? No. Why? Because my net worth outside India, there is no change at all. Suppose I bought 1 million property in California, that is outside India. Who am I? Resident. Property outside India. Is it a capital account transaction? Yes. For purchasing that property, 80% I took loan from a Standard Chartered Bank, which is also located outside India. Now that loan amount, is it a capital account transaction? Yes. Purchase of property outside India by resident, taking a loan outside India by a resident, both are capital account transactions only. Similarly, Trump sir buying one villa in Chennai. Trump sir to finance that purchase, taking some 70% finance from SBI. Both transactions are also treated as capital account transactions. But the difference point, if you observe the difference is contingent liability. This contingent liability is only for resident, not for non-resident. Why? Because you all know the prudence concept, right? What prudence concept is telling? Anticipate all future losses, but don't anticipate future gains. Correct? From India point of view, contingent liability, I'm telling example. My friend is there in California. He applied for a loan. My friend, who is my friend? Non-resident. He is taking loan from a bank in California. Is it a capital account transaction? No. Why? Non-resident's net worth, there is no change in India. Non-resident's net worth is getting affected outside India. Now loan by my friend is not a capital account transaction, but I am giving guarantee. What I am doing? I am giving guarantee. That means tomorrow if that fellow fails to pay that amount, who is liable? I am liable. Now what is that liability to me? Contingent liability. Now giving guarantee is also a capital account transaction. Yes. But reverse is not possible. Why reverse is not possible? Say for example, my friend non-resident outside India. I am taking loan from SBI. Who am I? Resident. Taking loan from SBI. Transaction in India. Is it a capital account transaction? No. And my friend is giving guarantee, right? To my friend, this is a contingent liability. To that person, contingent liability. SBI point of view, if you observe, SBI point of view, that is a contingent asset. Yes or no? Tomorrow if I fail to pay amount, SBI collect amount from that fellow. That means SBI point of view, what is that amount? Contingent asset. What prudence concept is telling? Anticipate all future losses, but don't anticipate future liabilities. Anticipate future losses, but don't anticipate future profits. So when we are not considering future profits, contingent asset will not be identified here. Are you getting my point? See, for me, contingent liability means that country's contingent asset. For that country, contingent liability means for our Indian country, it is a contingent asset. But prudence concept is telling recognize liabilities, but don't recognize future assets. That's why here you will not find contingent liability. That is the logic actually. Now I think you can remember this definition. Assets liabilities including contingent liability outside India of resident. Assets liabilities in India of a non-resident. Simply Donald Trump net worth in India and Modi sir net worth in USA. Over Modi sir's net worth in USA, Trump sir's net worth in India. If any transaction affecting these two things, we call it as capital account transaction. Can I proceed? Currency, simple definition, give one time reading. Currency includes currency notes, postal notes, money orders, checks, drafts, traveler check, letter of credit, bills of exchange, promissory notes, credit cards, other notified instruments by RBI. Inclusive definition. Currency notes means and includes cash in the form of coins and bank notes. Today 10 rupee coin is there, 20 rupee coin is also there. That is also currency note only. Current account transaction. In mathematics, I think we had a concept called mutually and exclusive probability. Mutually and exclusive. That means if suppose I'm flipping a coin. If head comes, that means tail will not come. If tail comes, head will not come. Mutually and exclusive events. Getting my point? Similarly, capital account transaction and current account transactions are mutually exclusive transaction. If a transaction is capital account, it will be never a current account. If it is a current account, it will be never a capital account. Like partly capital, partly current. That concept is not there. So current account transaction means any transaction other than capital account transaction, including 4 items. What are the 4 items? Payments for foreign trade services, banking and credit facilities. This is nothing but imports, exports, and short-term banking facilities. Short-term banking facilities. Banking and credit facilities. This is short-term. This is short-term. Interest on loans and investments income. Remittances for living expenses of family abroad. Expenses for foreign travel, education and medical care. My B point if you see. I invested $1 million in Microsoft company shares or Tesla company shares. Now that investment, asset, not an asset. Therefore, it is a capital account transaction. But every year they are paying dividends. That dividend is current account transaction. Investment is capital account, whereas dividend is current account. Suppose I took a loan from World Bank and I'm paying interest. Loan is capital account transaction, but interest is current account transaction. And C point, remittances for living expenses. If I remit living expenses, any asset created outside India? No. Any liability outside India? No. So not a capital account transaction. Expenses for foreign travel, education, medical care. Any asset created outside India? No. Therefore, it is not a capital asset. Current account transaction means capital asset. I am telling a capital account transaction. Any confusion? Capital account transaction means residents' net worth outside India is getting affected, or non-residents' net worth in India getting affected. Residents' net worth, 3 components: assets, liabilities, contingent liabilities. Non-residents' net worth in India, only 2 components: assets, liabilities. Any transaction other than capital account transaction is current account transaction. And 4 transactions are known as current account transactions only. 4 specifically they declared. 4 are current account. Which 4? Last onwards: foreign travel, education, medical care. Next one, living expenses abroad. And next one, incomes, regular incomes, interest expenditure, income on investments, interest on loans. And first one, to finance imports and exports. And next one, short-term banking facilities. Small example, one small question only. In examination, definitely they will ask this. Reliance Industry Limited. In their factory, one plant and machinery was severely damaged, and this plant and machinery is available only in Russia. So it is some $1 million. So Reliance Industry Limited, from SBI they took a loan. $1 million means $10 lakh into 90 rupees, 9 crores. Reliance Industry took 9 crores loan from SBI and transferred that amount to Russian supplier. Russian supplier supplied this machine, this plant and machine. Russian supplier supplied to us. Now 2 transactions are there: purchase of plant and machinery, loan. Now tell me, which transaction is capital account, which transaction is current account? Loan from SBI 9 crores. Is it capital account or current account? First of all, FEMA is not applicable. Because this is a domestic transaction. Now purchase of plant and machinery, you tell me, is it a capital account transaction or current account transaction? Capital or current? Tell me. Current account transaction. Why? When I purchase plant and machinery, that plant and machinery will be installed in India. What I told, residents' net worth outside India should be affected. When I am buying an asset, if it is coming to India, my net worth outside India remains same only. So don't get confused between capital expenditure and capital account transaction. Capital expenditure need not be capital account transaction. It may become capital account transaction if asset was created outside India. Getting my point? Suppose I got this $1 million not from SBI. I got this $1 million from London Bank, for example, London Bank. And this loan is just for 3 months only. Now this 3 months loan, is it a capital account transaction or current account transaction? Current account transaction. Why? Because short-term banking facilities, short-term finance, I clearly told under current account transaction. Observe carefully. Banking and credit facilities. Getting my point? Suppose this loan is not for 3 months. This loan is for 10 years. Now short-term finance or long-term finance? Long-term finance. Definitely now it is a capital account transaction. Are you all getting my point? Everyone. One last time. What is a capital account transaction? Any transaction altering residence net worth outside India, non-residence net worth in India is a capital account transaction. Residence net worth three components: assets, liabilities, contingent liabilities. Non-residence net worth two components: assets, liabilities. Now any transaction other than capital account transaction is current account transaction, but four transactions specifically current account. Four: imports, exports, short-term finance, credit facilities. Next one, living expenses abroad, foreign travel, medical care. Next one, incomes, interest loans, dividend income, interest expenditure. Four are current account only. Now purchase of import of plant and machinery is a current account transaction because my net worth is not getting affected because of that purchase. Suppose to finance this purchase, if I take long term loan outside India, now it becomes capital account transaction. Which one? Purchase of plant and machinery or loan amount? Loan amount. Can I? Now timely I'm repaying the loan ma. Timely I'm paying the loan. And in my payment, two components are there: interest component to principal component. Listen carefully. Interest component to principal component. Now interest component, is it current account or capital account? Current account, because of payment of interest, my loan outstanding balance, there is no change. But payment of principal component, my principal is coming down, my outstanding loan amount is coming down, it is a capital account transaction. Can I proceed? Over. Capital account, current account identification, distinction completed. Next one ma. Foreign currency means very simple definition: any currency other than Indian currency. Foreign exchange, important. Foreign exchange. DCB, deposits, credits, balances payable or receivable in foreign currency. Foreign exchange is equal to foreign currency. First, one component is there. Majority of students, they started, I have seen certified copies, what they wrote is foreign exchange includes, directly they started writing ABC points, and they didn't wrote foreign exchange means foreign currency. 1 mark katma. Foreign exchange is equal to foreign currency and includes deposits, credits, balances payable that are expressed in foreign currency. And also you will see next one, drafts, traveler checks, letter of credit, bills of exchange expressed drawn in Indian currency, payable in foreign currency. So here I will write like this: demand draft, traveler check, bills of exchange. Namesake I wrote 3: demand draft, traveler check, bills of exchange. Drawn in Indian currency, payable in foreign currency. Now also it is a foreign exchange. Next one, drawn outside India, but payable in rupees, payable in Indian currency, then also it is foreign exchange. Total in foreign exchange, how many components are there ma? 4 components. 1, 2, 3, 4. Any one component missed, 1 mark cut only. 1 or half mark will be cut. Getting my point? Demand drafts, traveler check, bills of exchange. Drawn in rupees, payable in foreign currency. Don't write like drawn in rupees. Drawn in Indian currency, payable in foreign currency. Generally, students think ulta, they need to write drawn in foreign currency, payable in Indian currency. Don't write like that. Drawn outside India, but payable in Indian currency. Like that you have to remember. So what is a foreign exchange? Foreign exchange is equal to foreign currency. Deposits, credits, balance payable expressed in foreign currency. Next one, demand drafts, traveler check, bills of exchange drawn in Indian currency, payable in foreign currency. Drawn outside India, payable in Indian currency. That's it. Foreign exchange over. Next, another wonderful definition: foreign security. Foreign security, important condition. Foreign security, it should not be a it should be denominated in foreign currency ma. Foreign security, the face value should be denominated in foreign currency. So when a security is called foreign currency, face value compulsory it should be denominated in foreign currency only. Like Microsoft share $5, foreign security. Suppose sir, Infosys share 1300 rupees, that share is available outside India also sir. Now will it become foreign security? No, share should be compulsorily denoted in foreign currency only. And next one, face value may be in dollars, whereas redemption value or returns can be in Indian rupees also. Two components, face value, redemption value in foreign currency, or face value should be in foreign currency, whereas every year returns like dividends, interest, and at the time of maturity redemption amount, that can be in rupees, but still it is a foreign security only. Just look at the definition once. It must be denominated in foreign currency, including securities denominated in foreign currency, but returns, maybe interest or dividends, are payable in Indian currency. Getting my point, everyone? Next one, person. Simple definition: person, individuals, HUF, company, firm, association, artificial juridical persons. Up to here it is common, even in Income Tax Act also up to here it is common, but in FEMA this point is extra. BOA, controlled by such persons. Branches, offices, agencies controlled by above mentioned persons, they will also be treated as persons. Can I continue? Here comes most important definition: residential status. Person resident in India. 11th one is very simple, who is PROI other than PRI? Transfer includes sale, purchase, exchange, mortgage, pledge, gift, loan, any other form of the title transfer. Ignore. Now the last definition and the most important definition: resident in India. I'll write it. If you want, you can copy it. Is PRII. Two categories, individual, nothing but natural person, and others means, company, artificial juridical person. Others means artificial persons. Body corporate, simply body corporates. Individuals, general rule, period of stay should be greater than 182 days in the preceding financial year. Just look at the screen. More than 182 days, that means what? Greater than 182 days in which year? In the preceding financial year. Right now we are in which financial year? 26-27. For 26-27, am I resident or non-resident? For that I need to check preceding financial year 25-26. In the preceding financial year 25-26, if my period of stay is greater than 182 days, suppose my stay is 200 days. Now current year I'll be resident. Clear? How to calculate? If you have passport, when you entered into the country, when you left the country, between these 2 dates you can calculate. So if it is more than 182 days in the preceding financial year, you will be treated as resident. Can I proceed? But to this general rule we had exception. Sir, what is that exception, sir? What is that exception? First one, if any person leaving India for the purpose of employment outside India, business or occasion outside India, or intention to stay abroad of uncertain period. What is the period? Uncertain period. Intention to stay abroad for uncertain period. Because any one of these three reasons, if you are leaving India, from the date you leave India, your residential status will be lost. That means when you are leaving, suppose today you are leaving, till today you will be resident. Tomorrow onwards you will be not treated as resident. Are you all getting my point? Now what is the general rule? Come on. What is the general rule? Period of stay in the preceding financial year is greater than 182 days. It's not at least, it's greater than. They will confuse you by giving exactly 182. Exactly 182 non-resident. Greater than 182 days, I'll be called resident. But if I am leaving India for the purpose of job outside India, job or employment, business or vocation outside India, or intention to stay outside India for uncertain period, from the day I leave this country, I lose my residential status. Everyone. Suppose my period of stay in the preceding financial year is 365 days. For the current year, I'll be resident. And today, I'm going to Malaysia. Why? Tourism. My purpose is tourism. After 20 days, I'll come back. Now, during these 20 days, the period of stay in Malaysia, am I resident or non-resident? Resident only. There is no change in the status. Resident only. Suppose I got employment offer in USA. For that purpose, I'm going to USA. So immediately the next day onwards, I'll be treated as non-resident. So simply, general rule is not applicable in the three cases. Even though you are living more than 182 days in the preceding financial year, but if you are leaving India for employment outside India, or business or vocation outside India, or intention to stay outside India for uncertain period, you'll be treated as non-resident. Clear? Again, to this exception, we had one more exception. Now you tell me, exception to exception, general rule is applicable? Applicable. Generally, general rule is applicable. But here general rule is also not applicable. So simply just wait. Yeah. So here I will tell excludes. Next, includes. Any person coming to India for the purpose of employment in India, business in India. Next one, intention to stay in India. Is for uncertain period. Person coming to India for the purpose of employment in India, business in India, intention to stay in India for uncertain period, he will also be treated as resident from the date he entered into the India. For that fellow, you should not check period of stay in the preceding financial year. Getting my point? Sima, small difference. You have to understand small difference. Period of stay in the preceding financial year more than 182 days, you need to check. Generally, you need to check. But you should not check in two cases. In two cases, you should not check. Case 1, any person leaving India for 3 reasons. Any of the 3 reasons. At the same time, any person coming to India for these 3 reasons. In these 2 cases, general rule more than 182 days will not apply. Getting my point? Suppose a Malaysian citizen coming to India for tourism purpose. Malaysian person coming to India for tourism purpose. Now you can apply general rule. Suppose he is coming to India for employment in India. Now don't check general rule. Clear? Logic is very simple, See, I got a job in USA, I'm going to USA. Because of my period of stay in the preceding financial year is 365 days, if you call me resident throughout the current year, if you call me resident, when I'm entering into contract with a non-resident, every time I need to report to RBI. It's a harassment only for me. Getting my point? Suppose I'm Sri Lankan citizen, came to India for job. Now if you tell that I'm a non-resident, if I enter into contract with any resident, that fellow has to communicate with the RBI. That is also harassment only. So these 2 cases, don't check period of stay in the preceding financial year. That is the logic. Okay na, everyone? Next, any person residing in India for more than 182 days during the course of preceding financial year but does not include following: person who has gone out of India or who stays outside India. In either case, employment outside India, business or vocation outside India, intention to stay outside India for uncertain period. Excluded. Next one, a person who comes to or stays in India in either of the following cases. Otherwise than, observe carefully, otherwise than. For taking up employment in India, business or vocation in India, intention to stay in India for uncertain period, then that fellow becomes these persons becomes person resident in India. Any confusion? Any confusion? Resident going out for tourism purpose, resident only. Non-resident coming to India for tourism, non-resident only. Any person or body corporate registered incorporated in India, automatically resident only. Place of incorporation decides residential status for companies. This point observe. Office, branch, agency in India, either owned or controlled by person resident outside India, but still this is also person resident in India. That means you tell me all foreign companies are person resident in India only. Branch, office, agency in India. It might be controlled by a foreigner, but still this person is also resident only. Which person? Branch, office, agency. D point ma. On D point 2 times practical question came. Read this D point. Office, branch, agency outside India owned or controlled by a person resident in India, then that branch, office, agency outside India is also treated as resident. One practical question. Yeah. For example, Singapore company located in Singapore, having two branches. One is in Mumbai, other one is in Dubai. Other one is in Dubai. In both the branches, 100% ownership is with Singapore company only. Singapore company is having 100% ownership. So both the branches are owned by Singapore head office. Clear? Everyone? Now out of these three entities, you tell me which one is a resident, which one is a person resident in India. Tell me which one. Which one is a person resident in India and which one is a person resident outside India? Singapore company definitely person resident outside India because incorporation happened outside India. Mumbai branch, India because it was in India. Dubai branch, outside India only. Suppose Dubai branch operations are controlled by Mumbai branch. Dubai branch operations are controlled by Mumbai branch. And 100% is controlled by, 100% is owned by Singapore branch, Singapore head office. Listen carefully. Singapore head office is having 100% ownership in Dubai branch. Whereas Dubai branch operations are controlled by Mumbai branch. Now you tell me whether Dubai branch is person resident in India or not. PRI or PROI? Tell me. PRI or PROI? PR, and the answer is PRI. Because if you look at the point one more time, branch, office, agency located outside India, either owned or controlled. Not telling owned and controlled. They're telling owned or controlled. Either owned or controlled by person resident in India, then that branch office which was located outside India also becomes person resident in India only. So now Dubai branch is person resident in India. One time, I think very recently, 2025 only, one time this point was tested. So total PRII. Two branches, individual, others. In others, you can see company, you can see BOA. For companies, place of incorporation. For companies, place of incorporation. For BOA, place of business. Place of business. If place of business in India, obviously PRII. Suppose BOA outside India, branch, offices, agencies outside India, but if it is owned or controlled by PRII, then definitely it is also PRII only. Getting my point? Everyone? Next, for individual, you need to check residential status, POS, greater than 182 days. Tell me 182 days, which year I need to check? Preceding financial year. Two cases, no need to check. In two cases, no need to check. Excludes job outside India, business or vocation outside India, uncertain period, intention to stay outside India for uncertain period, obviously excluded. And include any person coming to India for job, business or vocation to stay in India for uncertain period. Okay, now everyone. One more small story. Priya, mother of Pooja. Preceding financial year 25-26, their period of stay, both people period of stay is 365 days. Now with respect to 26-27, we need to check 26-27. 1st May 2026, Pooja married NRA and left India exactly 1st May 2026. Now what is Pooja's status for financial year 26-27? So for April month, remember residential status you need to check every day. For April month she is resident, but from May month onwards she becomes non-resident. And after going to USA, she fell sick, and to take care of Pooja, Priya also went to USA just for 2 months only, not for uncertain period. Now what is the residential status of Priya? Is there any change? No change. Priya is resident only. Pooja is non-resident because after marriage going to USA means intention to stay outside India is uncertain period. Everyone understood? Okay, fine. So if at all you can mark, D point, you mark it, D point. BOA outside India, owned or controlled by Indian branch, then it is also resident only. Fine. Residential status over. And just give one time reading. Citizenship is not a criteria for determining residency under FEMA. Residential status is determined from a specific date, unlike Income Tax Act, which considers full year. In Income Tax Act, full year you may be resident or non-resident. But coming to FEMA, up to one point of time you may be resident. After that point of time, non-resident. That means in a given financial year, you can have two statuses. One is residential status, other one is non-residential status. FEMA is a regulatory law requiring real-time determination of residential status for transactions. And just give one-time reading of these examples. You will understand. Okay, na? Next one. And you have to remember one more point. As per RBI rules, if a student is leaving India for higher studies outside India, then also he will be non-resident once he leave India. Actually in Act we had only 3 points. Employment, next business, intention to stay outside India, uncertain period. Where is study abroad? Not there. But as per rules, studies abroad also, during that period also you will be treated as non-resident only. Special cases, HUF, AOP, BOI. These entities cannot be employed or travel abroad, so exception clauses do not apply to them. If they are in India, they are considered PRII. Corporate entities, any company registered in India, automatically PRI. Branch outside India owned by PRI is a PRI to prevent FEMA violations. Branch in India owned by PRY is also PRI to facilitate business transactions. Can I proceed? Next, section 3, section 4. Observe differences between section 3 and section 4, ma. Section 3, section 4. If you see section 3, no person. If you see section 4, PRII. That means section 4 is talking expressly about resident. 4 is applicable only to the resident. Whereas section 3 is applicable to any person, maybe resident or non-resident. No confusion. Non-resident means PROI. Resident means PRII. Okay, now 3 is applicable to all persons. What is section 3? Dealing in foreign exchange, payments to non-resident, receiving payments from non-resident, entering into financial transactions in India to acquire, create, transfer assets outside India. And it starts with no. So no person shall deal with foreign exchange. No person shall make payments to the non-residents. No person shall receive payments from the non-residents, and no person shall enter into financial transactions for creation of foreign assets. But there is an exception. What is that exception? Exception is above transactions can be carried out if it is permitted under FEMA and with general or special permissions from RBI. And if you observe carefully, if they are permitted under FEMA, these transactions you can carry out through AD. AD means authorized dealer. Sorry, authorized person. Beginning first definition we have seen authorized person. all authorized dealers, money changers, offshore banking units. Getting my point? So you can carry these transactions only through authorized person, then only transparency record will be there. Are you all getting my point? So 4 transactions: dealing, making payments, receiving payments, and next one, entering into financial transactions to create foreign exchange. Allowed or not allowed? Not allowed. Not allowed. Financial transaction means making, receiving payments, issuing, drawing, negotiating bills of exchange, transferring securities, or acknowledging the debts. Simply all hawala transactions according to section 3. Legal or illegal? Illegal. In recent S3 movie also, villain is having Australian currency, one big suitcase, Australian currency. Now getting that suitcase money also illegal only. Next one, what is the purpose of section 3? Regulates inflow and outflow, ensure transactions are conducted through authorized dealers, applies to both resident as well as non-resident. Next is section 4. Resident cannot acquire, hold, own, possess, transfer foreign exchange, foreign security, immovable property abroad unless permitted under FEMA notifications. And one more difference you need to find out. 3 is applicable to all persons, 4 is applicable to residents. 3 is with respect to dealing with foreign currency, dealing in foreign exchange. Whereas 4 is holding foreign exchange. 4 is holding foreign exchange. Section 3 prevents you from dealing with foreign exchange. Section 4 prevents you from holding foreign exchange. If an Indian resident inherits US dollars 10,000 from his uncle in London, he must bring back the funds to India as per section 8. Can I proceed? Next, current account transactions. Just now I finished. What is current account transaction? Any transaction other than capital account transaction. But 4 items are current account transactions. Which 4 items? Imports, exports, banking facility, banking, credit facilities. Next one, incomes, interest expenditure. And next one, living expenses abroad. Next one, foreign travel, medical care, studies outside India. Okay. For current account transactions, CG is having power ma. For current account transactions, who is having power to frame rules? CG. Current account transactions are freely permitted unless prohibited. Capital account transactions are prohibited unless permitted. And remember these rules also. All current account transactions are freely permitted unless prohibited. And all capital account transactions are all capital account transactions are prohibited unless permitted. This example I already covered. Import of machinery. Capital account or current account? Current account. Because there is no change in net worth outside India of resident. Import on credit, you can see here 3 months credit period. This is short term, that's why this is still a current account transaction. Gift concept ma, tricky point, so far not tested. Gift, sir, gift capital account or current account? Question, super question. Listen carefully. Resident giving gift to non-resident. Resident giving gift to non-resident. This is obviously capital account transaction if that gift is still in India. Listen carefully. Modi sir, Trump sir. Modi sir is giving a gift of 1 crore rupees to Trump sir, and that 1 crore rupees is in the bank account of Trump sir in India only. Now Trump sir's net worth affected or not affected? Affected. His assets increased. So capital account. No sir, already transferred that money to Trump sir bank account sir. Now there is no change in net worth of Trump sir in India. It becomes a current account transaction. Getting my point? Ulta, reverse. Suppose non-resident is giving a gift to resident. Non-resident giving gift to resident. Same. My uncle gave me a gift of $10,000. Is it a capital account or current account? As per section 4. Section 4, just now I told you. No resident shall hold foreign currency. Definitely he should bring back that money to Indian economy. He should convert them into Indian rupees. So when my uncle is giving me a gift of $10,000, can I keep that money outside India? I should bring it to India. If I'm getting it to India, my net worth outside India, any change? No change. Automatically current account transaction. Automatically current account transaction. Sima, gift in Indian rupees from resident to non-resident creates Indian asset for non-resident making capital account transaction. Modi sir giving gift of 1 crore to Trump sir. Trump sir net worth in India is getting increased capital account transaction. Whereas Trump sir giving gift to Modi sir allowed. However, if the funds are given abroad, resident must repatriate them to India. Therefore, automatically it's a current account transaction only. Can you remember? Okay. Next. Restrictions imposed by central government in current account transactions. Yes, ma. We are having 3 schedules. In current account transactions, we are having how many schedules? 3 schedules. Cut 3 schedules. Schedule 1, Schedule 2, Schedule 3. Schedule 1 prohibited. Schedule 1 prohibited. Schedule 2 CG permitted current account transactions. That means Schedule 2 transactions are allowed, but you have to take prior permission from CG. And Schedule 3 RBI permitted current account transactions. RBI permitted current account transaction. Sir, if any current account transaction not given in Schedule 1, Schedule 2, Schedule 3, is it permissible or prohibited? Listen to my statement carefully. We are having 3 schedules: prohibited, CG permitted, RBI permitted. If any current account transaction not mentioned in Schedule 1, Schedule 2, Schedule 3, is it allowed or prohibited? Allowed. Why? Because general rule just now we see all current account transactions are freely permitted except prohibited. So if any transaction not mentioned in Schedule 1, Schedule 2, Schedule 3 is freely permitted. Getting my point? Everyone. Now let's see one by one. In Schedule 3, you will find LRS concept, liberalized remittance scheme, up to how much? 2.5 lakh USD. And this LRS concept is not applicable to all the persons. It is applicable only to the individuals. It is not applicable to companies. It is not applicable to branches, offices, agencies. It is applicable only to the individuals. Can I proceed? Everyone? Yeah. First, Schedule 1 prohibited transactions. I don't know what you will do. You have to mug up all these points. You have to mug up because they will give one item and they will tell whether permitted or prohibited. You have to remember this. Before I start this, let me tell you one more time. Let me tell you one time. These are not illegal transactions. These are not illegal transactions. But withdrawal of foreign exchange for carrying these transactions is prohibited. Getting my point? These are legal transactions only. But to carry these transactions, withdrawal of foreign exchange is prohibited. Sir, what are the transactions? Remittances out of lottery winnings. A non-resident won lottery in India. Can he take back money in foreign currency? No. We can't pay foreign currency to the lottery winner. Remittances of income from racing, riding, etc. or any other hobby. Remittances for purchase of lottery ticket. This time, resident want to purchase lottery ticket outside India. For purchase of ticket outside India, withdrawal of foreign currency allowed or not allowed? Not allowed. Also, some banned prescribed magazines, football pools, sweepstakes. For this, withdrawal of foreign currency not allowed. Simple logic, ma. If this list is not there, if everyone start drawing foreign currency, ultimately one day our foreign exchange reserves will become zero. We can't finance our imports. Okay, na? First 3, ma. First 2 is about winnings. Third one is about purchase of tickets. First 2, non-resident is winning the games. Third one, resident want to purchase ticket outside India, not allowed. Fourth one, commissions. Super point, commissions. Yeah. Exports, commission on exports, ma. Commission on exports. These are 3 categories. Third category, others. Allowed. Not prohibited, allowed. 2 are prohibited. Which 2? Exports made to finance subsidiary or joint venture abroad. Exports made to finance subsidiary or joint ventures abroad. Listen carefully. Reliance Industry Limited exported crude oil, exported some petroleum and diesel to for example to Australia, for example Australia. The contract value is, for example, $1 billion. And the fellow, the broker who brought this transaction, to him we need to pay commission, generally 2%, 2% of $1 million. But Reliance is not taking this money. Instead of getting this money, what, it told to Australian government, to finance a company, C Limited, which is a subsidiary of Reliance Industry Limited. Getting my point? What is the contract amount? $1 billion. That means 100 crore dollars. 2% commission means $2 crore we need to pay commission. Here, withdrawal of foreign exchange for payment of commission to this broker is prohibited. Why? Our Indian economy is not getting 100 crore dollars. First of all, the export you made, correct, you created turnover, but it is not coming to Indian economy. That amount you are utilizing to finance your subsidiary or joint ventures outside India. So Indian economy is already at zero, because of this transaction Indian economy is getting zero. If you want to withdraw $2 crore means again it is lost to our foreign exchange reserves. Getting my point? So commission on exports that are made to finance subsidiaries or joint ventures outside India, commission withdrawal is prohibited. And exports made under rupee state credit route, India and Russia both are friendly countries. Between India and Russia there is a one agreement. According to that agreement, India will sell all its goods, agriculture goods to Russia, and India will purchase defense items. The settlement of this transaction will happen in rupees only, not in dollars, in rupees only. Now we are exporting some items to the Russia, for which we get dollars or rupees only. Now the broker who brought this contract, we need to pay commission, right? Can we pay commission in foreign currency? And the answer is no, not allowed, prohibited. Why? Because we are not getting any dollars. Clear? But there is an exception. Oh my God, exception. Exception is for tea and tobacco. Remember, for tea and tobacco, 10% of invoice value, up to 10% of invoice value, withdrawal of foreign currencies, withdrawal of foreign exchange is allowed for tea and tobacco, because we are very big manufacturers in tea and tobacco. We are having bulk quantities. Even if you export them under rupee state credit route, for payment of commission up to 10%, withdrawal of foreign exchange is allowed. 2 points over, 2 points over. Observe carefully. Payment of commission on exports made towards equity investment in joint ventures, wholly owned subsidiaries outside India, prohibited. Next one, payment of commission on exports under rupee state credit route, except, already these are prohibited, again except, that means permitted, except commission up to 10% of invoice value of exports of tea and tobacco. Can you remember? This is very important point. I think 1 year back this point was tested. Next one, remittances of dividend by any company to which requirement of dividend balancing is applicable. Suppose Kia company, South Korean company, opened one plant in India, Kia India. In a year it manufactured some 3 lakh cars. How many cars it manufactured? 3 lakh cars. Out of 3 lakh, 1.8 lakh cars were sold in India. 1.8 lakh sold in India, and 1.2 lakh cars were sold in for example USA, outside India. Now company got profits. How much profits? From India, company got a profit of, for example, 30 crores, and from USA business, company got profit of 20 crores. When the subsidiary company Kia wants to pay dividends to South Korean Kia company, for this withdrawal of foreign currency allowed to the extent of this 20 crores only, not to this 30 crores. Why? This 30 crores profit you got from Indian business, it is not in dollars, whereas this 20 crores profit you got because of doing business in USA, that means that is available in the form of foreign currency. Are you all getting my point? This is freely permitted, whereas this is prohibited, where dividend balancing is applicable. Getting my point? Logic you understood? Next one, callback services, outdated point. For callback services, payment in foreign currency is also prohibited. And last one, remittance of interest income on funds held in non-resident special rupee scheme account. Suppose Trump sir having one daughter, Ivanka Trump. Madam want to explore India. That's why madam decided to come to India. Madam is having dollars. Is dollar a legal tender money in India? No. So whatever money she brought, it was deposited in special rupee scheme account. It was deposited in special rupee scheme account. For example, $1 million. $1 million. From that account, she can use the money. But since madam is a celebrity, our governments incurred all the expenditures with respect to madam. 1 year over. After 1 year, madam decided to go back to USA. So when she decided to go back to USA, the amount that was deposited in this non-resident special rupee scheme was increased because of interest. Whenever you deposit amount in bank account, interest will be added, right? So adding that interest, if you want to withdraw that money, you can withdraw only the amount you invested. Interest amount you can't withdraw in foreign exchange. Here only interest amount they are telling, not deposited amount. Interest income only not allowed. Understood, everyone? So remember prohibited current account transactions. First one, remittances of lottery winnings, remittances of horse race winnings. One is lottery, horse race. Purchase of tickets outside India. Next, exports 2 points commission on exports 2 points. One is financing subsidiary, equity investment in subsidiary joint venture outside India. Other one is rupee state credit. But rupee state credit had one exception. If you are exporting tea and tobacco under rupee state credit route, you can still withdraw foreign exchange to pay commission up to 10% of the invoice value. Over. 5 points over. Next, callback services not allowed. Dividend balancing not allowed. And next one, non-resident special rupees scheme account. Over. 8 points you have to mug up. That's it. Next, schedule 2, transactions requiring prior approval of CG. In this, this advertisement point and prize money. Advertisement to prize money. These are very, very important. Advertisement, prize money, very, very important. And one more point is there. That is also with the limits only. We'll see one by one. For cultural tours, even if you want to withdraw single dollar, how much? A single dollar also, you have to take prior permission from Ministry of Human Resources Development. For advertisement, the diagram will be like this. The structure will be like this. Advertisement in which media is matter? Print media, other media, audio visual means. For others, no permission required. Print media. Now you need to check who is incurring this expenditure. Sir, PSU, state government. Advertisement in foreign print media by the state government and PSU. Yes, who is incurring this expenditure is important. State government, PSU. Others. For others, ignore. Permissions not required. State government, PSU incurring advertisement expenditure in print media. What is the purpose? Sir, promoting trade. You can see here the purpose. Purpose is promotion of tourism, foreign investments, international bidding. 3 points. 3 points. Promoting tourism. Next one, international bidding. Next one, international bidding and foreign investments. If the purpose is tourism, international bidding, international investments, foreign bidding, then also permission not required. Other than these 3 purposes, now you need to check how much amount they are spending. What is the limit? 10,000, exceeding 10,000. If the amount spent is greater than $10,000, permission is required. If it is less than $10,000, permission not required. Let me read it. Advertisement, okay. Advertisement in which media? Foreign print media by the state government or public sector undertaking, other than tourism, foreign bidding and international investments, exceeding $10,000, permission is required. This classification you need to understand. This combination you need to understand. Advertisement in foreign print media by PSU or state governments, Purpose other than tourism, international bidding, foreign investments, exceeding $15,000, sorry, exceeding $10,000. Total five elements you have to remember. Then only permission is required. Other cases, permission not required. Can I proceed? Permission is to be taken from Ministry of Finance, Department of Economic Affairs. Next one, remittances of freight of vessel chartered by PSU. Tell me here, who is the payer, ma? Here, who is the payer? You can see any point, ma. Here, payer can be any person. Limit can be any dollar. Single dollar also permission required. And here, who is the payer? PSU, state government. Here, who is the payer? PSU. And what payment they are making? Freight. Generally, freight paid to domestic vessels, rupees is enough. Freight paid to foreign vessels, foreign currency is required. Why you are going with foreign vessels? So like that, clarification to be given to the Ministry of Surface Transport. If they give permission, you can withdraw foreign currency. Payment of import through ocean transport by a government department. Here also, who is the payer? State government to PSU. If these people are making payment on CIF basis, cost to insurance freight basis, then also Ministry of Surface Transport. Multimodal transport operators making remittance to their agents abroad. Multimodal transport operators. Multimodal means, airways, waterways, roadways, railways, everything is covered. Sima, today if you want to book a ticket, movie ticket, you will use Book My Show, you will use Paytm, and the theaters will pay commission to these agencies. Similarly, if you want to book a ticket, Make My Trip, Paytm applications are there. If you want to pay commission, website commission, for that also, registration certificate from Director General of Shipping, if they have it, you can make payment, or else you can't make payment. Remittance of hiring charges of transponders by TV channels, internet service providers. Last edition World Cup happened in India only. In 2024, I think World Cup happened outside India, West Indies. The telecast, live telecast, the rights are with some foreign channel. Best example, Netflix or National Geographic channel you take. They are recording everything. But to get those rights, we need to make payments, right? For making such payments, Ministry of Information and Broadcasting permission is to be taken. Okay, na? Broadcasting rights. Next one, container detention charges up to prescribed rate, no problem, ma. Exceeding prescribed rate, container detention charges. Right now because of Iran-Israel war, all the containers that should come to India were parked somewhere near to the Iran or some Gulf countries ports. So parking means definitely parking charges will be there, right? Detention charges. Up to one limit, no permissions required. Exceeding the limit, Ministry of Surface Transport permission is to be taken. Prize money, amma. Prize money. Observe carefully. If this prize money is paid by international, national, state level sports body, permissions not required. Who must be the payer? Here the payer is other than ICC, International Cricket Council, and national, that means BCCI, state level, for example, Tamil Nadu Cricket Academy, state level, national level, international level. If these people are making payments in foreign currency, for which withdrawal, no need of permissions. But by a person other than these people, exceeding $1 lakh, how much? What is the limit? Greater than $1 lakh, permission is to be taken. That means up to $1 lakh, permission not required. Example, IPL team only we will take. Kingfisher, sorry, RCB. Once upon a time, this team belongs to Vijay Mallya sir. Do you remember Vijay Mallya sir? Suppose Vijay Mallya sir want to pay some winning prize money to a team of I think Australian cricket. It's Big Bash League, BBL, something, some name is there. Didn't remember the name. Okay, fine. Vijay Mallya sir decided to give prize money of $1,10,000 to the winner of Australian Cricket Premier League. Now who is making payment? ICC, BCCI, Tamil Nadu Cricket Academy? No. Other than these people, how much amount they are making payment? More than $1 lakh. Permission is to be taken from Ministry of Human Resource Development. Both prize money as well as sponsorship. Remittances for membership of P&I club, Ministry of Finance, Insurance Division is enough. Can I proceed? Next one, Schedule 3, permitted transactions. Schedule 3, permitted transactions. Individuals can avail foreign exchange facility for the following purposes up to USD 2,50,000. You know what are the purposes? Private visits to any country except Nepal and Bhutan. Except Nepal and Bhutan means this is also prohibited only. Hidden prohibited transaction. If you want to travel to country Nepal and Bhutan, for this withdrawal of foreign exchange, allowed or not allowed? Not allowed. Any other country? Allowed. Gift to donation allowed, going abroad for employment allowed, immigration allowed, maintenance of close relatives abroad allowed, travel for business, attending a conference or specialized training for meeting expenses, meeting medical expenses, checkup abroad, accompanying a attendant. That means patient is there, compounder also, for example. Patient attendant, for example. Going abroad for medical treatment checkup, here also no problem. Expenses in connection with medical treatment abroad, no problem. Studies abroad, only abroad is there in your material, just write studies. H point, also write studies. Any other current account transaction, but remember, immigration, next studies abroad, medical treatment abroad. Actually for all these, 9 items, what is the limit? $250,000 individually, consolidated, both individually 2.5 lakh, consolidated basis also 2.5 lakh. But in case of immigration, education outside India and medical treatment outside India, if you are having a proof like quotation, that university gave a quotation of $3 lakh, in that case RBI permission is not required. Show that letter, you can withdraw $3 lakh. What is this LRS? Under LRS no need to take any permission if you are withdrawing foreign exchange of up to 2.5 lakh, either for single transaction or for the series of transactions you are taking up, you are handling in that year, per annum. That is, the limit is per annum. Okay na? But for these three purposes, if you are having a valid proof, valid evidence, then you can even withdraw more than 2.5 lakh USD without any RBI permissions. LRS, individuals including minors can remit up to 2.5 lakh US dollars per financial year for both current account and capital account transactions. Not available to the corporates, firms, HUF trust. Why? Because if corporates are also having a benefit of this, I'll incorporate 20 bogus companies. Each company 2.5 lakh dollars means 20 companies into 2.5 lakh. I can withdraw 50 lakh dollars. Again, foreign exchange reserves will come down. So that's why LRS limit is only for individuals, not for others. For person resident but not permanently in India. A person is resident but not permanent. That means a US citizen. Now I remembered one question. I'll ask you, just wait. A US citizen, US employee, for example, Sundar Pichai sir, for example, he's a non-resident only. But he came to India to look after these operations. They want to set up Google in Andhra Pradesh, in the India they want to set up. So to look after these operations, he is coming to India. And his period of stay would be some 2 years, for example, 2 years. That is nothing but less than 3 years. Remember the point, does not exceed 3 years. So it is less than 3 years. Now Sundar Pichai sir will be treated as resident but not permanent resident. Temporarily he is coming to India. Imagine his salary in India is 10 million, $1 million. $1 million means how much? $10 lakh. $10 lakh. TDS, PF, etc. Some $2 lakh deduction is there. Now what is the take home salary? It's $8 lakh. How much is the take home salary? $8 lakh. Now he can send this amount without any limits. Actually under LRS, what is the limit? $2.5 lakh. How much amount is having? $8 lakh. Can he send complete amount without complying LRS rules? Yes. This point is important. See, citizen of foreign states except Pakistan, Indian citizens on deputation abroad can remit up to their net salary. Net salary means gross minus tax and PF deductions. And for this schedule, a resident on account of his employment or deputation of a specified duration or for a specific job or assignment, the duration should not cross 3 years. Not permanently resident. One more time. Last time. An individual can remit maximum how much in foreign currency? $2.5 lakh. But if he is a resident but not permanent resident and drawing a salary in excess of 2.5 lakh dollars, 2.5 lakh dollars, can he remit complete amount without complying LRS rules? Yes. Whatever net salary is having, he can remit complete amount. There is no restriction. Next one, for entities. For entities, 4 points are there. Entities means other than individuals. LRS 2.5 lakh dollars is only for individuals. Okay, na? Okay. This is not LRS but similar. That means up to these amounts, permissions not required. Exceeding these amounts, permission is required. For donations, for donation, 1% of foreign exchange earnings. How many years? 3 years. 3 financial years. How much you earn on that, multiply with 1% or $5 million, whichever is lower. Oh my god, A point you have to fix lower. Up to that limit, a company can make donations even without RBI approval. Getting my point? Sima, how many schedules are there with us? Schedule 1, 2, 3. 1 is prohibited. 2 is CG permitted. 3 is RBI permitted. We are in which schedule? Schedule 3, RBI permitted. Can I proceed? Yeah. So establishing chairs in reputed educational institutions, contributing to the funds set up by educational institutions, contributing to technical institutions, bodies, associations related to the company field of activity. What is the permitted amount? Up to 1% of 3 years foreign exchange earnings or $5 million, whichever is higher or lower. Lower. Because for B point it is higher. For D point it is higher. That's why confusion. A point only lower. BD points higher only. A point lower, BD points higher. What is BD? Commission to the foreign agents. Which commission? Selling residential flats or commercial plots in India, commission per transaction cannot exceed 25,000 USD or 5% of inward remittance, whichever is higher. Suppose company is getting, Indian company is getting $1 million for sale of one flat to NRI. These NRI people will have, mothers, parents in India only. NRI purchasing one flat for their parents means payment will be in foreign currency only. How much inward remittance? $1 million into 5%. That means $50,000. How much it is? $50,000. $50,000 or $25,000, whichever is higher. Up to that limit, permission required or not required? Not required. Exceeding that limit, permission required. Next one, see, consultancy service remittances. Payment exceeding USD 10 millions per project for consultancy services related to infra projects. Example, a national highway, for example, Chennai to Bangalore connecting national highway. Regarding design, a design, foreign people are having, foreign engineers are having a design. Through that design, we can complete our construction very quickly. Now they are rendering that consultancy services. Services with respect to which project? Infra project. Now you can remit up to $10 million without permission. Sir, other than infra, you can remit $1 million. Other than infra projects, simply other consultancy services, you can remit how much? $1 million. Can I proceed? Reimbursement of pre-incorporation expenses, 5% of investment brought into India or 1 lakh USD, whichever is higher. For pre-incorporation expenses reimbursements, up to 5% or $1 lakh, whichever is higher. 4 points are there, What are the 4 points? Donations, commission on sale of properties. Next one, consultancy services, and last one is pre-incorporation expenses. First one is lower, 1% of 3 years foreign exchange earnings or $5 million. It's not $5 lakh, $5 million, whichever is lower. And second one is foreign agents, commission to foreign agents, 5% or $25,000, whichever is higher. Whereas for consultancy, infra 10 million, so other than infra 1 million. And pre-incorporation expenses, 5% of the investment brought into India or USD 1 lakh, whichever is higher. Up to these limits, no permission required. Above this limit, allowed with permissions. From RFC account, EFC accounts, if you want to withdraw foreign exchange, if you want to make payments, you can make payments. Suppose, Dubai students are buying my classes, for example. I'm getting foreign currency. I can use that money for schedule 2 transactions without any permissions because it is earned money. RFC is for resident. EFC is for business entities. So exchange earners foreign currency account. No approval required for Schedule 2, Schedule 3 transactions. Schedule 1 is already prohibited. That's why Schedule 1 no need to talk. Schedule 2, Schedule 3 from RFC freely permitted. For Schedule 2 no need to take permissions. I want to attend a cultural tour outside India and I'm having balance in RFC account. So for withdrawal of that amount, CG permission required or not required. EFC, remember 3 points ma. P&I club, commission to foreign agents, pre-incorporation expenses reimbursement above 5%. Commission to foreign agents above $25,000. For these 3 purposes, definitely you have to take prior approval from RBI. You know, these 2 RBI permission. First one is from CG. P&I club schedule 2. P&I club schedule 2. Whereas commission to foreign agents and pre-incorporation expenses reimbursement schedule 3. Can I proceed? And payment via international credit card is allowed for schedule 3 expenses. I think last attempt or yes, last attempt only. This point was tested ma. The point is limit of $2.5 lakh is there, right? Limit of $2.5 lakh. Is it individual limit or family as a whole limit or individual limit? Suppose husband and wife, 2 persons are there. 2 persons can withdraw how much? $5 lakh. Sir, husband want to withdraw $5 lakh for acquiring an asset outside India. Allowed? Generally not allowed. But if you want it, the property which they are acquiring outside India, that property should be registered in both the name of husband and wife. That means joint share, joint ownership. Family remittances can be consolidated, but capital account transactions must be in joint ownership. Joint ownership. For current account transactions, that limit is not there. For capital account transactions, if you want to withdraw and if you want consolidation, consolidation is allowed, but property should be owned by both. Minors can remit under LRS, but this guardian must sign the declaration form. Next one ma, capital account transactions. In this entire point, you know, 6th point, 7th point very important ma. Remaining, you know, it's all about RBI powers, CG powers ma. RBI powers is limited to debt instruments. CG powers is limited to equity instruments. Only you remember that point. See, capital account transactions not involving debt instruments. That means equity is taken care by CG. Debt instruments is taken care by RBI. That's simply distribution of powers between RBI and CG. Distribution of powers between CG and RBI. Okay, na? But here, you know, important points 5, 6, 7. For capital account transactions, particularly these 2 capital account transactions, there is no limit on, there is no limit, there is no restriction. There is no restriction, there is no limitations. For carrying these 2 capital account transactions, there is no restriction. Which 2 transactions? Loan amortization payments. I took foreign loan to finance foreign project. Now I want to repay that foreign loan. For that, withdrawal of foreign currency is allowed without any restrictions. And second one is depreciation of direct investments in normal business operations. Suppose I made investment in a Microsoft company. Microsoft company issued partly paid up shares. And I made a investment partly paid up. Now they are making call money. They're asking call money. They're making calls on shares. And that call amount is more than 2.5 lakh US dollars. So if I wait for RBI confirmation, if I ask RBI and RBI meanwhile, if it is making delay, definitely company will forfeit the shares. My investment will become 0. So is this a emergency matter or not an emergency matter? Emergency matter. So these kind of things doesn't require any permissions. 2 transactions, remember. Loan amortization payments, depreciation of direct investment in normal business operations. Both are allowed without any restrictions. Next one, section 6, subsection 4. Holding of foreign assets by resident. Mr. Sundar Pichai sir. Mr. Sundar, okay, Mr. Sundar. Who is he? Non-resident. He got some, you know, for example, 2000 crores remuneration from Google. When he was non-resident, he got that amount. With that amount, he purchased some assets. He was a non-resident and assets were located outside India. Now he decided to come back to India, to stay in India for uncertain period. Now what is the residential status of Sundar's? Resident. What about his foreign holdings? Why? Because what section 4 is telling? Resident should not hold foreign assets. Now, can he continue to hold those assets or not is this point, and the answer is a resident can hold, own, transfer, invest in foreign currency, securities, immovable property acquired when they were a resident outside India, assets inherited from a non-resident. He can continue to hold them, no need to sell them, no need to bring them to India. Next one, reverse non-resident, reverse resident. Suppose Mr. V, I earned some, for example, 1 crore in India. With that 1 crore, I purchased one villa in Chennai. Now I got a job offer in USA. I went to USA. Who am I? Non-resident. Non-resident. And I'm having Indian assets. Can I continue to hold them or should I sell them? The answer is I can continue to hold them. A non-resident can hold, own, transfer, invest Indian assets which were acquired when he was a resident or when he inherited them from a resident Indian. Getting my point? In one attempt, question came like this, for example, Pooja working in USA earned some $1 million. With this money, he bought one villa and he returned to India for uncertain period. After returning to India, what is the residential status of Pooja? Resident. Can she continue to hold that property which was located in USA? Yes. Yes. The question is, from this property, every month she is getting a rents. For example, $10,000. After 1 year, total $1,20,000. With that money, she bought another property. Now RBI permission, section 3, section 4 applicable or not applicable? Not applicable because she is not withdrawing any money from India. It was already accumulated outside India. That means assets inherited or assets you bought when you are a non-resident outside India. You can continue to hold them for those assets, for those properties, no restrictions. Next one, capital account transactions, 3 categories: permissible, no restrictions, prohibited. No restrictions, just now I told you, depreciation in investments, loan amortization. Permissible transactions, just give one time reading, enough, just give one time reading. These are resident, non-resident, no, these are two people, resident outside India, non-resident in India. Permissible capital account transactions. Next one is this already completed. Transactions with no restrictions already completed. Prohibited, important. Prohibited, important. First one, prohibition is on whom? You tell me. Prohibition is on whom? Just wait. Just 1 second, 1 second. Prohibited transactions. Let's see what is this. Resident cannot withdraw more than 2.5 lakh US dollars for financial year for capital transactions without RBI approval. Funds cannot be remitted to Financial Action Task Force listed non-cooperative countries. Non-cooperative countries, for example, Pakistan only. You can't transfer that money to Pakistan country. So this is normal thing only, normal thing. If you want to withdraw foreign currency, you can withdraw up to how much? 2.5 lakh USD. So simply Schedule 3 cut plus CAT. Both put together, the limit is 2.5 lakh USD per individual per financial year. Getting my point? That's it. Now let's see restrictions on non-resident. Non-resident. These 5 points about non-resident only. Prohibited capital account transactions. This is applicable only to the non-residents. What are those 5 points? Chit funds. A non-resident cannot invest in chit funds. But there is an exception. Exception means allowed or not allowed? Allowed. Allowed subject to approval of state government. Approval of state government. That too on what basis? Non-repatriation basis. Non-repatriation basis means what? Incoming allowed, outgoing not allowed. Repatriation means what? Whatever money you are bringing to India, you can take back. That is repatriation. Is it repatriation or non-repatriation? Non-repatriation. That means incoming allowed, outgoing not allowed. If you want to subscribe chit fund company, you can subscribe. Monthly you can deposit chit money also. But once you want to withdraw, not allowed. For that also, whose permission is required? State government permission is required. First of all, chit funds straight away prohibited. But allowed subject to 2 conditions, with SG approval and on non-repatriation basis. Nidhi companies not allowed. Agriculture plantation activities also not allowed. It is something for Indians only, not for foreigners. Real estate business, construction of farmhouses also not allowed. But what is allowed, except what is allowed, REIT, development, townships, roads, bridges allowed. So simply what is not allowed, trading of immovable properties is not allowed. Why? Because they are having huge money. With that money, they can artificially increase the prices of the lands. Speculation will happen. In real estate, speculation will happen. It is very dangerous. Getting my point? See, buying and selling of immovable properties is not allowed. But REIT, townships, roads, bridges allowed. Trading in TDRs also not allowed. Remember, 5 are not allowed. Tell me, what are those 5? Chit funds. Next one, agriculture and plantation, Nidhi, and next one, real estate, and last one is TDRs. But 2 are allowed. Which 2 are allowed? Chit fund is allowed subject to prior approval of state government office, state government, and on non-repatriation basis. Other one is development, townships, roads, bridges allowed. Next one, transaction with North Korea is also not allowed. If you are having any investments in North Korea, immediately you sell them within 180 days unless extended by the government. Don't carry any investments. Investment is nothing but capital account transaction only. Don't carry investments in the Democratic People Republic of Korea without CG approval. Already there, immediately withdraw them within 180 days. Getting my point, everyone? So with this, FEMA completed. Let's continue marathon with the next chapter, General Clauses Act 1897. The weightage of this chapter in your examination is 12 to 14 marks. Recent Jan 26 examinations, 2 MCQs came 4 marks and 2 descriptive questions came 8 marks. So total 12 marks came from this chapter. And from this chapter, every attempt we are getting a case scenario based multiple choice questions. So we should not take this chapter choice. Important, scoring, simple and small chapter. So let's continue. This chapter is of 2 parts. Part 1, definitions. Part 2, general principles of interpretation. And this chapter and interpretation of statutes, these both chapters are something you should not read them in an isolated way. That means directly reading them, you won't understand. Everywhere, for each and every point, you have to take examples from other laws. Simply, we had a Companies Act, we had a Limited Liability Partnership Act, we had FEMA 1999. So the examples which I used in these 3 units, same examples I'll use them here also. I'll link these points with those examples. Then you will understand. Even when you are revising this text, you have to recap those examples. Then only you can easily remember the text of General Clauses Act and interpretation of statutes. Chalo, first one, need of General Clauses Act. General Clauses Act 1897 was first enacted on 11th March 1897 to consolidate and extend General Clauses Act 1868 and 1887. See, this definition, this kind of points are not new to us, because Companies Act, if you see, it also consolidates and amends all the previous company laws. FEMA, you take, consolidates and amends previous laws relating to the foreign exchange. Similarly, General Clauses Act 1897 is also enacted to consolidate and extend General Clauses Act 1868 and 1887. That means the present act which we are studying is not first General Clauses Act. It is a third one. First one is General Clauses Act 1868, General Clauses Act 1887, second one. This act contains definitions for certain terms and general principles of interpretation. I forgot to tell you, see, this is an act that studies only general clauses. Act for general clauses. See, in every act we are having definitions. A small company, we had a definition. Private company, we had a definition. Government company, subsidiary company, holding company. Why? Because these are the words which we use them regularly, almost all the chapters. Company is a word which we use in all the sections. Now, what is a company? Instead of defining the word company in all the sections, if we define them under one roof, that is section 2, what happens? Repetition will be avoided. If you are avoiding repetitions, what happens? The length of law will come down. Getting my point? If you want to make amendment, amending that particular definition itself is enough. Or else, suppose, small company we defined in some 10 sections. If you want to amend small company, 10 places you have to make changes. It leads to mistakes. Getting my point? Now the point is, in all the central laws, that means like Companies Act, Income Tax Act, yes, we had a definition to the technical words. What about general words? Like government company, we had a definition. And what is a government? Financial year, we had a definition. What about year? Every company has to conduct AGM every year. Year means what? Next one, within 9 months after completion of financial year, first AGM shall be conducted. 9 months. Months refers to what? Is it a calendar month, or is it a Telugu calendar month or Tamil calendar month? So ambiguity is there. Now we had two solutions. One solution, let's define all the general words in all the acts. Now laws, all the central acts size will be increased. And if you want to change a particular word, you have to amend all the laws where that word is getting used. So instead of defining these general words in all the central acts, let's define them under one roof. That roof is General Clauses Act. Again, I am telling this chapter is of two parts. Part 1, definitions. 66 definitions are there. But in our syllabus, 66 definitions are not there, around 20 there. And general principles of interpretation. General principles of interpretation is the second part. These general definitions apply to all central acts and regulations unless a specific act or regulation defines the term differently or the context requires otherwise. For example, you take a financial year only. As per General Clauses Act, financial year means 1st April to 31st March. But if you take financial year as per Companies Act, if a company incorporated on or after 1st January, then the financial year closure date will be 31st March of following year. If you take a LLP Act, for example, company incorporated after 30th September, first financial year closure date will be 31st March of following financial year. That means 18 months there, 15 months in case of a Companies Act. So if a particular term is defined differently in other central laws, follow them. If other central laws is not defining the word, then come to the General Clauses Act. Also you take, for example, person definition you take. Person definition is different for FEMA, person definition is different for Income Tax Act. The act helps in cases where clear definition is absent in specific laws and resolves conflict between pre-constitutional laws and post-constitutional laws. Pre-constitutional laws that were enacted before Constitution, for example, Indian Contract Act, Indian Evidence Act, Negotiable Instruments Act, Sale of Goods Act. Post-constitutional laws are something after commencement of Constitution, like recent Companies Act, and next one, LLP Act. It provides guidance on conflicting provisions, clarifies legislative intent, and distinguishes laws based on their commencement and enforcement to prevent uncertainty. For example, agreement with minor, valid or void? Void. That is one point. Another point, agreement with minor for the benefits of the minor is valid. One is selling void, other one is selling valid. Sir, now which one I should apply? There is a conflict. No, very simple. For benefits, agreement will be valid. For the benefits of minor, agreement will be valid. So that means these general principles of interpretation helps you to remove ambiguity, to remove to remove conflicts. Object of the act, to shorten the language of central acts. As I told you just now, 66 definitions are there. If you start defining 66 definitions in all the central acts, the length of the law will be increased. So having these 66 general definitions under one roof, all other central acts language got reduced. To provide for uniformity of expression in central acts by giving definitions for commonly used terms. Uniformity of expression. If a word is defined in General Clauses Act, the meaning will be applicable to all the central acts unless otherwise specified. That means we are bringing some uniformity. We are bringing uniformity of expressions. Expressions is nothing but words. To state explicitly certain convenient rules for construction and interpretation of central acts. That is what general principles of construction. Section 5 onwards we will see the same point. Section 5 to 30. Ignore right now. To guard against slips and oversights by importing certain common forms, clauses which otherwise ought to be inserted in every central act. Ought to be inserted in every central act. Suppose imagine appointment of the auditor. Who is having power to appoint auditor? Members. Imagine section 140 is not there. Removal of auditor is not there. Members are having power to appoint the auditor. Members are having power to appoint the director. Lawmaker at the time of drafting the law, he mentioned only power to appoint auditor, power to appoint director is with the members. And he didn't told about removal. Now tell me whether the appointing authority had power to remove them or not. Logically you tell me. Appointing authority, that means who appoints auditors, the same people, will they have authority to remove them? Logically yes. But law is not telling, no sir, apply these general principles of interpretation. While drafting, lawmaker is having n number of issues to cover that, to cover a particular point, to cover a particular situation. He is having n number of thoughts. He may not keep all of them on the paper. So wherever you see power to appoint, unless otherwise specified, power to appoint is equal to power to remove. Power to remove is not there, no sir. General principles of interpretation is giving that power. Power to appoint includes power to remove. That means, is it providing some oversights, where otherwise ought to be inserted in every central act? Yes. In the absence of this chapter, general principles of interpretation, we have to copy and paste in all the other chapter, all the other central laws. In that case, language of the central acts will be increased or shortened? Increased. So 4 objectives you have to remember, shorten the language, uniformity of expression, certain convenient rules, slips and oversights. Guard is nothing but protection against slips and oversights. Purpose of the act: it consolidates various interpretation rules and legal principles into a single statute, reducing the need to specify them in multiple laws. And act eliminates unnecessary repetition in legal language. Any definitions or principles laid out in General Clauses Act automatically apply to all relevant statutes. Same point. Purpose, objective, same. Next one, applicability. This act does not define its territorial extent. See, this act is not isolated act. You can't apply it in an isolated way. The act applicability depends upon all other central laws, including rules and regulations made under them. For example, GST, if you take, GST is not only applicable to, geographical body of India, it is also applicable to territorial waterways up to 12 nautical miles, up to 24 nautical miles. So when you are interpreting GST Act, General Clauses Act in reference to GST, it is also applicable to territorial waterways. Suppose Companies Act applicable to whole of India. GCA, General Clauses Act, in relation to Companies Act applicable to whole of India. If a if a central act is not applicable to particular region of India, then General Clauses Act in reference to particular statute is not applicable to that region. Getting my point? So it is not having its independence existence. Its existence depends on the existence of central acts. This act is considered a part of every central law. If a central law applies to a region, General Clauses Act will also apply for interpretation. Earlier, we had this special article. Jammu and Kashmir had a special status. That's why few acts, Indian Contract Act also before amendment, applicable to whole of India, excluding Jammu and Kashmir. In that case, General Clauses Act for Indian Contract Act applicable to whole of India, excluding Jammu and Kashmir. Right now everything is included, so General Clauses Act is also applicable to whole of India. Acts covered, only central acts are covered. See, Act of Indian Parliament, it is a central act. Act of Dominion Legislature. Right now, who is having authority to pass acts? Parliament. Before Constitution, Dominion Legislature, after independence up to Republic Day. That means up to Constitution Day. And acts passed before Constitution by Governor General in Council or Governor General acting in the legislative capacity. Examples if you want, Indian Contract Act, Sale of Goods Act for last point. Chartered Accountants Act 1949 is for acts of Dominion Legislature. Companies Act, LLP Act is for recent one. Next one. Article 367 states that this act helps in interpreting the Constitution similar to how it applies to the central laws. So for interpretation of Constitution also you can take help of General Clauses Act. Supreme Court stated in Chief Inspector of Mines versus KC Thapar that General Clauses Act must be read into the every applicable law. Already it was proved in one case study. State versions of this act should follow the central version to avoid confusion in legal interpretation. I told you General Clauses Act is applicable only to the central acts. What about state acts, sir? For state acts, State General Clauses Act is applicable, and the State General Clauses Act should be as per the directions of Central General Clauses Act. Each and every state will have a General Clauses Act, but it should be inconsistent with, not conflict with. It should be consistent with the General Clauses Act 1897. Next one, basic understanding of legislation. Basic understanding of legislation. Every act has a preamble that defines scope, objective, purpose. Yes. What is the importance of preamble, Preamble defines scope of the act, purpose of the act, object of the act. The preamble is a primary source for understanding the legislator's intention behind the act. For what purpose this act was enacted? For what purpose this act brought into the picture? is dealt by preamble. If a provision of the act is ambiguous, preamble can be used to aid in its interpretation. Suppose best example, you take company. Company is an association, right? But every association is not a company. Suppose in a particular section, word association is there. Only the word association was mentioned. Now we got it out. Association means which association? Is it a partnership, HUF, or LLP or company? What? Go through the preamble of Companies Act. What preamble of Companies Act is telling? This is an act to consolidate and amend previous company laws. That means this act talks about only company. That means association is nothing but company only. The preamble is a part of the enactment and can be legitimately used to interpret the statute. The preamble cannot override the plain provisions of the act. See what he is telling, if a provision is ambiguous, that means if there is any confusion in interpreting the provision, take the help of preamble. But if provision is clear and provision is telling one thing, preamble is telling another thing, that means there is a conflict between provision and preamble, then which one I should follow, sir? You follow provision. I didn't remember whether your CA foundation had this concept of illegal association. It's an unregistered association with more than prescribed number of members. If it is in the lawful, if it is in the business without any registration, we call it as illegal association. That section, 464, I think it is talking about unregistered partnership forms, whereas the preamble is telling this act is Companies Act. This act is applicable only to the companies. Now provision is telling about unregistered partnership forms, whereas preamble is telling only companies. Now there is a conflict between provision and preamble. Which one I should follow, sir? Follow provision. If the word or phrase has multiple meanings, the preamble can clarify which meaning was intended. So simply listen carefully. If a word is having ambiguity meaning, multiple meanings, association means registered association, unregistered association. To remove that ambiguity, study preamble. Word is clear. Apply the meaning as it is. Getting my point, everyone? Negotiable Instruments Act, an act to define and amend the laws relating to the promissory notes, bills of exchange, checks. But certain provisions of Negotiable Instruments some provisions of Negotiable Instruments Act 1881 are still applicable to hundis, local bills of exchange. But in preamble, hundi is not there. Now whether NA Act is applicable to hundi or not, preamble is telling not applicable, whereas one section is telling it is applicable to hundi. Conflict between section and preamble. Which one we should follow? Section. An act to consolidate and amend law relating to the companies, that is the preamble of Companies Act 2013. Next one, Act. Act is a bill that has been passed by both the houses of parliament and assented to by the president. Simply Lok Sabha plus Rajya Sabha plus president consent, then bill becomes act. Bill will be introduced in either houses of the parliament. Once the bill is approved by both the houses of the parliament, then it will be sent to the president for his consent or assent. Once president gives assent, it becomes act. Bill is a draft legislative proposal. Bill is nothing but a proposal. Once approved by the parliament and assented to by the president, it becomes an act. After presidential assent, an act is published in the official gazette of the India. Next one, definitions. Every act contains definitions in section 2, though some acts may use section 3 or other initial sections. But right now, all the latest modern acts, if you see, section 2 is only for definitions. Section 1, you will find scope, objective, purpose. Section 2, scope, objective, extent. Section 2, you will find definitions. The definition clause avoids repetitive explanations of the word throughout the act. You see, small company, it was the word small company is present almost in 50 sections. Instead of explaining the word small company, defining the small company in all these 50 sections, if you define them under one roof, definitions, you can avoid repetitions. If a word is not defined in the act, its meaning is to be taken from General Clauses Act 1897. Word company, you can get definition of company from Companies Act. And the word security, Companies Act is giving reference to SCRA. Now apply security definition of SCRA in Companies Act. The word affidavit is not defined elsewhere. The word affidavit is not defined in Companies Act. Now the word affidavit gets meaning from General Clauses Act 1897. right now we are having a word declaration ma. At the time of incorporation, promoters, first director and professional must file declaration of complaints. So declaration means what? The word declaration is not defined in Companies Act. Now you take meaning from General Clauses Act. Next one, means includes, means and includes. In interpretation of statutes also we had this concept. Definitions are of three types ma. Exhaustive definitions, nothing but complete. Used in exhaustive definitions which exactly define a term without extending its meaning. For example, company, you take company means company incorporated under Companies Act or previous Companies Act, previous company law. That's it. Suppose sir, association registered under LLP Act, sir, is it a company? No. No additions, no deletions. Includes, used in inclusive definition which extend the meaning of a term beyond what it is stated. Example, debentures. Here you won't get the exact meaning of the word, however you get the list of items covered by the word. So inclusive in nature or expansive. Next one, means and includes. This is like exhaustive and clarification. If you see prospectus definition and share definition, prospectus means any document described and issued as prospectus, includes shelf, rendering deemed. So this is also an exhaustive definition only. At the same time, some clarifications were given. It covers only these items, but not other items. So used when a definition is both exhaustive and inclusive. Example, share. Share means share in the share capital of the company and includes stock. Apply to and include, used in extensive definition indicating a broader meaning. For example, body corporate. Body corporate includes companies incorporated outside India, but excludes cooperative society and any other notified entity. Okay na? See, out of these four restrictive definition, if they ask you what is a restrictive is means, because it restricts the purview. Exhaustive definitions are definition which having the clause mean, word mean, it is restrictive in nature, whereas includes is expansive in nature. Next one, shall, may. Shall indicates mandatory, may indicates directory, but sometimes you have to interpret as shall as may and may as shall. Shall as may as shall. Two examples I'll tell you ma. Two examples. Section 3, if you open section 3 of Companies Act 2013, a company may be formed for lawful purpose. A company may be formed for lawful purpose. Now reading this point like that, what interpretation we get? Company may be incorporated for lawful purpose. Company may also be incorporated for unlawful purpose, because may is just optional, right? May is a directory, it's a discretionary. So there you should not interpret, you should not understand may as may. There you have to understand may as shall. Getting my point? And any point, if it starts with shall, and if it is giving right to you, then you have to understand shall as may. For example, within 60 days of audit of government companies, within 60 days of C&AG shall, within 60 days of receipt of audit report of government company, conduct supplementary audit. Are you getting my point? C&AG shall conduct supplementary audit within 60 days of receipt of audit report of the government company. Now here, is it mandatory to conduct supplementary audit? No. But the word shall is mandatory, no sir. Their interpretation you have to understand, you have to understand shall as may. Getting my point? In our material only, you can see next, you can see after the class, a supplementary audit, test audit concept is there. It started with like this, C&AG shall. So shall accompanied with right, shall becomes may. Legal interpretation. If a statute uses both shall and may, it suggests shall is a mandatory while may is a discretionary. Next one ma, definitions. Can I proceed? Act. Generally, act is a bill passed by the parliament and assented by the President of India, right? But as per General Clauses Act, act refers to negative act. Negative means, here you can see, act used with reference to an offense or civil wrong shall include a series of acts and words which refers to acts done extend also to illegal omissions. 4 words you have to remember: offense or a civil wrong, series of acts, illegal omissions. Okay. Remember these three words, ma. Remember these three words. From this chapter, the questions can come from general principles of interpretation. One question can come from definitions. Okay na? So act, remember three words: offense or civil wrong. Next one, series of acts. Next one, omissions. Kidnapping a person is an act. Smuggling the goods is an act. Getting my point? These are, something you are doing. But here, act means not only an activity, but also omission is also an activity. Omission means, tell me, are we doing anything? In case of omission? No. But still it is treated as an act. For example, every company has to file annual returns with ROC. Every company has to file financial statements with ROC. If you are not filing financial statements and annual returns with ROC, we call it as omission. Omission is also an activity. Getting my point, ma? Omissions will also come under activity if it is illegal. Simply non-filing of income tax returns, GST returns, ROC returns, it is also act only. Generally here act refers to activity. Which activity? Positive or negative activities are? Only negative. Offenses, series of acts. Next one, illegal omissions. Affidavit. Affidavit includes affirmation and declaration by those allowed to affirm or declare instead of swearing. A written statement confirmed by oath for legal use. So affidavit, to call something as affidavit, it should be in writing. First of all, it should be in writing, and it should be done by the person who is allowed to affirm or declare. And what is the purpose of affidavit? Legal purpose, legal usage. Getting my point? Suppose director is telling that, director is giving a note. I'll use company money only for company purpose, and he's not signing it. He's not signing that letter. Now is it an affidavit? No. To call something as an affidavit, it should be in writing, signed by the person making it, and the law should allow that person to give confirmation, to give affirmation. So simply every day we are making promises to mother, mom, today I'll eat food, today I'll come to house within the time only. All these are promises, but these are not affidavits, because law is not asking us to make such promises. Getting my point? If law is asking you to make a promise, and if you are writing it, if you are making a promise in writing, signed by you for the purpose of legal usage, then it becomes affidavit. Everyone? So same definition applies to oath as well as swear. Next one, central act of the parliament, and also includes act of dominion legislature and acts by the governor general. Just now I told you, Indian Contract Act is an act of governor general. Chartered Accountants Act 1949 is an act of dominion legislature. Companies Act is an act of parliament. Central government before constitution, governor general in council. Central government refers to governor general in council before constitution. After constitution, central government refers to president of India. Next one, commencement. Commencement means coming into force, coming into operation. Coming into force, coming into operation. Suppose, in the state of Tamil Nadu, traffic police made an announcement. From 1st April 2026 onwards, helmetless drive attracts penalty of 60,000 rupees. For example, helmetless drive 60,000. Now from which day onwards this rule comes into the force? 1st April. That is nothing but commencement. The date when act or regulation comes into force. A law is not in force until officially brought into the operation. Suppose, cabinet of ministers, Tamil Nadu cabinet ministry, they passed a GO. They made an order, helmetless drive attracts penalty of 60,000. But if it was not enacted, if it was not declared officially, will that point comes into the force? Will that particular order comes into the force? No. Only through commencement, only through official announcement, it comes into the operation. A statute is not in force unless legally enacted. The theory of statute being in operation in a constitution says, though it is not in fact in operation, has no validity. For example, you take NFRA only. NFRA section 132. Yeah, wait. Section 132, applicability date. When section 132 came into the force, 1st October 2018. But if you say Companies Act 2013, Bare Act, which was published in the year 2013-14 years, 13-14 calendar years, section 132 was already there, but NFRA will not get powers until it was officially declared. NFRA assumes power only with effect from 1st October 2018. That means, sir, 5 years, you take 2013 onwards, 5 years NFRA had no powers, sir, no powers only. So drafting a law, drafting a provision, getting approval from parliament, getting approval from president is not a matter. The matter is when it got commenced is the matter. NFRA commenced, section NFRA was commenced on 1st October 2018. Next one, document. 4 components you have to remember. Document shall include, so this is an inclusive definition. Document shall include any matter written, expressed, described upon any substance. Written means, yes, written. Expressed means, like you take a hoarding, for example, printing. Described upon any substance. Here substance, there is no restriction, ma. Any substance, it can be a metal board, it can be a paper, or it can be on a tree wood also. By means of letters, figures, marks, by more than one of those means. And the resources we are using to describe the matter on the substance, resources we are using to describe matter on the substance is letters, ABCD, figures 1 2 3, marks, some indications, or by more than one of those means which is intended to be used or which may be used. Intended to be used means future tense, which may be used means present tense, for the purpose of recording that matter. For the purpose of recording that matter, then it becomes a document. 4 components, remember 4 components. Any matter, any substance, by means, any of the means, letters, figures, words, or combination of them. Why you are making why you are using these resources, why you are maintaining this document? To use it either in present or future, and we are recording the matter. Now all your gallery photos that are there in gallery, they also comes under definition of document only. It was described actually, not written. Okay, now next one. So books, files, paintings, inscriptions, and computer files. Note, document include everything, exclude currency notes. Yes, ma, tricky point, you have to remember this point. So document include everything, but document excludes currency notes. Why? It is also satisfying all the definition, all the components of the document. Yes, it was printed. On that you can see some 10 rupees or 50 rupees or 500 rupees. We can use it. Yes, we can use it. And it is recording the matter. The value of that money is, the value of that note is 500 rupees. Everything is satisfied. But document excludes currency notes. Next one, enactment. Enactment is equal to act plus rules. Act or rules, notifications, regulations, circulars. Just wait, ma. Act or rules or sections, provision, everything, ma. Act means combination of sections. Companies Act is having how many sections? 470 sections. Of course some sections got repealed. Enactment means it covers act, it also covers each and every section, it also covers rules, provisions, everything. So enactment is a broader term. It includes regulations and acts, including Bengal, Madras, Bombay codes. Before independence, when Britishers ruled our country, India is like unitary. India is like India is not having any states. India is having provinces. Madras province, Bombay province, Kolkata province, like that. We had concept of provinces. Right now, instead of using the word provinces, we are using the word states. Okay, na? So now the rules and regulations made by the Bengal government, Madras, Bombay, under Bombay code or Madras code, Bengal codes, all those comes under enactment definition. Covers any provision in act or regulation. Rules and regulations enacted by the authorities under legislative delegation. Simply, rules are something notified by MCA. Companies Act is something, Parliament made it, and Parliament plus President will amend it. But both comes under enactment. That is the interpretation. Next one, financial year. As per General Clause Act, financial year is equal to 1st day of April to 31st of March. It is different from calendar year because calendar year Jan to December. Financial year in Income Tax Act we use financial year, April to March. So financial year 23-24 runs from April 23 to March 2024. Next one, good faith. confused definition ma. Confused definition. Good faith generally, sorry, good faith as per General Clauses Act. Act done honestly. Act done honestly is said to be in good faith. Whether you are negligent or not is not a criteria. As per General Clauses Act 1897, good faith means doing an act honestly. Whether you are careless or not, whether you are negligent or not, whether you are a man of ordinary prudence or not is not a criteria. But we can't apply this definition as it is to the situations, to some cases, because as per Indian Penal Code or as per Indian Contract Act, or you take Sale of Goods Act, there good faith means not doing an act only in honesty, but also you should act as a man of ordinary prudence. That means when you are dealing with a person, if something is fishy, if something is, if some situations creating doubt circumstances, no, you have to make investigation. See, here they are not telling you first to do investigation. No, they are not asking you to do investigation. But if there is something, a doubt, first resolve that doubt. Getting my point? Simply, as per General Clauses Act, if you are buying a vehicle from a person honestly, you are said to be in good faith. But suppose the seller is not even having a proof, like RC copy, pollution copy, insurance copy. The seller is not having these documents. He is telling that this bike is for 40,000. Actually, that bike, in market value of the bike is 80,000. 80,000 worth of bike, why he is selling 40,000? When you got the doubt, you should immediately ask, show me this C book, RC book, insurance copy. Without asking this, if you directly buy the bike for 40,000 rupees, and tomorrow, if true owner comes in front of you, sir, I bought this in good faith. Whether good faith definition is applicable here or not applicable, because in that situation, good faith is equal to doing an act honestly plus negligently or carefully. So the question of good faith under General Clause Act 1897 is one of the fact. It is to determine with reference to the facts and circumstances of each case. It depends upon each case. Term good faith has been defined differently in different enactments. This definition of good faith does not apply to that enactment which contains special definition of the term good faith, and the definition given in that particular enactment has to be followed. At the beginning of this chapter, the lawmaker clearly told, if you're reading a Central Act, if the word is already defined in the Central Act, you follow that meaning. If that meaning was not given, if the word is not defined in that Central Act, you come and study General Clause Act definition. So case study already discussed, just to give one reading. Honest purchase made carelessly without making proper inquiries cannot be said to have been made in good faith so as to convey good title. Government. So wherever you see government companies, government includes both central government as well as state government. And government security means securities issued by CG, ESG, bonds issued by RBI on behalf of the government. Next important one, immovable property. I will expect this definition in the next exam. Very, very important. Immovable property. 4 components you have to remember. Land is immovable property. Benefits that arise from the land, or benefits to arise from the land. Benefits that arise from the land or benefits arising from the land, that is also immovable property. So here, September attempt, I think, rent in arrears versus rent with respect to future rents. Future rents one component, rent in arrears another component. Out of these two, which is movable property, which is immovable property is a question. Getting my point? First of all, renting a property, is it a movable property? Is it a renting? Sorry, I'm sorry. Renting a house. Is it immovable property or movable property? Will it come under immovable property definition or will it come under movable property definition? And the answer is immovable property. Why? Because benefits arising from the land. Getting my point, Sima? For example, forget about house also. I'm having 10 acres of agriculture land and I'm giving to nearby farmer to do cultivation. And I told after completion of year, I'll come, you have to pay me some 10,000 per acre, total 10 acre site, 1 lakh rupees you have to pay me. Now these rights I'm giving to the farmer, right? These rights come under immovable property or not? And the answer is immovable property only. The reason is these are the benefits that will arise from the land. Now here rents are of 2 types. Rent in arrears, advance, rents for future. Rents for future period is immovable property. Rents for future is immovable property, and rent in arrears is movable property. Why? That benefit already arised. And one more thing, rent in arrears means time period over, you are not paying me rent. If I go to court will order you to pay the amount. This is nothing but actionable claim. Actionable claim is not immovable property. Getting my point? Actionable claims are not immovable properties. So benefits arising from the land, things attached to the earth, nothing but buildings, permanently fastened to something attached to the earth. This AC you take, for example, or furniture you take, windows you take, or doors you take. Actually, they are mobile property. But once you use them in construction, they will be something permanently fastened to the something attached to the earth. So they also become immobile property. Getting my point? Benefits that arise from the land, immobile property. Things permanently attached to the something attached to the earth, that is also immobile property only. Trees, mobile property, immobile property, immobile property, because it is connected to land. But if you cut the tree, if you cut them into timber, sandalwood, for example, Pushpa movie, sandalwood, is it a goods, is it a mobile property, immobile property? Mobile property. Once you separate something from the earth, they become mobile goods. Right of way, access to a place is immobile property, but right to drain water is not. Right of way means, for example, this is a road, and this is also road. Here, three properties are there. Three properties. This property belong to A, this property belong to B, this property belong to C, and this property belong to D, and this property belong to E. Now, to enter into A's property, you can go like this. To enter into C's property, you can go like this. D property also accessible, E property also accessible. But B property accessibility, there or not there? Not there. Now B requested A, give me some way so that I can go to my place. That is nothing but right of way. Now A gave some space. Okay, this is the space I am giving to you to go to that property. Now for this, if A is collecting any rental amounts, that is a benefit to be arised in future. It is also an immobile property only. Getting my point? But right to drain water, like you can see a drainage facility or water pipeline facility under the ground, under the roads. Sometimes these pipelines or drainage facility may go under our house properties. Getting my point? Suppose our neighbor is getting water from a pipeline, that pipeline is under our property. So can I exercise any rights over that property? Can I exercise any right over that pipeline? No, because right to drain water is not an immobile property. Government is specifically telling. Next one, standing crops, fixed machinery are also considered as immobile property. So simply summer season, mangoes are coming, right? So until and unless you separate mango fruit from the tree, mango is immobile property. But once you separate the crops, once you separate the fruits, vegetables, then they become mobile property. Getting my point, everyone? Suppose I'm having 10 acres of mango, 10 acres of agricultural land, almost some 10,000 mango trees are there, 1 lakh mango fruits are there. I didn't separate them, and as a whole I'm selling to one person. Land some 1 crore, for example, land some 1 crore, and the fruits some 10 lakhs. Total consideration, how much I'm taking? 1 crore 10 lakhs. So stamp duty for transfer of immovable property, should I pay on 1 crore or 1 crore 10 lakhs is the question. Now for this answer is whether the fruits separated or not separated. That means they're still treated as immovable property. Stamp duty should be paid entire 1 crore 10 lakhs. Suppose fruit separated, sir. Trees also cut separated, sir. Now I'm getting only 1 crore worth. And 10 lakhs also I'm getting it. For that I'll pay GST if GST is applicable. Getting my point? If it is immobile property, for transfer I'll pay stamp duty. If it is a mobile property, for transfer I'll pay GST. So immobile property special points. Remember special points. First one, right to catch fish. Immobile property. Getting my point? Suppose 1 acre of land, I digged that 1 acre of land. I made it small canal, small river, and I'm growing fishes. Now right to catch fish, mobile property, immobile property because it is attached to the land. Water is mobile, fish also mobile, but that river, that small river, not movable. Okay na? Next one, right to access immovable property, but right to drain is not immovable property. Insurance policy taken on immovable property, whether insurance policy is movable property or immovable property. Insurance policy on this land and building, I took one insurance policy ma. Is it movable or immovable? Answer is it is not immovable. Why? Because it is an actionable claims. Getting my point? Next, imprisonment. So in the immovable property, you have to remember these points, trees, standing crops, all are immovable properties only. Building, immovable property. Things attached to the earth, immovable property. But once you separate them, they become movable property. Rent in arrears, tell me, rent in arrears, movable or immovable? Not immovable, not immovable. But rent with respect to future, immovable property. Imprisonment, yes, in Companies Act also, section 447, if you see, imprisonment up to 3 years, imprisonment up to 10 years. What imprisonment refers to? Not defined there. Now come to General Clauses Act. General Clauses Act, imprisonment shall mean imprisonment of either description as defined in the Indian Penal Code. Imprisonment of is of two descriptions, rigorous, simple. Simple imprisonment means you will be kept in jail, that's it. No labor work. Rigorous imprisonment means, yes, in movies we have seen some prisoners will be taken to hilly areas and they will break the rocks, they will break the mountains. So that is rigorous imprisonment. Getting my point? So rigorous is simple, with labor work, we call it as rigorous. No labor work, simple. Next, Indian law. Indian law does not include UK acts, UK orders, because more than 2 centuries approximately, or up to 2 centuries, we are ruled by Britishers. All our laws, we got from Britishers only. But British laws, UK acts, UK orders will not be treated as Indian laws. Movable property shall mean property of every description except immovable property. Example, debts, shares, electricity. Debts means nothing but debentures ma. Debentures, shares, electricity. Electricity is also movable property only. Even gas is also movable property only. Offense ma. Any act or omission punishable under the law. Covers both acts, something illegal and omissions, failing to do something legally required. Failing to do. Suppose ma, everyone has to pay advance tax by 15th March. By 15th March. If you are not paying advance tax by 15th March, you are already covered under Income Tax Act. You are earning an income of some 30 lakhs. You are bound to pay advance tax. And if you are not paying that advance tax, is it an offense or not an offense? Offense. And punishment for that offense is interest. Interest. You need to pay interest. Now, non-payment of tax, is it an activity? Yeah. Actually, it's a omission. Omission is also an activity only. Official Gazette. The Gazette of India, State Gazette, okay. Government policies, standards, notifications are published in Official Gazette. It's like a communication media between government and people ma. If government want to communicate something with its citizens, then it will use the word, it will use the medium of communication, that is Official Gazette. Person includes companies, association, body of individuals, whether incorporated or not. But sir, can I apply this definition to FEMA? No, because person was differently defined in FEMA. Person includes BOA, branches, offices, agencies. Okay. Next one, year refers to British calendar year. And simple definitions, month you all know. Month definition, British calendar month. Day means 24 hours, starts from 12 night, ends with 11:59 p.m. night only. So those are simple definitions. So with this definitions part over. Next one, application of foregoing definitions to the previous enactments. See, in General Clauses Act 1897, total we had 66 definitions ma. In General Clauses Act 1897, we are having total how many? 66. But General Clauses Act 1897 is not first act. What is the first act? General Clauses Act 1868. In that already few words were defined, like affidavit, immovable property, imprisonment, month, movable property, oath, person, section, year. So any central act, CA means any central act that comes into force on or after 3rd January 1868, in that central acts, these words will have same meaning that were defined as per General Clauses Act 1868. Getting my point? See ma, when General Clauses Act came in the year 1868, it is applicable only to the central acts that came on or after enactment of General Clauses Act. Retrospective effect will not be given. Generally, retrospective effect will not be given. Prospective, today notified or today onwards applicable. All 66 definitions will not come from 1868. Why? Because few definitions are there in 1868, few are there in 1887, and remaining are there in 1897. So now these definitions are said to be in force not from 1897 but from 1868. And some other definitions, commencement, financial year, offense, registered, schedule, subsection, writing, these are in force with effect from 1887. On this one point is there in general principles of interpretation. I'll discuss with you, just wait. Next one, application of certain definitions of Indian laws. Central Act, CG, Gazette, Government Security, Indian law, Official Gazette, apply to all Indian laws unless repugnant to the subject matter or context. In Companies Act, we had the government company. Government means what? You apply General Clause Act definition, that's it. Next one, references to the revenue of CG or SG. Just reading purpose, just reading purpose. Consolidated Fund of India, Consolidated Fund of the State. In Indian law, references to the revenue of CG, revenue of SG should be understood as references to the Consolidated Fund of India, Consolidated Fund of the State. Revenue to the government means that amount will be credited to which account? Consolidated Fund of India account. State government revenue means Consolidated Fund of the State. Okay, na? Last two, if you don't, no need to remember, ignore. Next one, general rules of construction. General rules of construction. Part 1 definitions over. Next, part 2. We are in part 2. Part 2 is general rules of construction or general principles of interpretation. So starting with section 5. What is section 5? Coming into operation of enactment. It is nothing but commencement. It is nothing but commencement. Suppose if you see Companies Act only, you take for example Companies Act. It got President assent on which day? 29th August 2013. And it was notified in Official Gazette 30th August 2013. Now from when onwards Companies Act is said to be in force? 30th August 2013. Why? Because this was notified. This was notified date. Notified date. If any particular day was notified, from that day onwards Act comes into the force. Sir, that day also, what is the time period, sir? If nothing is specified, the time will be 12 o'clock. That day midnight 12 o'clock. That day, not that day midnight. That day 12 o'clock. That means when clock hits 12 o'clock and when the day changes 29 to 30, from that day onwards it comes into the force. Because we celebrate Happy New Year January 1st. January 1st night or December 31st night? 31st night we celebrate, because 31st night after 12 o'clock it will be Jan 1st. If a Central Act does not specify a date, oh my god. If a Central Act does not specify a date, it comes into the force on the day it receives President or Governor's assent. Suppose if you take Companies Act, it received President assent when? 29th August. Suppose if 30th August was not specified, then Act comes into the force from 29th August. LLP also you take. LLP, President consent 7th January, but was notified on 9th January. 9th January. If date was not notified, then from 7th January onwards, LLP Act is said to be in force. FEMA also like that only. It was enacted in 1999, but it came into force with effect from 1st June 2000. The date was specified date onwards. If date is not specified, then when it received President consent. If a specific date is mentioned in the Gazette, it comes into force from the date. Courts cannot compel the government to enforce a provision on a specific date, but can direct them to consider the enforcement. As you all know, we are having three bodies: legislative, legislative, executive, judiciary. Legislative duty is to bring laws. Executive duty is to implement the laws. Whereas judiciary role is interpret the laws. So judiciary cannot compel legislative to bring the law. But judiciary can recommend, all mistakes are happening. It's better to bring the law. Like advisory. It's just an advisory, but it's not like a mandatory. Courts cannot compel government. Court cannot direct the government to bring the law, but court can advise the government. Next one, presumption against retrospectivity. Laws affecting substantive vested rights generally apply prospectively. That means today law was enacted, from today onwards law is applicable unless expressly stated otherwise. Retrospective effect is only valid if it is explicitly mentioned in the act. So if you want to give retrospective effect, that means what? Sir, today I am bringing the act. For example, you see General Clause Act came in which year? 1897. Nothing is specified. This General Clauses Act will be in force with effect from 1897 only. But if you see these definitions, now you can see first 2 points, in fifth case, first 2 points you see here explicitly, that means expressly they mentioned, these definitions are said to be in force not from 1897 but from 1868. Like that, you have to expressly mention it. Expressly you have to mention that these words are having retrospective effect. So for this, if you want, you can write examples 5, 1 and 2 above 5, 1 and 2. Can I proceed? Next one, repeal, super definition. Super definition. Repeal, deletion, both same or different? Both same or different? After reading these 5 points, you will think both are same only. After reading these 5 points, you will think both are same only. But generally, repeal means complete deletion of the law, as if it never exists. As if it never exists. It's like erase. It's like erase. For example, I brought Companies Act 1956. Repeal means it's like erase. You can't see it as if it existed in past. Deletion means what? Companies Act 1956. I'm deleting this act. That means it came in the past. Few years it was in operation. After that it lost its importance. Right now it is no more in force. So deletion means you can see the existence as well as closure. Whereas repeal means complete erase of the law as if it never exists. But the problem is these 5 points, ma. The problem is with these 5 points. What these 5 points are telling? See, repeal shall not revive anything not enforced, not prevailed during the period at which repeal is effected. This is the only first one. Repeal shall not revive. What it is telling, see, Companies Act 1913 was repealed. In that place, Companies Act 1956 came. And later this was repealed and Companies Act 2013 came into the picture. Suppose Companies Act 2013 not yet came. Companies Act 2013 not yet came. After the repeal of Companies Act 1956, do you think Companies Act 1913 will come into force? Are you getting my point? See, repeal of one statute doesn't mean revival of previous statutes. Getting my point? So if Companies Act 1956 was brought in the place of 1913. Now if you repeal 1956 Companies Act, it doesn't mean Companies Act 1913 will be in force. That is the meaning of first point. It will not revive anything that is not in force during that act tenure. Repeal shall not affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. Oh my god, it will not affect previous operation. Suppose Infosys you take, company was incorporated in the year 1981. Under which act? Companies Act 1956. When Companies Act 1956 got repealed, Infosys also lost its legality. Or Infosys is still a legal company? It is still a legal company. The financial statements which you prepared under Companies Act 1956 are still legal only, valid only. Repeal shall not affect any right, privilege, obligation, liability acquired, accrued, incurred under any act, enactment or so repealed. Suppose I was appointed as a director for 5 years under old act. Exactly 2012 I was appointed as a director for 5 years. In the 2013 old act got repealed. That means my appointment for the remaining 3 or 4 years will come to an end. Will be continued. Will be continued. My right for the next 3 years is still in place. Getting my point? Suppose I brought partly paid up shares under old act. Old act got repealed. Under new act, if company is making calls on shares, am I still liable or no liability? I'm still liable. That is the meaning of this point. Repeal shall not affect any penalty, forfeiture, punishment incurred in respect of any offense committed against any enactment so repealed. Suppose under old act, 2019, what is the old act? 1956. Under Companies Act 1956, in the year 2011, I was sent to jail for 8 years. But in between what happened? 2013, old act got repealed. Old act got repealed. Now balance imprisonment tenure. Am I liable or I will come out immediately? Liable only. Getting my point? There will be no effect on my punishment. Repeal shall not affect any inquiry, litigation, remedy with regard to such claim, privileges, debt, or responsibility, or any inquiry, litigation, remedy may be initiated, continued, or insisted. Sahara company you take, the scam happened in the year 2008 under Old Companies Act. It was identified in the year 2010. Okay, some proceedings are going on, investigation proceedings are going on, but in the year 2013, Old Act got repealed. Now the chairman of Sahara, can he tell, Array, the investigation you are doing under Old Act, it was repealed, so you should stop investigation. I'm not guilty. Can he tell like that? No. Ongoing investigation can still be continued. Now very simple. Right now we are having Income Tax Act 1961, right? Next year we'll get new. Already it is there, but from next year onwards it will be new. We need to follow new Income Tax Act. Under Old Income Tax Act, if I make any tax evasion, am I punishable or not punishable? Punishable only. Sir, already repeal, no sir. Already repeal, no sir. But it will not affect inquiry, litigation, remedies. Getting my point? Everyone? Now you tell me, complete erase of law means you should not punish me actually. You should not apply that provision, but still you are applying the provision. Getting my point? Everyone? GST, 2017 it came. But still some of my clients are getting notices with respect to non-payment of service tax, that is in 2016, 10 years back cases. Still today coming, some cases are coming. If we ask, that act was repealed, no sir, but your liability was not extinguished, you have to pay liability. Or another simple example, every company has to file financial statements with ROC, right? Under Companies Act 1956 also you need to file financial statements with ROC. 11 12 12 13 you didn't file. Suddenly new Companies Act came. Now with respect to these 2 years filings, still you need to file, or you no need to file, still you need to file. That is last point, last but one point. Getting one? Next one. In contracts, deletion takes effect only from the date it is enacted without retroactively erasing the provision prior existence of the effects. But logically, after reading these 5 points, I don't find much difference between these two. Why? Because even though it is complete erase, but still we are applying it with respect to that period. Next one, repeal of act making textual amendment. If any central act or regulation repeals any enactment that made amendments to the another law, those amendments still remain valid. Oh my god. For example, Tax Amendment Act is repealed, tax rates amended by it still apply. Example, Income Tax Act 1961 is there. Basic exemption limit, they fixed basic exemption limit 2.5 lakh, they fixed. Suppose this got amended in the year 2017. Example 2017 Income Tax Act was amended. There they increased basic exemption limit to 6 lakhs. Example only, not real. Income Tax Act was amended in the year 2017. Income Tax Amendment Act 2017, basic exemption limit has been increased to 6 lakhs. 2 years later, this Amendment Act was repealed. Now, original limit of 2.5 lakhs will survive, or a revised limit of 6 lakhs will survive, is the question. Revised limit of 6 lakhs only will continue. Getting my point? Any amendments that are made to the original act. Now, if you are repealing these amendments, if you are cancelling these amendments, unless otherwise specified, already these amendments were part of the original act, you have to follow amendments only. Suppose in the reenactment of repealed act, for example, in the Income Tax Act 2026, basic exemption limit, they increased it to, for example, 9 lakhs. Now you have to forget about all this. You have to remember it as 9 lakhs only. See, right now basic exemption limit under old regime is 2.5 lakh only. There is no change. Under old regime up to 2.5 lakh only, no tax. Example sake I'm telling. So one more time I'll tell. Amendment Act is making an amendment to original act. Now I'm repealing not original act. I'm repealing Amendment Act. Repeal of Amendment Act. What would be the effect of the amendments? Amendments still continue or comes to an end. Unless otherwise specified, amendments will still continue. Very recently, very recently, GST rates have been reduced. Government has reduced GST rates. Previously we had 18%. Many products which are taxed under 18% came to 5%. this was brought through some amendment act. Imagine, example, later if this amendment act got cancelled, now 18% is applicable rate, 5% is applicable rate, 5% is the applicable rate. Suppose in the new act if they tell 4%, then 4% only applicable. Next one, revival of repealed enactments. If any central act or regulation for the purpose of reviving either fully or partially any enactment wholly or partially repealed, it is necessary to expressly state that purpose. Suppose Companies Act 1956 is there, repealed, Companies Act 2013 came into the picture. I want to remove this and I want to bring back old law. If you want to bring back old law, expressly you have to specify the matter. I want to bring back old law. If you don't tell that, repeal of existing law will not revive previous laws that are there before Companies Act 2013. Getting my point? Companies Act 2013, I want to cancel it. If nothing is specified, Companies Act 1956 will not come into the force. But if you want Companies Act 1956, expressly you give a notification. Okay, na? Next one, construction of references to the repealed enactments. Construction of references to the repealed enactments. For example, right now, if Companies Act is silent, suppose Companies Act 2013 is silent on any word, we are referring those words to General Clause Act 1897, right? Imagine General Clause Act 1897 got repealed, in that place General Clause Act 2026 came, for example. Now we need to refer those words to old act or new act? New act. Sir, in Companies Act, General Clause Act 1897 was mentioned, sir. Automatically references will be updated. We had a concept in PGBP, MAT 1 concept is there, minimum alternate tax, MAT 1 taxation is there. MAT concept, what it is telling, you have to calculate book profits as per Companies Act 1956. See, when Income Tax Act came into the picture, 1961. But by the time we had Companies Act 1956. Very recently, Companies Act 2013 came into the picture. So when Income Tax Act 1961 was enacted, it gave references to old act. When old act got repealed, in that place when new act is there, automatically references will be updated to new act. Simply, right now we are seeing Section 8 companies, right? Under old act, it is Section 25 companies. Now in the entire Income Tax Act, wherever you see Section 25 of Companies Act to Section 25 of Companies Act 1956, you need to construe it as, you need to interpret it as Section 8 of Companies Act 2013. Okay, na? Repeals and reenacts any provisions of a former enactment, then all references nothing but indications, indicators, indication in any other enactment or in any other instrument to the provision so repealed shall, unless a different intention appears, be construed as references to the provision so reenacted. Simple way to remember, reference to old law is updated to reference to new law. If old law is removed and if new law was enacted, then all the references to old law will be automatically updated to references to new law. Next, Section 9, very simple, commencement and termination of time. Here you have to remember two words, from to. From excludes first day, to includes last day. From excludes first day, to includes last day. Suppose dividend shall be paid, dividend shall be deposited, amount of dividend shall be deposited within 5 days from the date of declaration. Date of declaration is 30th September 26. Within 5 days you need to deposit with separate bank account. Now counting 5 days starts with 30th, no, from excludes that day. So 1, 2, 3, 4, 5 and 2 includes 5th day. Last day will be included to, first day will be excluded from. That's it. Next, computation of time. In any legislation or regulation, remember Section 48, recap Section 48, variation of rights. Dissenting shareholders can appeal to NCLT within how many days? Within 21 days of variation. Suppose if the 21st day of variation is court holiday, then when we should file an appeal, sir? Before day na, next day na? And the answer is next day. The next day is also holiday, sir. The next day when court opens. Getting my point? See, Any legislation or regulation, any act or proceeding is directed to be done on a certain day within prescribed period, then if court or office is closed on that day, the last day of the prescribed period, the act or proceeding shall be considered as done or taken in due time if it is done or taken on the next day afterwards on which court or office is open. Getting my point? That means you tell me next day na previous day na? Next day. Suppose if any law is telling previous day, then follow that. If law is silent on that matter, then follow General Clauses Act. According to General Clauses Act, due date will be the next day. Can I proceed? Measurement of distances, very important from capital gains chapter, Income Tax Act. Capital gains, if you remember, up to this much population, I think 10,000 population, 2 kilometers from municipality, 6 kilometers, 8 kilometers is there, right? 246 or 8 is there, I think. 246 248, I think. 8 I remember, 2 I remember. Between number I don't know. Capital gains, location of property. Let me ask, it will give something. Yellow. Not interested. Not interested. Are 268 only, ra? 268 only. Now you know 2 kilometers from the limits, 6 kilometers from the limits, 8 kilometers from the limits. Suppose you know municipality is there. For example, municipality is here and the property was located here. Imagine for us 8 kilometers is applicable. Now how to determine 8 kilometers distance, sir? Suppose sir from municipality take left and then right, next left, again right, one circle, U-turn. Now oh my god, okay, for example, going like this, one circle and again like this, reaching this property, sir, total 16 kilometers came, sir. So therefore this is a rural property only. Like this determination of distance happen, or when you take these two on the geographical map, exactly the horizontal line, the straight line, simply don't determine distance by roadway, determine distance by flight. Getting my point? So that will be the distance as per General Clauses Act. Suppose this distance is just 800 meters. Now that is no more a rural property, that is urban property only. Getting my point? Measurement of distances, remember, straight line on a horizontal plane. Duty to be taken pro rata. This is for you, GST. You know, this is capital gains. This is GST. GST, for example, GST. If you import 1000 grams of particular item, 1000 grams, you have to pay 50 rupees tax, for example. Sir, I am importing 500 grams, sir. Then how much tax I should pay? Proportionate to 25. Sir, if I import 1500 grams, then pay 75 rupees. So how this calculation happened? Proportionately, pro rata. Pro rata. Any duty of customs or excise in the nature thereof. Excise, you know, earlier we had excise duty. Right now excise duty is only on the petrol. We had GST concept, right? But our act, General Clauses Act, came in which year? 1897. That time, you know, excise duty only there. So excise customs in the nature thereof is leviable on any given quantity, weight, measure or value of the goods, merchandise, likely duty leviable according to the same rate on any greater or lesser quantity. Okay, na? Even this pro rata is applicable to the dividends also, ma. You know, for every share 2 rupees, 100 shares you are having 200, 1 million shares is having 2 million rupees. Pro rata. Gender number. Gender number. In the beginning, you know, object of the General Clauses Act, if you see, object, there we have seen to guard against slips and oversights. Guard against slips and oversights. Protection. This General Clauses Act is a protection. Example you can see here. Suppose any officer who is in default, any officer negligent with respect to one activity, then he will be punished with fine some 10,000 rupees. Like that provision is there. Particularly gender, he is mentioned. Suppose that officer right now is a female and she is also negligent in that activity. Now court want to levy fine on her. Now she is telling that, sir, point he is there, she is not there, no, so I won't get any punishment. Can she escape from the punishment? No, because generally male includes female, singular includes plural. But for this also there is an exception. There is an exception. What is that exception? Here you can see, bullock cart mentioned. Bullock cart means bullock cart only, not cow cart. And singular includes plural is there, right? Singular includes plural. And uh, you have to pay tax with respect to previous year 24-25, for example. Here previous year means 1 year only, it's not previous years. There singular means singular only. If the text is telling that singular, you have to indicate it as a, you have to interpret it as singular, then singular will be singular only. Okay na? He includes she. Suppose specifically we are telling that woman director. Now here can I tell men director also? No, woman director. When reference is given to gender clearly, don't interpret like male includes female, female includes male, singular includes plural, like that don't indicate. Getting my point? Suppose officer in default gets a punishment of 10,000. For example, officer in default. In our situation, managing director, whole time director, both committed mistake. But act is telling officer in default. Now MD is telling officer in default. That means only one person. We are two in number. So we both should not be punished. Only one person to be punished. Correct interpretation or wrong interpretation? Or wrong. Why? Singular includes plural. See, general rule. What is the general rule? No confusion. Listen. What is the general rule? Singular includes plural. Male includes female. But we had exception. Exception. Previous year means previous year only. It's not previous years. Bullock cart means bullock cart only. It is not cow cart. That's it. Next one 14 to 19. Simple only. 80% of the chapter over 80% of the chapter over. Balance are small things only. Majority of time in this chapter, we will spend on the definitions and section 5 only. Section 6, repeal. Remaining all simple. Section 14, power conferred to be exercisable from time to time. If a power is conferred by any central act, it may be exercised repeatedly as needed unless stated otherwise. Example, you write small company. When act was enacted, when Companies Act was enacted, small company, the limit is like this. Paid up share capital 50 lakhs, turnover 2 crores. Later, government increased it to recently. Before December, what is the limit? Before December, what is the limit? 4 crores, 40 crores. But before that, 2 crores, 20 crores is the limit. Next, it became 4 crores, 40 crores. Recently, it became 10 crores, 100 crores. Now, how many times central government used this power? 3 to 4 times. So, as prescribed, if the word prescribed is there is no limitation on the government. Use that power only once or twice or thrice. There is no such power. It can use that power from time to time as and when required. Power to appoint includes power to appoint ex officio. If you take IEPF authority, one chairperson, others not exceeding 7, and one secretary is there. And who is the chairperson? MCA secretary. So how appointment happened? By his name or by designation he is holding? With the designation he is holding. Another live example, if you want, Speaker of Rajya Sabha, you take Speaker of Rajya Sabha is equal to Vice President of India. So if you appoint someone as Vice President, automatically they will be appointed as Speaker of Rajya Sabha. So any legislation or regulation grants power to appoint a person to an office or function. They may be appointed by name or by virtue of the office. So here I can tell Mr. V, you are the chairperson of, for example, chairperson of IEPF authority. Or I can name Secretary of MCA, chairperson of IEPF authority. I can appoint in 2 ways, either by name or by way of designation they are possessing. Power to appoint includes power to suspend, power to dismiss. On this point, one time a 4 marks practical question came. Managing director of the company for the purpose of one project can appoint employees. Is the power given to the MD. MD is having a power to appoint the employees. MD appointed employees, but those employees are not working. So immediately MD removed them. Those employees filed case on MD. MD, you had power to appoint. You had no power to remove me. So this removal is invalid. We will continue our positions. So valida, invalida, invalid. Why? Power to appoint includes power to suspend, power to dismiss. Next one, substitution of functionaries. For the purpose of indicating the application of a law to every person, number of persons for the time being executing the functions of an office, it shall be sufficient to mention official title of the officer at present executing the functions or that of the officer by whom functions are commonly executed. If you want certificate of incorporation, tell me If promoters want certificate of incorporation, they need to file documents with whom? ROC. ROC is like a title. So instead of naming a person, if I mention ROC, any person holding the designation will have the powers of the designation. And here, am I telling ROC or I am telling ROC AP, ROC Tamil Nadu, ROC Karnataka, ROC Kerala? No, ROC. That means all the ROCs in India had same power of issuing certificate of incorporation if they receive documents for incorporation. So substitution of functionaries, instead of calling you name wise, I'll call you with your designation. Successors. For the purpose of indicating the relation of a lot to the successor. Successor means whom? Next person taking the position. Of any functionaries or of corporations having perpetual succession, it shall be sufficient to express its relation to the functionaries or corporations. For example, you take President of India. Central government owned company, shares are held by President of India. So that rule is applicable to all the successors. Present Murmu madam is the President of India, so she will hold all the powers of, she will hold all the shares of central government companies. If some X is becoming next president, automatically the same powers which now madam is exercising, who are going to exercise in future? X is going to exercise. That is the point. Successors. Next one, official chiefs and subordinates. Suppose promoters file documents with ROC for incorporation certificate. At the time ROC is absent, ROC is on leave. Who is there? Assistant ROC is there, or additional ROC is there, or deputy ROC is there. Now can deputy ROC issue certificate of incorporation? Yes. So law related to the chief officer also applies to deputy subordinates lawfully performing their duties. In my childhood days, CBI one series is there. It's not web series, it's a daily serial actually. CBI, Prajuman, Joseph, Abhijit, the character names. I don't know Tamil names of them. Have you watched a CBI story? Okay. In the recent two to three attempts back, a question came like this. Commissioner of Income Tax gave income tax notice to company C Limited, did investigation, but 10% before completion of the work, commissioner fell sick and he took a leave of 3 months. Next, assistant commissioner of income tax issued a notice with punishment, with a penalty of some 60 crores. Now C Limited raised a question. Sir, this case was handled by commissioner of income tax. Only he can handle the case. Only he can pass the order. Assistant commissioner of income tax is not having any powers. So whether order passed by assistant commissioner of income tax valid or invalid? Answer is valid only, because the powers exercised by the officers can also be exercised by the subordinates in the absence of officers. Next one, 20 to 24. What is 20? Construction of orders etc. issued under enactments. Sima, expression. Recently government issued just wait. Every 2 years company, government will bring new amendment acts. It's not government, parliament bring amendment acts. Suppose Companies Act 2013 is the original act. It got amended in the year 2015, 2017, 2019, 2020, like that. It got amended. Now in the amended acts or in the circulars given by the government, if the particular expression is not defined, then what is the meaning of that expression? Expression means what? Word. Expression means what? Word. Now from where we should derive the meaning of the word? Very simple. Go through the original act. Getting my point? Suppose MCA gave a circular. Company is exempted from filing, but it didn't define the word company. Now word company will get definition from where? Companies Act 2013. That is the meaning of point. Same respect to meaning as in the act unless otherwise specified. Power to issue, amend, vary, resign, notifications, orders, rules. MCA, nothing but central government, is having power to issue rules. The same authority will have power to amend the rules, change the rules, cancel the rules. Next, it's similar to power to appoint, includes power to dismiss, power to suspend. Next point, making of rules, bylaws before enactment comes into the force. Before what? Before enactment comes into the force. We have seen just now, NFRA was constituted on which day? 1st October 2018, right? Now, if CG bring any rules with respect to NFRA in the year 2017 or in the year 2016, will these rules effective or not effective? Not effective. They will be effective only on or after 1st October 2018. And CG can also exercise powers with respect to section 132 only after enactment of section 132. If a central act or regulation is passed but does not come into the force immediately, any power granted under it to make rules, issue orders, establish courts and appoint officials can be exercised right after the act is passed. However, these rules and orders will only take effect when the act or regulation officially begins. Getting my point? NFRA section 132 was notified in the year 2018. That means CG cannot exercise powers that are there on section 132 until 132 got enacted. Even if they bring any rules, those rules will not be enforced. They will be enforced only after commencement of this act. Provision for making rules, bylaws after previous publication. One example here I'll tell you, that is in CME Enter you will find a minimum wages act, one concept. Every 5 years minimum wages will be revised. So that revision process would be like how, central government will appoint some committees. Those committees will do some groundwork, and they will send a report to the CG. Based on the report of this committee, CG will draft rules. So particular metropolitan areas, minimum wage should be some 25,000 per month. Semi-urban areas, minimum wage should be 20,000. Rural areas, minimum wage should be 15,000. Like that, government framed rules. Of course, these rules are affecting the employees, labor. So before you publish these rules, before you enact these rules, before you bring them into force, first give it to the public. And wait for some period. During this period, the affected parties, nothing but employees will make some recommendations, will tell their objections. Now it's up to the central government whether to consider them or not to consider them. Central government may consider them or central government may ignore them. Finally, central government will bring final rules copy, and once published, that's it, you have to follow it. So that is point. So first publish a draft means not final, publish a draft. Next, authority must publish the rules in a way it considers sufficient as prescribed by the government. If prior publication is required, notice must be published with the draft stating the date from which it will be considered. And objection suggestions, approving authority must review the objection suggestions raised during the period. Once published in official gazette, the rule or bylaw is considered legally valid and properly made. Okay, na? Next, section 24. If a central act or regulation is repealed and reenacted with or without changes, then unless stated otherwise, all appointments, notifications, rules, orders made under old law will continue to be valid under new law. Simple example, ROC was appointed under Companies Act 1956. The word ROC and the appointment of ROC also happened under Companies Act 1956. Now Companies Act 1956 got repealed. Do you think ROC will lose their jobs? Registrar will come out of that position, or still they will continue? Still they will continue. They will be in force only. If a law previously extended to a specific area is later withdrawn and then re-extended, it will be treated as repealed and reenacted for that area. This section confirms that if a law is repealed but reenacted with same or similar provisions, repeal is neutralized and the provision remain in force without interruption. However, if the reenactment introduced significant changes, then modified parts replace and override the old provisions. Suppose under old act we had 20 ROCs. Under new act we told 24 ROCs. Under old act, 1 ROC for AP and Telangana. Under new act, 1 ROC for AP, 1 ROC for Telangana. Now when there is a significant change, follow the significant change. If nothing is mentioned, it will be neutralized. That means what? Under old act, what rules and regulations are made, same rules and regulations will continue. Next, miscellaneous, recovery of fines. Now 447 we told fine will be minimum 1 time of amount involved in the fraud, maximum 3 times of the amount involved in the fraud. Fine amount we told, but how we are going to recover that fine, nowhere mentioned. So for that, General Clauses Act is telling, go to IPC, go to CRPC, Code of Criminal Procedure. What they are telling, just follow it. Even General Clauses Act also is not giving you direction. It is just telling, go and follow CRPC, IPC. Over. Next, Offenses punishable under 2 or more enactments. This is actually a tricky point, ma. Listen carefully. Offenses punishable under 2 or more enactments. Ma, you did a mistake. That mistake is covered by 2 acts. For example, Law A, Law B. Law A is telling 10 years imprisonment. Law B is telling 5 years imprisonment. Now, which period is applicable to you? Sir, 10 plus 5, 15. No, 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 no. If same offense is, if it is a one offense, only one offense, covered by 2 statutes, prosecution may be conducted differently. Prosecution means what? Investigation, hearing can be done under 2 enactments separately. But punishment will be either under one statute only. It's not like 10 plus 5. It's either 5 or 10 up to the court discretionary powers. But suppose offense had 2 ingredients. One ingredient is covered by law A, another ingredient is covered by law B. Now punishment under 2 laws or only one law now? Punishment will be under 2 laws. Suppose Shivaji movie, you see Shivaji movie. Black money. You have to submit to the government, but you didn't submit to the government. You did hawala. Money laundering act is money laundering act will prevention of money laundering act provisions will apply, and you converted them into foreign currency without authorized dealer permission, without RBI permission. FEMA non-compliance is also applicable. You did one mistake, but 2 or 3 ingredients are there. All these 2 or 3 ingredients are covered by separate statutes. Now punishment under separate statutes is applicable to you. This is very, very important. See, prosecution under both laws is allowed. Prosecution under both laws is allowed. But punishment under both laws is not allowed. You may be investigated under 2 laws, but you will get punishment under only one law. Everyone? Next. Another example, if you want, section 34, section 35, you see. What is section 34 of Companies Act? Criminal liability for misstatement in the prospectus. What is 35? Civil liability. Suppose you issued a prospectus with misstatement. In 34 misstatement is covered, 35 also misstatement covered. But in 35, along with misstatement, there should be some loss to public. Yes or no? Sir, there is no loss to the public, sir. So investigation can be done under 34 and 35, but punishment will be only under 34. Sir, misstatement and there is also loss to the public, sir. Then you will get punishment both under section 34 and 35. Next, meaning of service by post. If Central Act is silent, the document is said to be served if it is properly addressed, prepaid stamps and posted by registered post. Address compulsory, stamp should be prepaid, and it should be posted by registered post. Address plus stamping plus registered post. But if any particular rules or enactments are telling their registered post acknowledgement due is compulsory, then you have to send it through registered post acknowledgement due only. See, General Clauses Act when applicable? If Central Act is silent, General Clauses Act is applicable. General Clauses Act, addressing and prepayment of stamps and through registered post enough. The document is said to be properly served. But if you see registered post acknowledgement due is compulsory, then you have to send document only through registered post acknowledgement due. If a person, recipient, refuses to receive registered post, it is deemed to be served. It is considered as served. Next one, citation of enactments. Citation of enactments. I can call Companies Act like Companies Act 2013, or I can also call it as Act number 13 of 2013. See, ICA can call you in 2 ways. One is through your name or through your SRO number. Getting my point? Saving for previous enactments or rules or bylaws. New provisions do not affect the interpretation of laws, rules, bylaws made before Act's commencement. Nothing but, suppose MCA already framed NFRA rules before enactment of NFRA section. So those rules, we need to start interpreting them only after commencement of the enactment. The term Central Act includes ordinances made under the various laws. So General Clauses Act not only applicable to the acts but also applicable to the ordinances. Okay, na? The only difference, Act will have unlimited validity period unless terminated by the Parliament. but ordinance will have a limited validity period. It's 6 months or within 6 weeks of commencement of parliament session, ordinance should be ratified, or else ordinance validity will come to 0. Generally, how act comes into the picture? Bill approved by the parliament and president act. In case of emergency where parliament can't be called for, by with the president consent, directly you can apply the bill. That case bill is known as ordinance, but ordinance will not have unlimited validity period, it will have only limited validity period. Clear? So with this general clauses act over, again I am telling 2 parts ma, definitions. 2 definitions will come for 4 marks. And next one, general principles of interpretation. In this general principles of interpretation, you can expect 2 MCQs and you can expect 1 descriptive question. Let's continue marathon with the next chapter, interpretation of statutes. The weightage of this chapter in your examination is 8 marks. Recent Jan 26 attempt, 2 descriptive questions came, 8 marks. Okay. This chapter is easy to understand, easy to study, but difficult to remember and difficult to reproduce as it is. You know, the technical words we will miss out. So you can keep this chapter as a last priority. You can keep this chapter as a last priority. Once all the other chapters are over, read this chapter, because from this chapter even case scenario multiple choice questions are also not coming regularly. So that's why keep this chapter as a last priority. And this chapter is of 2 parts ma. Rules of interpretation. We are having primary rules of interpretation, secondary rules of interpretation. And second part is aids to construction. We are having internal aids and external aids. And last, a small minute concept, that is interpretation of documents, deeds. Clear? So chalo, let's begin. See, statute refers to act of the parliament and refers to written laws. See, we are having 2 types of laws ma. Written laws, unwritten laws. India, we are having only written laws. If you take New Zealand for example, for them, you know, written laws are not there, unwritten laws. Sir, what is the difference, sir? Written laws, you know, before we follow something, it was codified by the parliament. You can take Companies Act for example. So first a draft proposal has been done, you know, we call it as a bill, draft bill. Once it was introduced in the parliament, you know, some discussions will happen. After completion of discussions, voting. After completion of voting, bill will be sent to the president for consent, act. And we follow only act. What is there in act, we follow. What is not there, we don't follow. Unwritten laws means like this codified procedure will not be there. For them, custom is the top source. Customs, you know, daily we will have a number of practices. Some are good practices, some are bad practices. We ignore bad and we follow only good practices. Even law is also prepared from customs only. Law comes from customs only. Since we follow, it becomes only law. It's not hypothetical subject, right? So in case of unwritten laws, they follow traditions. In the tradition, if something is harmful, if something is evil there, you know, court rejects them, court prohibit them. So through the customs and case studies, they follow the laws. Such kind of laws are known as unwritten laws. And you know which one is more flexible? You know, unwritten laws are more flexible because amendments are not required. Whereas which one is more rigid? You know, written laws, because for every amendment, yes, parliament, constitution, again draft bill, after approval, president consent, enactment, official gazette, notification, everything is required. So each and every system is having its own advantages and disadvantages. We follow written laws, some countries follow unwritten laws. That is the difference. Maxwell defines statute as a will of the legislature. In India, statute refers to the enacted law. A bill is passed in Lok Sabha and Rajya Sabha. Upon receiving president's consent, it becomes act of parliament or a statute. Simply, act is nothing but statute. But word statute is not that much popular in India. We follow act. Companies Act, Indian Contract Act, like that. Clear? Next one. This I already covered ma. Document. Document. In General Clauses Act, I already covered this point. See ma, document consists of 4 elements ma. Any matter, any substance. Means, coming to the means, yes, letters, figures, or anyway, any expressions. Next one, what is the purpose? Record that matter. Why? To be used or intended. You know, right now we are using it, or we had intention to use it in future. Let's see here. Matter. Its usage with word any. That means there is no limitation on the matter, any matter. Record. Second element is record. Mutual or mechanical device employed on the substance. It must be by writing, expression, description. And substance, mental or intellectual elements comes to find a permanent form. It's not something erasable, it will be permanent. And next one, means, that means resources. We employ letters, figures, marks, symbols which can be used to communicate between the two persons. Even submarines will send messages to the port authorities using radio frequency. That will also be printed, or that will also be coded, and it is also a message, it is also a document. Okay na? And here you need to understand the difference between document, instrument and deed. Three technical terms are there, document, instrument, deed. Document means a written item, including type written item. Document means a written thing. Instrument means a formal legal document that creates, confirms, records a right or fact. Formal writing of any kind, such as an agreement, deed, charter, record, drawn up and executed in a technical form. And formal legal document having legal effect, either creating a right, yes, this is the point, creating a right or liability. Simply, instrument, if you ask me equation, instrument is equal to document plus rights or liabilities to the parties. Rights or liabilities to the parties. Any document creating rights and liabilities to the parties of the document, we call it as instrument. For example, promissory note, bill of exchange, check. So that means every instrument is a written document. What is the difference? Document may have rights, may not have rights, but if the document is creating rights and liabilities, then it becomes instrument. So you tell me which one is wider? Document, because every document need not be instrument, but every instrument is a document. Next one, a deed is a formal written instrument. What he is telling, deed is equal to instrument that affects a legal disposition, legal usage. All deeds are instruments, but not all instruments are deeds. In India, there is no clear distinction exists between deeds and instruments. But in common sense, the difference between deeds and instruments, in deeds you will find witness signature. In instrument you will not find a witness signature. And deeds will have, both will have legal usage only. Both had legal usage only. But deed is something narrow compared to instruments. Instrument creates rights and liabilities. Deeds also create rights and liabilities. But something is more extra compared with instrument. For example, MOA is a deed. Partnership deed is a deed. So partnership deed create rights and liabilities of the partners. What is the right of the partner and what are the responsibilities of the partner? Everyone? So simply if you ask me, every deed is an instrument and every deed is a document. But every document need not be an instrument, every instrument need not be a deed. Differences, if someone asks you, document, a written thing, any matter on any substance by any means, recording the matter to be used or intended to be used, used or intended to be used. Next, instrument, a document capable of creating rights and liabilities. Deed, having some legal disposition, that's it. So out of these three, which one is a wider term? Document. And which one is narrow term? Deed. So more scope document, lesser scope deed. That's it. Interpretation, see, what is the importance of interpretation? It is a process of understanding the law. It is a process of understanding the law. Right now we are having Companies Act 2013 in our syllabus. I think this is the latest act, because LLP Act 2008, FEMA Act 1999 late, General Clause Act 1897 also very late. So recent act that is there in our syllabus is Companies Act 2013. Tell me when this act was drafted. It was drafted in the year 2013. But when we are reading this act, 2026. So there is a time gap. And interpretation and construction main objective is to bring a bridge between the lawmaker and law reader. See, these two are not happening at one point of time. These two are happening at different points of time. Lawmaker made a law in the year 2013, whereas we are reading it in the year 2026. To bring a bridge between these two time points, we employ some resources, namely interpretation and construction. Interpretation means understanding the true sense of the law. That's it. Understanding the law. It's a meaning of the legislature, real meaning of the act, intention of the legislature, and remove any ambiguity. Importance of interpretation. Interpretation is important especially for laws, because legislation is a key source of the law. They can ask interpretation and its significance 5 marks. Sorry, 4 marks they can ask. Next one, making laws and interpreting them are separate process handled by different authorities. Correct. Different authorities. Legislative is lawmaking body, interpretation body is judiciary. Are they happening at one point of time or different points of time? Different points of time. Interpretation helps connect the meaning of the laws with their application. And classification of interpretation, Zolovich, Fizzled. So these two are others. According to Zolovich classification, interpretation is of two types: legal, doctrinal. And Fizzard classification, literal interpretation, functional interpretation. Nothing to do with the pronunciation. Ignore ma. Okay na. So according to Zolovich version of interpretation, like in economics we had Alfred Marshall sir, like in physics we had Newton sir, right? And for interpretation these two fellows are there. These two fellows version of interpretation, let's see. First one, interpretation that follows a binding rule of law requires judge to interpret statute in a specific way. Authentic interpretation, the rule of interpretation comes from the legislator himself. The rule of interpretation comes from the legislator himself. Suppose you take CSR only. Net worth 500 crores, turnover 1000 crores, net profit 5 crores. Exactly matching. Also CSR applicable or not applicable? Applicable. If CSR is applicable, CSR committee is required. But if CSR commitment is less than 50 lakhs, less than or equal to 50 lakhs, CSR committee is not required. That provision, whatever you read, apply accordingly. Authentic interpretation. Law will tell you what to do, what not to do. That's it. Law will tell you. Nothing to be added, nothing to be deleted. Suppose another example, private company. For private company, minimum 2 members are required. For public company, minimum 7 members are required. Authentic interpretation. Usual interpretation. The interpretation comes from the sources like custom or case law. For example, doctrine of ultra vires, doctrine of constructive notice, doctrine of indoor management. Anything beyond the powers of the company, it is ultra vires. The word ultra vires is not defined in Companies Act 2013. Then how to interpret it, sir? Go with related case laws. What is the related case law? Ashbury Railway Carriage Company versus Ritchie. So that is usual interpretation. Usual means sources like customs, case laws. Authentic means words used in the law. Usual means surrounding circumstances, nothing but traditions and case laws. Clear? Over. Doctrinal interpretation. Legal means from the law. Doctrinal means will go beyond the words used in the law. Interpretation aimed at discovering the real and true meaning of the statute. Grammatical interpretation. The court applies ordinary rules of the language to determine the meaning of the words. Grammatical, shall mandatory, may optional. Clear? Next one, logical interpretation. Court go beyond the words to determine the real intention of the law. Here it is like reverse. May you have to understand as shall. Shall you have to understand as may. Like a company may be formed for lawful purpose. There may you have to understand it as, you have to interpret it as shall. That means, are we going with words used in the law? Logical law. We are going with logical. That means if grammatical interpretation is not giving you desired result, go with logical interpretation. Suppose we have seen proxy has no right to speak. In section 103, I think 103 quorum, 104 chairman, 105 proxy. In 105 we see proxy has no right to speak. Suppose proxy after 1 hour of meeting he's asking water bottle. Immediately chairman scolded, hey proxy, you have no right to speak. Is it correct interpretation? No right to speak means what? No participation into the decision matters. No participation. When decisions are going on, you had no participation right. So if you apply grammatical interpretation, if it is not giving you the desired result, then go with logical interpretation. Getting my point? Another example, if you want, what is separate legal entity? Company is separated from its members. It is a separate person. But if you use this corporate will for fraudulent purposes, like we have seen, to avoid taxes, to avoid welfare legislation in CA foundation law we are having. In that case, what court will do? It will go beyond the words used in the law. It will lift the corporate will. Lifting of corporate will. That is usual. That is logical. Can I proceed? Next, literal interpretation, Functional interpretation. Literal interpretation, nothing but, it's like legal only. Just now we have seen, right? Legal. Verbal expression of the law. Private company, 2 members. Public company, 7 members. That's it. Primarily through the words and language used in the law. No external factors are considered beyond the text of the statute. Functional interpretation. Interpretation that go beyond the literal meaning seeks the true intention of the legislature. Suppose you want to write here, you can write here, separate legal entity, lifting of corporate will. Lifting of corporate will. Examples. Interpretation that goes beyond the literal meaning and seeks true intention of the legislature. The court departs from the literal text and looks for a broader meaning, balancing the letter of the law with the spirit of the law. So always separate legal entity will be there. But if you are using company for fraudulent purposes, here the intention of corporate will is to protect members from genuine cases, genuine liabilities. But if members are carrying fraudulent activities, still giving this benefit, useless. So courts usually prefer literal meaning, but in exceptional cases, they may use functional interpretation to achieve justice. Letter of the law is often exclusive and conclusive evidence of its spirit. See, the main highlight, the main point is, lawmaker is a natural person, first. It is not something created by the God. Law is not something prepared by the God. Law is prepared by the natural person. He is also a human. Definitely there is a chance of errors. And he may not draft completely. He based on his past experiences, predicting future some 4 to 5 years, he will draft the law. At that point of time, that might be correct. But going forward, it might not be correct. So here we need to identify the intention. What is the real intention of the lawmaker? So that is what functional interpretation or logical interpretation. Can I proceed? Construction interpretation. What is the difference, sir? Construction interpretation. My interpretation, plain reading of a provision, only one meaning you are getting. That is interpretation. Sir, plain reading of provision, we are getting 2 meanings, sir. One is desired meaning, other one is undesired meaning. Now, which one we should adopt? Desired or undesired? Desired. So we are coming to some conclusions. Desired meaning we need to adopt. That means ignore undesired meaning. This kind of thinking you will do under construction. Interchangeably we use interpretation, construction. Sometimes we call it as construction, we call it as interpretation. But there is a thin line of difference. The thin line of difference is literal interpretation is correct. Logical interpretation, going beyond the interpretation or reasonable interpretation, we call it as construction. So simply, if you are sticking with the words used in the law, it is interpretation. Construction involves drawing conclusions beyond the literal meaning of the text. Court must enforce intended meaning of the law, especially for legal terms with clear definitions. If the words of a law are clear, court interpret them directly. If unclear, courts analyze whether the wording applies to the situation, which is construction. Construction aligns with the law spirits even if it is not an exact wording. In practice, construction includes interpretation and 2 terms are often used interchangeably. For example, let me show you Section 3 of Companies Act. Section 3 of Companies Act 2013. Formation of company. What word he started? A company may be formed for any lawful purpose. Word only there. Only, if it is only is there, then lawful purpose only, restricted. So plain reading of provision, only one meaning is there. Like that we can get. But here only is not there. And shall is not there. Company may be formed for any lawful purpose. People may interpret it as company may also be formed for unlawful purpose. Getting my point? Now here, judge gave 2 things. Judgment can be of 2 things. Like for carrying lawful business activities, you can have proprietorship, you can have partnership, you can have LLP. So their word may is not for lawful purpose. The word is for company. LLP may be formed for lawful purpose. Company may be formed for lawful purpose. Getting it? Or may should be understand as shall. Company shall be formed for lawful purpose. Like this, drawing conclusions is the process of construction. Everyone? But the second line, if you see, 7 or more persons are required for public company, 2 or more persons are required for private company, literal interpretation. No addition, no subtractions. Next, importance of need of interpretation, construction. Just now I completed, significance of interpretation. Same points you will see here also. Here the main important point is understanding the lawmaker's intention ma. Our interpretation should match with the intention of the lawmaker. That is the importance of the interpretation or construction. Avoid ambiguity. Absolute precision is impossible, but absolute precision is impossible because the lawmaker can explain the law in a better way. Law reader may get 2 or more results reading the law. Getting it? Sometimes we convey a message to our friends with one intention, but our friends will receive it in different. Between friends only interpretation issues coming means between lawmaker and law reader definitely will come. Yes or no? And law is not everything completely written. Law is always 30% incomplete. So because if law is completely written, why this many years court is taking to come to close the cases? Always a new situation will come. 30 pages, 30% of the law is blank, and judges will write that 30%. By the time they finish 30%, again another 30% will come. Why? Because environment is not static in nature, it is dynamic in nature. Earlier, robbery means someone damaging your property, someone looting your money. Now robbery means cyber crimes also robbery only. Hacking your FB account, Insta account is also illegal. That's what. In future what happens we don't know. In Dubai the security system is like that. For example, if you fire your friend using a gun, if you kill your friend, within 1 to 2 hours Dubai police will catch you. That much advanced security facilities are there. Okay, next one interpretation may be either grammatical or logical. Jolovich already told you, grammatical or logical. Grammatical means focus will be on words. Logical means focus will be on intention of the lawmaker, what the law means. What the law says is grammatical, what the law means logical. Application of interpretation, grammatical, cannot alter or add words. Same points you will also see under rules of literal interpretation also, same points. So I start with primary rules of interpretation. See, we are having two set of rules, primary rules, secondary rules. Primary rules, first you need to apply primary rules. If primary rules are not giving results, then go to secondary rules. Okay, no, straight away going to secondary rules not allowed. First primary rules, next secondary rules. In primary rules also, first you need to apply literal interpretation. This is the cardinal rule of interpretation. If they ask you write down the cardinal rule of interpretation, you have to write rule of literal interpretation. Next beneficial, next exceptional, mischief, eugem generis, beneficial construction. Total 6 rules are there. Let's see one by one, 6 or 7. Let's see. Primary rule of construction is that legislator intent must be derived from the words used in the statute. A statute should be interpreted literally and grammatically, giving words their ordinary and natural meaning. If language is clear and unambiguous, courts cannot adopt a different interpretation based on the assumed legislative intent. You take 1% company for example, and you take these points investment in body corporate, NBFC activities, Section 8 activities. Tell me, these 3 activities are legal or illegal? Legal only. So OPC, in OPC MOA, these 3 activities are mentioned. Member is telling that, sir, these 3 activities are legal. Government is telling, no, these 3 activities are illegal for OPC. Matter went to the court. Now court should read Section 3 and implement as it is. OPC is prohibited from investment in body corporates, NBFC activities, Section 8 activities. Getting my point? Now court cannot tell like this, array these 3 are legal, no, why can't be carried out, I'll do addition. No. If language is clear and unambiguous, court cannot adopt a different interpretation. Court must interpret words in the ordinary grammatical sense unless ambiguity exists. This is supported by Latin maxim, absoluta sententia expositio non indigent. That means clear words require no explanation. Clear words require no explanation. If 2 interpretations exist, one narrow and one broad, broader one should be preferred if narrow one fails to achieve the law's purpose. For example, if you see section 102, broader one, section 102, explanatory statement I am writing here, explanatory statement. There if you see, in any proposal, if company, directors, promoters, KMP and their relatives are having interest, that interest shall be disclosed. Nature of the interest and extent of the interest, nature of the interest, amount of the interest, both to be disclosed. Now if you see, following only promoters, directors, KMP, it will give restricted meaning, or only 3 people. But their relatives means broader sense. Now you have to consider all the relatives of these people. If any one of them are having interest, then they need to disclose. Courts cannot add missing provisions to a statute, as doing so would amount to legislating rather than interpreting. What is the role of court, ma? Law making a, law interpreting a, law interpreting. So court should not add anything, because the role of court is not legislation. The role of court is interpretation. Natural and grammatical meaning. Words should be understood in the ordinary sense unless so leads to absurdity, inconsistency, repugnancy. In such case, meaning may be adjusted slightly, but only as necessary. And technical words should be understood in technical sense only. Technical words. Generally, proxy means representative. But coming to Companies Act, proxy means member representative. Proxy means member representative. So technical word. Getting my point? Small company will have two meanings, but coming to Companies Act, small company means turnover limit to paid up share capital limit you have to take. Technical words, technical sense only. Financial year, another technical word. Financial statements, books of accounts, all these are technical words. They should be understood in, they should be interpreted in the technical sense only. Next one, rule of reasonable construction. Other name is logical interpretation. Logical interpretation. Two examples, section 3 you can take, proxy also you can take. Section 3, company may be formed for lawful purpose. There, rule of reasonable construction, according to rule of reasonable construction, company shall be formed for lawful purpose. Company shall be formed for lawful purpose. Also exceptional construction, also reasonable construction only, ma. See, the words of a statute must be interpreted in a way that gives a meaningful effect. Utras magis valet quam perit. Generally, words must be given their ordinary meaning. Only when a statute allows two possible interpretation should the one that supports the law purpose should be chosen. Now, company may also be formed for unlawful purpose. Is it supporting the law? No. Is law supporting unlawful purposes? No. If a literal interpretation leads to absurd result, positive as well as negative result, courts can adjust the interpretation to maintain the consistency in the law. The goal is to interpret statutes logically to ensure that they serve intended purpose rather than making ineffective. Rather than nullifying the provision, what best interpretation is possible? That is the solution of reasonable construction. The principle follows the Latin maxim, interpretatio fenda est utras magis valet quam perit, meaning statute should be understood grammatically but not in a way that makes them meaningless. When strict grammatical interpretation causes absurdity, courts may modify it just enough to avoid absurdity, just ambiguity. To avoid ambiguity, court can go ahead. How it can go ahead? According to its will and wish, or as per the intention of the lawmaker, as per the intention of the lawmaker. Next, harmonious construction. Harmonious construction we will bring when there is a conflict between two provisions, P1, P2. When there is a conflict between two provisions, we will bring harmonious construction. For example, section 53, issue of shares at discount, valid or void? Valid or void? Void. Whereas sweat equity shares, valid. Now there is a conflict between 53, 54. Agreement with minor is void. Agreement with minor is void, but benefits for the agreement for the benefits of minor is valid. Again conflict. Again section 55, section 67. Next, section 67, 68 you take. 55, redemption of preference shares. 67, no company can purchase its own shares. 67, no company can purchase its own share, whereas 68, buyback. Buyback allowed, purchase of shares not allowed. Redemption of preference shares mandatory, but purchase of shares not allowed. Again conflict between the provisions. So whenever there is a conflict between two provisions, we should not select a provision randomly. We should select a provision based on the situation. See, like we'll take a coin. If head comes, one provision will follow. If tail comes, another provision we will follow. It's not like that. It's not a random thing. Based on the context, one provision will be valid, one provision will be ineffective. How to identify them? For that, we are having words, subject to, notwithstanding, without prejudice. Subject to means what? Suppose if provision 1 is telling subject to provision 2, that means what? Provision 1 is accepting, provision 2 is dominant. 1 is accepting, 2 is dominant. Whereas if one is telling that notwithstanding, that means one itself is declaring superior. If provision 1 is having notwithstanding anything contained in any other laws, that means 1 is dominant whereas 2 is inferior. Without prejudice means both are equal. I will come, he will also come. I mean, my law will come, that law will also come. No effect. Since I'm applying, the other provision will not apply. No. Both are applicable. Getting my point? Harmony, nothing but getting a peace. Harmony is nothing but peace. Bringing peace between two provisions, how it is possible? We use certain provisions like certain phrases like subject to, notwithstanding, without prejudice to. Sir, if these words are not there, then how to bring peace, sir? Very simple. Which one is later act, which one is older act? Because later act will always override older act. Or which one is general act, which one is special act? Because special act always overrides general act. Getting my point? 80 to 90% of the cases will be solved using these three words only: subject to, notwithstanding, without prejudice to. Or else later act prevails over older act, or special act overrides general act. Harmonious construction also over. So sir, which construction is applicable where, sir? See, reading of provision giving only one meaning, literal interpretation. No sir, giving two meanings, sir. One is positive, one is negative. Adopt positive, reasonable construction. Sir, giving only one meaning, but this is conflict with another provision, sir. Harmonious construction. Applicability, I'm telling, applicability. Next one, Heden's case or mischief rule. Heden's case or mischief rule. Best example to understand this, tax on gift, tax on gift, or tax on perquisites. I think section 28(4), I think, not sure, section 28(4) of IT Act, Income Tax Act 1961. If it is wrong, ignore. But as per this section 28(4), perquisites will also be taxable. Perquisites, salaries, do you remember salaries? Salaries chapter, income from salaries. Suppose I'm paying you salary of 2 lakhs, total 24 lakhs, you need to pay tax on 24 lakhs. In the absence of this provision, in the absence of 28(4), what happened? You are approaching me and telling that, sir, if you pay me 24 lakhs, I need to pay tax on 24 lakhs, sir. Better you pay me 10 lakhs only. Oh my God, balance 14 lakhs. You provide me house accommodation. You give me car. You give me that driver. You give me maid. All these facilities you provide. Since you are incurring this expenditure, you will get deduction in PGPP. And since I'm not getting salary in cash, no need to pay tax. So this is nothing but loophole. Using this loophole, salaried employees started paying less taxes. Government understood this loophole and brought this section. Not only your cash salary, but also your perquisites will be taxed. Getting my point? Suppose, sir, okay, salary is getting taxed. No, sir, don't give me salary. Give me salary of 5 lakhs, balance 19 lakhs, give me gift, sir. Gift is also taxable under income from other sources. And Companies Act you take, securities premium is generally not taxable. Companies Act you take, Companies Act and Income Tax Act you take. Securities premium, it's up to you. You can fix any limit. It is a reserve, not taxable. That's why what companies are doing, suppose, the company, I want money from you to do one activity. That is a in-depth provision, actually. What happens is, for example, I'm a government officer, you want one contract. I'm ready to give this contract, but definitely at free of cost or some amount. If you pay me white amount, I need to pay tax, and my reputation will be damaged outside India. Sorry, my reputation will be damaged in India because officer is for sale. If you give me black money, IT department will conduct search warrant. Yes or no? So that's why what this officer is doing, my nominee will incorporate a company. The share face value will be 10 rupee and issue price would be just 1 crore 10 rupee. 1 crore 10 rupee. You come and purchase that share. This company belongs to my nominee. That means that money also mine only. Now company is receiving how much amount? 1 crore 10 rupees. I'm giving a contract to that X. Later, once work is over, company is announcing buyback. And buyback price, how much? Buyback price 10 rupee. How much is the buyback? 10 rupees. Now this fellow is surrendering the share and company is paying 10 rupee. So company is having how much amount to 1 crore. Company, why are you not paying tax? Securities premium is a reserve. No need to pay tax. And this fellow, what he is doing under capital gains, sale consideration, nothing but buyback price 10 rupee, purchase consideration 1 crore 10 rupee, he is claiming 1 crore short term capital loss and he is adjusting with other incomes. Government is losing revenue two sides. And in the year 2014, what government did? I will compare issue price with fair value, not face value, fair value. If issue price is greater than fair value, excess will be taxed under securities premium. Now you tell me what is happening in all the three cases I told you. First, there is a loophole. Perquisites, gift, securities premium, there is a loophole. To cover the loophole, lawmaker is bringing the law. Now how we should interpret the law? What was the law before this act? And what mischief or what wrong, what defect is there in the previous law? And how the new act resolve the cure the mischief, and what are the two reasons for the remedy? For example, another example, if you want from Companies Act, CSR only you take. Under old act, CSR related rules are not there. Under new act, CSR rules were there. Why? To cover the mischief. So just imagine, if CSR rules are not there, just imagine a foreign company coming to India, or you need to spend 2% of the net profit. They're spending that amount in that country, not in India. Now having this provision, any user, useless or useless. So through rules we are telling preference should be given to the local area. So simply, what was the mischief? What was the law before the act? What was the mischief? How it was resolved? And what are the true reasons for the remedy? If you are able to answer these 4 questions, that's it. You will get correct interpretation. You will get correct interpretation. So to cover a mischief, any law is coming, you need to apply mischief rule or Heden's case. Can I proceed? Beneficial construction. Small, only 3 points are there. Beneficial construction. What is the meaning of this beneficial construction? See, when you interpret a law, suppose about employees, you are reading a law. A provision is having 2 meanings. One is a normal meaning, normal. Other one is beneficial to the employee. Beneficial to the employee. So from employee's point of view, which provision which meaning I need to adopt, sir? Beneficial provision, beneficial meaning you need to apply. Beneficial meaning. See, beneficial construction applies to the statutes aimed to improve the conditions for underprivileged or previously unfairly treated groups. In such cases, court may extend the meaning of the words clauses, but only when 2 reasonable interpretations exist and not when the statute language is clear and unambiguous. Why? If language is clear and unambiguous, we will apply literal interpretation. We will apply literal interpretation. That means here 2 meanings should be there. One is beneficial to a particular group. I will apply beneficial construction. Suppose positive meaning is there, sir, negative meaning is there, sir, then I will apply logical interpretation, reasonable construction. Getting my point? First you need to understand applicability, then you will observe the rules. Next, rule of exceptional construction. Here sometimes end to be treated as or to be treated as end, may to be understood as shall should be understood as may. That is what exceptional. Generally shall means mandatory, but under exceptional scenarios shall becomes may. May is optional, but under exceptional scenarios, may becomes compulsory. End is conjunctive, or is disjunctive. End can be read as or when necessary to fulfill the legislator clear intent. Say for example, financial statements whose responsibility? MD, whole time director in charge of finance, CFO. Suppose CFO is not there in India, he was not negligent, and imagine word end is there between these 2 people. Now simply having end, so is CFO will CFO get punishment since end is there? No. Here end will be interpreted as or. If that fellow is there and if that fellow is also party to the fraud, end to be treated as end only. End to be treated as end only. Suppose or is there, MD or whole time director or CFO is there. Suppose 3 people committed the mistake. Now looking at the provision, MD telling that either MD or WTD or CFO will get punishment, not 3 people, only one should get punishment, not 3. Like that interpretation if you want to take, no, or should be treated as end. That means depending on the situation, end becomes or becomes end. Similarly, may becomes shall becomes may. That's it. Next, wisdom generous. ujusdom generis. Here you need to you need to remember these 5 points ma. Long back these 5 points were tested, or these 5 points or 4 points you have to remember. Long back tested, so chance is there. Ujusdom generis, when it is applicable, when there is a combination of special words and general words. General words. General words derive meaning from special words. General words derive meaning from special words. In Ashbury Railway Carriage Company, I told the same point ma. I told the same point. Ashbury Railway Carriage Company, doctrine of constructive notice, I told the same point. See ma, cat, cow, dog, etc. Cat, cow, dog, etc. What that etc indicates? Elephant, wild elephant, tiger, lion, or only pet animals, domestic animals, or domestic animals. Suppose our academy teaches CA, CMA, CS and etc courses. Etc indicates what? Etc indicates BPC, MPC, MBBS, IIT, IIIT, no, commerce related courses. Understood? So that means, yeah, MBA, like that. That means when special words are there, when these special words form one category, if they represent one category, general words always derive color from that special words. Suppose it is not a category ma, different, for example, cat, chair, light. Suppose cat, chair, light. Is there any category between these three elements? Cat, chair, light means. So that group is not forming as a, that three words are not forming as a category, then ujusdom generis is not applicable. So let me read here ma. Statute lists specific words and these words belong to a common category. Suppose if they are not belonging to common category, you can see here, if they are not belonging to common category, if they are diverse in nature, listen carefully here. If they are diverse in nature, that means do not form a common category, then ujusdom generis is not applicable. First thing, there should be specific words, common category, and that category is not fully covered. Suppose that category is fully covered ma, our academy teaches only CA, CMA and CS course. When category is complete, apply literal interpretation. Ujusdom generis is not applicable. Next one, general words follow specific ones and there is no indication that legislature intended otherwise. There should be no prohibition in the law ma. Suppose in the law beginning itself, if they tell rule of ujusdom generis is not applicable to us, then ujusdom generis is not applicable. So in examination they may ask conditions for application of ujusdom generis. Conditions for application of ujusdom generis, write 5 points. Specific words, common category, not fully covered. General words follow specific ones and no indication in the law regarding applicability of ujusdom generis. And exceptions means what? This rule does not apply when specific words and general words are broad. They do not cover, they cover entire category. That means at the end only or end is there. For example, CA, CMA and CS. Over. Category is over. Or the specific words are diverse like cat, light, chair. The legislature explicitly states that general terms should not be interpreted under this rule. Suppose if law is clearly telling that ujusdom generis is not applicable, then this rule is not applicable. Okay na? So with this primary rules over ma. With this primary rules over. Next secondary rules. Nos iter associes contemporanea expositio. Nos iter associes means word meaning will be derived from the associated word. Example, plant, you tell me plant. What plant refers to? Is it a tree planta or machina? So for that you need to see associated word. Suppose plant and machinery, their plant means equipment. Just plant, branches, trees, leaves like that, their plant refers to tree plant. So what is the associated word? That associated word will derive the meaning of this word. Associated word will give you the meaning of this word. Nos iter associes means that when two or more words with similar meanings are used together, they should be understood in relation to each other. General word takes its meaning from specific words it is associated with. Suppose chips ma, chips. What chips refers to? Potato chips or integrated circuit chips. So when I'm talking about electronic gadgets, chip means electronic chip. When I talk about eatables, chip means potato chip, like that. Purchase Tax Act phrase manufactured beverages including fruit juices Here fruit juices means fresh fruit juice or pulpy orange. For example, pulpy orange is there, mango pulpy orange, or orange, minute pulpy orange is there. Whether minute pulpy orange is a fresh fruit juice or a manufactured beverage. That is the question. It was held that freshly pressed, unsweetened orange juice did not fall under fruit juice category because they will not be preserved for longer duration. Beverages can be preserved for 4 to 6 months, whereas fresh juices max to max 2 hours, max to max. Doctor private dispensary is not a commercial establishment, ma. See, ma, if you see the definition of business, the word profession was interpreted in the context of business trade, business trade profession, like this there, ma. If you derive associated meaning, business means profit is the objective, trade also profit is the objective, simply profession also profit is the objective. But private dispensary is not for profit motive. Doctor's private dispensary is not for profit motive operation, it's a service to the public. Therefore private dispensary, will it come under commercial establishment? No, it's not commercial establishment. So thus words must be interpreted based on their association. Generally doctor means profession, profit, income is the profit. But doctor's private dispensary, here it is not a commercial establishment. You need to check the text context. Commercial establishment as one engaged in business, trade, profession. But private doctor's dispensary is not a commercial establishment. Next one, contemporaneous exposition. What it refers to? Indian Contract Act is there in 1872, right? Indian Contract Act was enacted in year 1872. If you remember, communication of offer. If you remember, communication of offer, communication of acceptance. When offer is yet to be communicated, ma, when it reaches offeree. From offerer point of view, offeree point of view also same. When offeree receives that offer, communication of offer is said to be accepted. Communication of acceptance, if you remember, offerer point of view, when that fellow posted the letter, offerer is bound by the acceptance. But offeree point of view, when the letter reaches offerer, correct? 1872 WhatsApp, Instagram, Gmail, Telegram not there. But right now post is like negligible. So now how to interpret that provision? Simply bring the text to current context. Now here communication of offer is said to be communicated when, for example WhatsApp you take, when 2 ticks come, message is said to be delivered. When blue tick comes, communication is done. Getting my point? Opponent party, if you tell yes, that's it. At a time, from both the parties' point of view, communication of acceptance is done. Or else another example, if you want, Companies Act 1956 you take. At the time all the filings are manual filings. Now all the filings are electronic filings. So wherever you see the word filing with ROC, what the filing refers to? Electronic filing or manual filing? Electronic filings. So simply here we should follow the customs. We should follow the customs. Custom is the best interpreter of the law. So maxim applies only to the ancient statutes, only ancient, some 100, 150 years back. Modern acts where more contemporary methods of interpretation are used. One part over, ma. Second part, internal aids to the construction. Headings only I will read, but you have to read the text completely. See, aids two types, internal, external. How? If you are taking help from internal sources, internal aids. From external sources, external aids. Internal sources, namely title, long title, preamble, both are same. Both are same. Long title, detailed description of the enactment explaining its purpose, and preamble also you will see scope, purpose, objective of the act. But in preamble, remember this one point, ma. If there is ambiguity, if the wording is unclear, preamble helps you. But if there is a conflict between preamble and enactment, preamble cannot override the provisions of the act. That point you have to remember. Can be asked for 2 marks. Preamble 2 marks. Just read 4 to 5 points. Headings and titles of the chapters. Headings, ma. Section 3 to section 22. If you see, what is the chapter title? Incorporation of company. Section 23 to section 42, if you see, prospectus and allotment of securities. 77 to 87, registration of charges. Suppose in any provision they mention like this, any provision of this chapter failed to comply, not complied, then this is the punishment. Then we will understand that provision by reading the chapter name. Getting my point? Next one, of course these will not override act. These will not override act. Not override. If there is any conflict, for example, section 180 subsection 1 clause C, if you take borrowing powers of the directors, same point is there in section 42 private placement, same point is there in section 71 debentures. Now chapter heading share capital and debentures cannot restrict the scope of borrowing powers of the company. Section 180, marginal notes, left side or right side, in the margin, if you see section heading or any title, we call it as marginal notes. As per ICI, they are part of the act, but they do not part of the enactment. Yes, summary you will see in the act itself, but interpretation point of view you can't use them. They are not part of the enactment and cannot be used for interpretation unless necessary. That means actually part of the enactment only, but general rule not part of the enactment. Definitional sections, section 2 here definitions 3 types restrictive, extensive. Restrictive means means definition having phrase mean, restrictive. Definition having a include, extensive. Means, includes, means and includes, applies to and includes, same meanings that are there in General Clauses Act. Ambiguous definitions, suppose you take person only or you take financial year only. Person is having one definition in Companies Act, FEMA Act. Financial year is having different definition in Companies Act, General Clauses Act, LLP Act. Or else take body corporate. Body corporate includes company incorporated outside India, excludes cooperative society, that is Companies Act. Whereas body corporate in LLP Act, you take some 3 are included, 3 are excluded, body corporate is equal to company. So these kind of definitions should not be read in an isolated way. They should be read along with the context used in the act. Or else generally you tell me free reserves includes securities premium, excludes securities premium, excludes. But for the purpose of buyback, the explanation clearly told that free reserves include securities premium. Now if you are reading section 68, free reserves includes security premium. Other sections, free reserves excludes security premium. Ambiguous. Definition subject to contrary context, multiple meanings, specific use depends upon the context, the act scheme, provisions language and the intended objective. Next one, illustrations. Indian Contract Act best example. If consent is not obtained freely, contract becomes voidable at the option of aggrieved party. For that, illustrations will be there, like consent obtained by way of coercion, undue influence, misrepresentation, contract becomes voidable. All those you will find in illustrations. Or suppose some underwriting commission you take 5% to 2.5%. Any problem solved there itself, nothing but illustration. For better understanding of the provision, you can refer to the illustration, better understanding. But illustration do not modify the language of the section. It will not restrict, curtail means restrict, or it will not expand the section scope. Proviso generally refers to exception. Proviso generally refers to exception. In capital gains, if you see proviso, many times you will find. Proviso, the wording may be like this, provided that, or the wording may be exception, but the meaning is proviso. The effect of proviso is it restricts the applicability of general rule. It restricts the applicability of general rule, or it may specify the conditions where general rule is applicable. Okay, na? That means whenever you see the word proviso, okay, general rule is not applicable in the below cases. That is the interpretation. Qualifies or creates an exception. Does not state general rule but restricts the broad language. Exceptional clauses, saving clauses. Next one, explanation. 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 So to remove the vagueness, absurdity, explanations will be given. in the act itself, explanation they will keep heading, and they will give the clarification. Explanation is nothing but clarification. Clarify the meaning of the certain words. It's almost similar to definition, but definition is universal. For that entire act, definition is same, but explanation will be limited to that section only. Explanation to that section only. If you have time, download Bear Act, Companies Act, Bear Act, and search for explanation. You'll get 2 to 3 lines. So in the Companies Act PDF, you will see 130 plus explanations are there. For the purpose of this clause, it is hereby clarified that person holding, like that, holding company, you can see here explanation. Generally, company means company, but in explanation, company includes body corporate, and that is limited to only that section or that clause, not for the entire act. So definition, in definition, if you tell company includes body corporate, then all the sections of the Companies Act, company includes body corporate, wrong interpretation will come. So that is the difference between definition and explanation. Schedules. LLP Act, you take first schedule, rights and duties of the partners and LLP. If partnership deed is silent on any matter, then matter will be referred to the schedules. So common formats will be in schedules. Of course, if there is conflict between act and schedule, act only prevails. For example, for big companies, schedule 3 applicable or not applicable? Not applicable. Banking, insurance, generation of and distribution of electricity, supply of electricity, big, schedule 3 is not applicable. Act clearly told schedule 3 not applicable to big. Now if schedule 3 is silent on this matter, can I apply schedule 3 to them? Answer is no. Read the statute as a whole. If you read section 55 one time, if you read section 67 one time, what it tells: 55, redemption of preference shares compulsory. 67, company is not allowed to purchase its own shares. Oh my god, there is a conflict. So for removing the conflict, for better understanding, you need to read statute as a whole. So in 67 clearly told nothing will affect section 55. This is nothing but harmonious construction only. Next one, external aids, historical setting. Right now Income Tax Act 2026 came, right? So to understand any of these provisions, you can go through the finance minister speeches in the parliament, from the speeches also, and from the committee meetings, and the answers or the replies given by the committee people. We can understand the law in a better way. But this is something not in the law, outside the law. That's why these are external aids. Next one, consolidating statutes and previous law. Suppose if you see Companies Act 2013, it's a consolidation, it's an amendment and consolidation of all previous company law. For better interpretation, if at all needed, you can go through the previous laws also, earlier laws, later acts and analogous acts. Next one, usage. Usage is nothing but custom. Custom is the best interpreter. For example, take sale concept. Sale refers to cash sale as well as credit sale. Correct? But if you take gold shop, credit sale concept there, like buy today, pay tomorrow. Today complete sales, so tomorrow complete bad debts. So depends on the situation. Sometimes sales will be only cash sales. Next, earlier act explained by the later act. Reference to the repealed act. So here you can see general clauses act related points also. Next one, dictionary definitions. First, if there is no definition in the Central Act, go to General Clauses Act definition. If General Clauses Act is also not defining, then go through dictionary definitions. Use of foreign decisions. Doctrine of constructive notice, doctrine of ultra vires, doctrine of indoor management, everything happened outside India only. If similar case study happened in India, you can refer that case to Indian case study. In Indian case study, in India there is no such case, but same was solved in foreign courts, sir. You can give reference to the foreign courts also. Next one, interpretation of deeds and documents. Whatever we read so far, apply to the document also. First give literal interpretation. In this, understand as a reasonable person. Read as a whole. Golden rule of construction. What is the golden rule of construction? Literal interpretation. Intention of the party should be determined based on the ordinary natural meaning of the words. Status and training of the party should be considered, as words may hold different meanings for different individuals. Next one, comparison with other documents, consistency in the meaning, resolve conflicts in the clauses. Resolve conflict in the clauses. One example, not hurry burry, because reading this each and every point will give you the same meaning. That's why I'm just giving overview brief. Suppose in board of director powers, board of directors can borrow up to 50 lakhs. This point is there. With member special resolution, board of directors can borrow up to 80 lakhs. One clause is telling board of directors can borrow up to 50 lakhs. Another clause is telling board of directors can borrow up to 80 lakhs. Which one I should follow? Or up to 50 lakhs, first rule. Anything above 50 lakhs but up to 80 lakhs, follow second clause. Suppose Mr. A is a managing partner. Check signing power is with B. Check signing power is with B. And sale or purchase of immovable properties, the power is with C. Now, if you don't read these two, what we think, A is having all the powers to represent the firm. And if you read second point, you'll get a clarity. If you read third point, you'll get another clarity. So read document as a whole to remove the conflicts. If there is any conflict, as usual, notwithstanding, without, subject to prejudice. If these words are not there, later act always prevails over earlier acts. I mean later part will always overrides earlier parts. Clear? That's it. With this, we finished marathon.